To speak in the public comment section at this point. They may do so by coming forward, stating their name, and telling us what they'd like to speak about. Seeing none, I will close the public comments to our agenda and open it up to commissioner comments. Steve.
On this Friday at 9 a.m., the town of Snowmass Village is holding their annual town cleanup. And the meeting place is at the town park parking lot, and it's a fun thing. They take lots of the village shuttle buses, take people up to the tops of different roads, and they pretty much clean all the public parts of the village all in one day, and then have a big barbecue party afterwards. So I hope to see some people there. Thank you.
Other commissioner comments? George.
Yeah, I just want to wish congratulations to the class of 2014. Congratulations to all you students and parents and your families and friends. And I hope great success for you graduates on your next phase of life. And remember that education is a lifelong pursuit.
All set. Other commissioner comments? Seeing none, I will move to our consent actions. We've got the approval of the minutes May 6 minutes of May 6 work session and May 6 special meeting and May 14th regular meeting. I will take a motion to approve if there's.
So moved.
Second.
We have a first and a second. Any discussion? Seeing none, all those in favor say aye.
Aye.
Next, we have a first reading set for public hearing on June 11th. It's an ordinance authorizing the sale of the Stapleton Brothers Ditch Historic Consumption Use Credit to Maroon Creek LLC. And John Ely is going to present this to us.
And a representative for Maroon Creek Club LLC is present, Nicole, and I don't want to butcher your last name because I lost it. The county owns water rights associated with the Stapleton Brothers Ditch that it acquired through the gradual accumulation of land surrounding and now currently occupied by the Pickens County Airport. As a result of the airport's continual growth and development, a portion of the airport property no longer needs to be irrigated, which would obviously be quite obvious with the construction of all the buildings and the runway and taxiways, etc. The county in 1999 went to water court to establish the historic consumptive use associated with the water right that we held as part of the airport's assets through the enterprise, the airport enterprise. It was quantified out, and the next dilemma for the county was what to do with it. We have established approximately 220 acre-feet per year of water rights that were originally decreed for irrigation purposes that were related to approximately 130 acres at the airport, particularly at the, I believe, the north end of the runway and the expansion of the taxiways. The first transaction that the county did was a sale to actually the Starwood Homeowners Association to facilitate augmentation for depletions associated with wells that they were developing. The lion's share of the water right has been dedicated to a trust agreement established between the county and the Colorado Water Conservation Board. That trust agreement is still in place and still functioning. The Maroon Creek Club approached us about a small amount of water that was still being held in reserve by the county, particularly 12 acre-feet. The diversion amount associated with that is approximately 1/2 of the CFS. The opportunity that Maroon Creek presented us with is an ability to transact these historic consumptive credits, whereby the Maroon Creek Club would be able to augment evaporative losses associated with ponds on the Maroon Creek property.
I'm going to ask if you turn the phone around because it's just flashing in my face there. Whatever that light is. Thank you.
Are we on candid camera?
In order to augment this evaporative loss, the historic consumptive use associated with the Stapleton Brothers ditch that would be transacted in Maroon Creek Club would be bypassed at the Stapleton Brothers headgate. That water would be left in stream and would go to the benefit of the Maroon Creek Club to allow for their continued use of ponds. The structure that is being presented in the attached contract provides for a sale of these water rights to Maroon Creek LLC at a price that had previously been set by the county for a total purchase price of $120,000. The money realized from the sale would naturally go back to the airport enterprise as this asset held by the airport. The transaction provides that this water will remain in the stream for augmentation purposes, and if it should ever not be put to that purpose, if it should not be left in the stream, bypassed at the headgate, if the Maroon Creek Club LLC ever prosecutes a change of use or anything else with the water right, then the county would have the ability to reacquire that water right for one half of the purchase. The one half of the purchase, I feel, is very fair, given the fact that we will not be involved with the costs associated with otherwise dedicating that same amount of water to the in-stream flow program in CWCB. The cost of the change application will be borne by the purchaser, by the Maroon Creek Club or Maroon Creek LLC?
Maroon Creek LLC.
And the county would be in a greatly enhanced positive cash flow with this type of arrangement. By virtue of the water being left in the stream, going past the historic diversion point, the stream will be enhanced by that amount of water, and it will necessarily have to be in the stream all the way down the Roaring Fork, and actually, theoretically at least beyond, in order for the Maroon Creek Club to continue to utilize their ponds and provide for evaporative loss. So the recommendation is for the board to accept this ordinance on first reading and to set the matter for a public hearing and second reading, and the date for that is June 12th. Thank you.
Questions for Johnny Lee? Michael?
John, you mentioned CFS, and then you also mentioned acre feet. How does that work in terms of CFS is a flow measurement, and acre feet is a volume measurement. Is there a limitation on the amount of water that there is from the Stapleton ditch? Is that what you're saying?
It's actually a pretty complicated question, but to try to
Would you
drill
want it
down
any other way?
to drill down on it, the water right that is being transacted is expressed in acre feet, and it is the historic consumption of that amount of water that was applied to the airport. The diversion rate that put that amount of water on the airport property and available to be consumed for irrigation purposes was originally 8 CFS, or cubic feet per second, of direct flow. And that was diverted out of Maroon Creek at approximately the location of the Island Fields, just down from Highlands a little bit. The proportion of that 8 CFS is about half a cubic foot per second that is associated with this amount of historic consumptive use of 12 acre feet. So there is a relationship between the two, and should not change in the future by virtue of the 1999 decree that the county obtained, or the 1999 application for which the county obtained a decree establishing the use based upon that diversion rate. But ordinarily the two don't necessarily have to stay static. I mean, you can maintain your consumption while changing your diversion rate and so forth. But that's the reason I wanted to express what we were actually transacting, which is 12 acre feet, but put it in terms also that would relate to an amount of water that is physically going to be in the stream and left in the stream as such.
Also, John, on the buyback portion, the $60,000 buyback, would we want to have some sort of inflator or cost of living associated with that? Because if they do it in 50 years, $60,000 is going to be like $60.
Well, if inflation continues to run in the positive, and we don't have many recessionary cycles, then the fixed price will work in the county's favor as the cost of the water, or the value of the water continues to climb, and our buyback is as described. So I think that that this is actually a good situation for the county.
Okay.
Steve?
John, without this augmentation water, would the Maroon Creek Club be in danger of having to shut some of their ponds down and not keep water in them? Or
Well,
are they required to get the augmentation water either from Rudai Reservoir or from someplace?
They would have to obtain augmentation water from someplace. I can't comment on the danger or the risk of losing ponds on the golf course, but they would have to go someplace else. The dilemma for water consumers in the upper valley, Maroon Creek would not be an exception to that, is that they are very far upstream from the augmentation supply, which is essentially the confluence of the frying pan with the Roaring Fork. So you've got a number of miles of depletion of river flow that have to be accommodated. And the county is in a position to do this transaction and satisfy this need simply because our water right is associated at a high physical location in the valley.
And is this water that would be going into the stream but in their name instead of in the county's name, is it the same water that is going to CWCB, or is it different water?
It's part of the same water right.
Okay.
Rachel?
Yeah, thank you. John, should the county not proceed with this transaction, what would we need to do to prove beneficial use of the water in order to maintain it, or how would we maintain that water right? What are the alternative courses?
Well, the only real viable alternatives are two. To either consume the water ourselves, and the only real logical place to do that is in on the airport, at some location. The ability to do that really isn't there because of the other water rights the county holds satisfy the irrigation need, so that there's not a dry area of the airport that could accommodate the use of the water. And the other potential use would be to enter into a transaction with the CWCB to dedicate the water to in-stream flow.
Okay, and when we dedicated the first portion of some of that water to the in-stream flow, what were our costs in prosecuting that action?
The costs were pretty steep, but you have to keep in mind that it was an initial transaction. So it was the first time to prosecute a change of use under the decree establishing the historic consumptive use. It was the first instance of utilization of the trust agreement between the county and the CWCB, and reflected the costs of establishing that trust agreement in the first instance, and those costs were approximately $350,000.
And we had a number of objectors we had to deal with in that case?
Yes.
And we would imagine there may be objectors if we were to do the same thing?
I can't imagine there wouldn't be.
Okay, and that's because they were then associated with the minimum stream flow and being called to support the minimum stream flow versus this augmentation proposal, which just will leave it in the stream.
Well, the opposers all had different positions and reasons for asserting opposition to the change. Primarily, it's the opposition was reflected in a challenge for the previous adjudication of the amount of historic consumptive use. Even though that was established through a decree and it was established to be a res judicata for all purposes and so forth, the the opposers wanted to re-examine that number and to challenge the amount of water that we could contribute to in-stream flow and therefore not be available for any other consumptive use. Because the reality of it is if the water is not being used for in-stream flow, then it's still available for diversion and some other consumptive use. So that was the unifying characteristic of all the opposers, but their motivations were different depending on their assets, really, and their water rights.
Thank you.
Steve?
One more question, and it might be a question for you. Is the Maroon Creek LLC being required by the state water engineer or the water court to augment your water right?
No, the ponds have never been called by the state, and Maroon Creek LLC does have contract rights in Redeye Reservoir and storage on the Colorado River, so if there were a downstream call on the Colorado River or downstream of the Prime Cannon North Fork confluence, then it would have augmentation supplies for that area. It's just the upper reach is what we're seeking to.
So the pond rights are younger than 1922, so they would be potentially called by a compact call. But the senior water rights in the Stapleton ditch predate 1922, so it's augmenting it with senior water right. Okay. Would you accept a motion, Ron?
Yes, I will.
Okay. I move to approve an ordinance of the Board of County Commissioners of Pitkin County, Colorado, authorizing the sale of Stapleton Brothers Ditch Historic Consumptive Use Credits to Maroon Creek LLC.
Second.
First and a second, any discussion? Seeing none, all those in favor say aye.
Aye.
Thank you. Next is our confirmatory reading, and which is a public hearing for an emergency ordinance amending the Pitkin County retail marijuana license regulations to prohibit issuance of retail marijuana licenses in the Crystal River Caucus area. And then after that, we've got a similar one for medical marijuana. So I'll handle the first one first, item number 3.
Both items were last handled by the BOCC on May 6th of this year, wherein the board adopted an emergency resolution pertaining to the medical marijuana licenses and an emergency ordinance relating to the retail marijuana license regulations. With regard to the retail marijuana license regulations, well, actually, I should say the motivation, the genesis of both actions were to bring the existing regulatory structure in compliance with recommendations and requests from the various caucuses within the county. So in regards to the retail marijuana licensing regulations, the county, in response to requests presented to it from the Snowmass Capital Caucus, the Frying Pan Caucus, Woody Creek, and the Emma caucuses, prohibited any type of retail marijuana licenses being issued for those caucus areas. Since the adoption of the retail marijuana license regulations, the Crystal River Caucus has come forward and essentially made the same request that retail marijuana licenses not be issued in the caucus area. So this emergency ordinance amends the retail marijuana license regulations to include the Crystal River Caucus area in that area of prohibition. The background of the regulatory scheme for retail marijuana license regulations provides that the caucus recommendations would be adopted for a period of a year after the initial implementation of retail marijuana licensing regulations, which was in February of this year. So by February of next year, the board has committed to re-examine its position on this prohibition and to determine essentially what to do next and how to evaluate that, and to inquire from the caucuses if they want to maintain the same recommendation. This is a confirmatory reading and a public hearing on the previously adopted emergency ordinance.
Questions of staff? Michael?
John, we got a letter from Herb Klein. Did you get
Yes,
that letter?
I did. And
Yeah, he's here.
Can't imagine Herb would not be here, are you? Yes.
So, I didn't quite understand the letter. Do you know what the gist of the letter was?
Well, I'd rather, to be honest, Herb should probably speak to it himself if it's okay with the board, but the gist of the letter is to allow for a carve-out and a continuation of an enterprise that has already been established within the Crystal River Caucus area. And in so doing, allow that business to continue to operate at the same location and in the same size and scope, but to allow the issuance of supplemental licenses regarding that same operation.
So as the ordinance as it stands now doesn't do that?
That's correct, it does not. It reflects only the recommendation that came in from the caucus itself.
And this wouldn't, so John, how would this affect the existing license within that Crystal River Caucus
The
area?
existing license could continue.
Yeah.
And depending on its schedule and how that relates to the board's reexamination to the regulations as a whole, there might be some effect for renewal.
Yeah.
And that's, that will be a consequence of the timing of the process of when an application for renewal must be filed and when the board determines how to change the regulations going forward or to keep them the same. But at least from this point forward, there is a prohibition.
Rachel?
Yeah, there seemed to be some intimation in the letter that the caucus recommendation was to refer to new licensing and new operations as opposed to anything that's existing. And I know we had some dialogue as we were looking at the emergency ordinance, but it wasn't in depth about whether that was the case. And I'm just wondering, did you feel there was the specificity in the caucus recommendation regarding that matter one way or the other?
The only thing that I've seen was an email communication sent from Dee Malone, who I believe is the current chair for the caucus. And that communication reflected that the caucus area wished to recommend to the BOCC that there be no retail marijuana licenses issued for the caucus area without any discrimination within the caucus boundaries. The caucus was aware of outstanding,
Existing.
valid licenses being issued, and so it was a prospective recommendation on their part, understanding that there is a licensed location from this point forward, so to speak, a desire that the county entertain or respect or adopt its recommendation.
Just to clarify, but adopt its recommendation so that any existing license would not be grandfathered and would be prohibited in the new code, or that they wanted to make sure that in the perspective looking forward there are no new licenses?
The email communication that I have did not discriminate that way.
Okay. So it's just left it kind of vague.
George?
Although this moratorium will just prohibit any new licenses issued in any of these caucus areas for a period of 1 year since we instituted those regs, which was, I think, around February 15. Anyone who has a current license, they have to come up for an annual renewal anyway. Mm-hmm. And so that will be a further discussion regardless. At that time, I believe we can then entertain comments back from the caucus, similar to a land use application. Someone is requesting to renew their license, which would give it earlier comments. So I'm not sure it would pose a problem at all, given the system we have in place in terms of informing public process.
And the timelines.
The timelines.
Okay, thank you.
For the board's reference too, I was at the caucus meeting where this vote came up, and there was specific discussion about the fact that there was a grow operation within the caucus area at the time, and I was kind of used as a reference point to what the interpretation of some of the code that we were adopting at the time, or that we just recently adopted at the time would do. And there was discussion that that person would have a renewal time period, and that during that renewal, if the moratorium still held, that they could lose their license.
That is the effect of this language.
Yes.
I'd be curious to know the renewal time period, if we could find that out at some point, of that specific license.
There are several. I don't know the dates for the renewals on those licenses.
This was one of the licenses that I believe was approved immediately after we had written the retail marijuana regulations.
I think Jeanette may have that information.
The date is, the current license expires on March 3rd.
Of 2015?
So March 3rd, 2015, which would be after our February 12, 2014 date that's stipulated in this emergency ordinance as a
Full review.
as a full review.
Right. And that, of course, would go to the renewal. And hopefully that the board would have obviously dealt with the continuation of this prohibition by continuing it or repealing it. The other factor, though, is that there is a consequence for the need and the conduct of the business for additional licenses for the same, like I said before, the same location, the same size and scope of operation, but just to inventory under the state's MITS system an amount of the marijuana product or plants to different outlets. And I think that is more of the focus of the issue with the current licensee down the Crystal River.
Additional questions for staff or comments, Michael?
So this is getting pretty complicated, but so they've asked for no new licenses to be issued. We just talked about renewal. They haven't said asked for a prohibition on renewal of any licenses. Is that right?
They did not discriminate, but the content of the email was as Rob described it, that they understood that there was a licensed establishment, but that the renewal would be the issuance of a license, a type of license. They didn't discriminate as a renewal license or an original license, just that their desire was from this point forward that no license is issued. In other words, they realized they could not take any action to revoke an existing license that was validly issued and being complied with, but from this point forward, they didn't want to see any other or future licenses issued.
Okay, so the current license is not in question, then, is that what you're saying?
Correct.
Okay. I'm sorry, go ahead.
No, I was...
I was going to state that at that meeting, the conversation was about participating in the same moratorium that the other caucus areas were participating in.
Right.
So it wasn't doing something different than what these other caucus areas were participating in. It was, we want our name on that list too.
Okay.
And they were aware that it would not affect the existing license that was already in place. Steve?
It doesn't affect the existing license, but it would affect a renewal license and in effect shut down Jordan Lewis's grow operation on the Crystal River, because the way our thing is worded, it says prohibiting a license, doesn't say a new license or renewal, it just says a license. So the way it's worded, Jordan's going to be shut down unless we make a
Well, it's
change.
prohibiting a license of being issued. That license has already been issued.
But it would affect the renewal.
It would affect the renewal.
But this, and I guess this is a question for John, when a renewal comes in, is that considered a whole new license? Or is it the same license just being renewed?
It's the same, it's a renewal of the previous license. However, so you're correct, Steve, and so is the rest of the board. The way this is written, in keeping with the recommendation of the caucus, is that it would capture a request for, or an application for renewal as well as an application for a new license, an original license.
So it's asking that that operation be shut down. Now, question for John. How would we change this? Would we have to issue a new emergency ordinance if we wanted to change this one, since this is a confirmatory reading?
It depends, I suppose, on what the change is, but I would request that the board consider what the change is and then make a determination of fact consistent with the charter that the change either is or is not significant. And in the determination of the board, if that change is not significant, we can go ahead and confirm the original ordinance with an amendment. If the board feels the change is significant, then we'll have to essentially start over.
Well, I was going to suggest that the wording that Herb Klein suggested sounded good to me, but I'm not an attorney, so, and it's basically just grandfathering in Jordan's thing so it doesn't get shut down during this one-year moratorium time.
I didn't have any issues with the suggestion that was presented by Herb Klein on behalf of his client. From a legal point of view, it's a policy determination for the board.
George?
What I'm understanding is this emergency ordinance was put into place to allow the Crystal River Valley Caucus to provide their input to the BOCC regarding retail marijuana. And it came in late because at their earlier meetings, they were unable to vote on it because they didn't have a quorum. So there was a delay there. The emergency ordinance will then take into account the same timeline as the other caucuses, which is a one-year moratorium which will expire
February of 2015.
February 2015. At that time, we'll have these discussions again. The current site, Jordan Lewis's site up in the Crystal, his renewal does not come up until March, which is after the moratorium would end.
Essentially, yes.
So I don't see how this impacts Jordan's operation negatively at all, because at that point, it's going to be a whole new discussion. He'll have to come up for a renewal anyway, which will be a public hearing, and we'll go through that process.
Michael?
Well, I have the suggested change to the ordinance here, and it speaks to apply the renewal of a license for a retail marijuana establishment that is an existent as of date of design, or to a conversion of an existing medical. So it's also about conversion of an existing license to a retail. So I think that's the crux of the question. Not particularly the renewal, but a conversion here. So maybe we can ask the public to address this issue.
And it's my understanding that that's already been converted to a retail license.
A portion of it.
Portion
But
of
there
it.
is still a remaining capacity under the existing medical marijuana optional premises grow license that could be converted. And that would constitute a license under retail marijuana, which would be stopped by this.
So I think that's what this suggested change is.
And that's what I mean by keeping the size and the location and the scope of the existing enterprise the same, but simply reapportioning the product to different
Market.
different market, a different venue, a different retail ability.
So that's what the word conversion means. So you're going from, you're not increasing the number of plants, is that right?
That's my understanding, but I hesitate to completely address that.
So a conversion can be to, do they need a separate license for manufacturing or for testing, or would that be part of the conversion?
That would be a separate activity which would require a different type of license. It would not be one type of cultivation becoming a different type of medical marijuana cultivation becoming retail marijuana cultivation. It's a different type of activity.
Okay. But this moratorium would protect the concerns of the caucus from not happening during the moratorium period.
Well, as you mentioned, George, the caucus was trying to discuss this for a while, and it took them a bit to get a quorum essentially present so that they could conduct some business. And I wasn't there, and I would assume that there was a bit of discussion on the part of the caucus members just to the effect of how this new system of ours works, and I don't mean of ours just the county, but the state in general. And I would assume that that is what led to the recommendation that was expressed to us. And it was not nuanced as to conversion of inventory or allowance for testing of inventory that's already being grown or anything else. It was just simply it was in the simplest terms, no retail marijuana licenses of any kind.
Any other questions at this point of the commissioners? Steve?
Jordan said he had 5 different licenses, like some of them would be medical marijuana licenses, and he said that some of them would be expiring during the time of the moratorium. Do you have the dates and the types of licenses that could be affected?
There are 2 types of licenses. There's a infused products manufacturing license for medical marijuana, and there is an optional premises cultivation license for medical marijuana. Those are the 2 types of activities on the premises. I do not know what the dates of expirations are.
Yeah, because he holds other licenses in other areas, like the city license to sell. You might have been referring to that.
Could we ask Mr. Klein that
We'll have
question?
public comment.
Is this a public
Yes, this
Yes.
is a
public hearing? Okay.
George?
So what I understand from the last caucus meeting, which Jordan had attended, was that he does have an additional license, which is a testing license for that, at that facility as well.
No, an infused products manufacturing license, not a testing license.
A manufacturing license, thank you. A manufacturing license. And that was given under slightly different auspices of the codes at that time, where there was a grow site in a house that was still being used as a residential, but since that time, it's no longer being used as a residential, so it's really a commercial operation, and there was concerns from the caucus members about the ability to convert that manufacturing or extend and renew that manufacturing license without having public input. They have some concerns about safety, about fire hazards, because in a sense, it's similar to distilling a product. If you're distilling potatoes to make alcohol in your home, there's some dangers there. So they have concern about that. And again, I think the way this is worded, our moratorium would protect them, but it would not prohibit Jordan from coming in for renewal and again having a public comment and bringing it back to the caucus for consideration. So that's how I understand it, but that's the background.
And let me just try to clarify here. The manufacturing is for medical marijuana, which is different than retail. We do have a moratorium on all medical marijuana licenses at this time, so regardless, he can't, we put a moratorium in place until we rewrite the medical marijuana.
With the exception of renewals.
With the exception of renewals.
Yeah.
So he could come in for renewal of a medical marijuana license now, and the Crystal River Caucus had not put on their agenda medical marijuana for that meeting, so they have not become a moratorium site for medical marijuana. So this would not affect at all a renewal of any medical marijuana license within the Crystal River Caucus going forward.
That's not entirely correct, because they have stated earlier that they did not want to have any dispensaries on the Redstone Boulevard.
That's within the Redstone district, not within the Crystal River
Yeah.
Caucus area. It was two different groups talking to us.
Right.
And this is not within the Redstone district, this is within the Crystal River Caucus.
The caucus, Redstone District is part of the caucus.
Yes, but not all of the caucus is within the Redstone district.
Well, it's the caucus. The caucus is a caucus vote is a caucus decision in terms of how they view their entire boundaries and neighborhood.
There is a prohibition on medical marijuana licenses, particularly retail, for areas within the village of Redstone.
Yes.
Yeah.
But this is not within the village of Redstone.
Well, this is the caucus in its entirety,
Yeah.
which would include Redstone.
Any other comments from commissioners? At this point, I will open up the public hearing on this event. Anybody wishing to speak on this item, they may do so at this time. We do have two different items here, and they're addressing two different things. If people want to speak to both, I understand that, but try not to completely spend a lot of time repeating your comments. So this is the item on retail marijuana, as we've been discussing. And if you just raise your hand, Herb, if you'd like to come forward and state your name for the cameras and the record, and yeah.
Thank you, Ron. For the record, my name's Herb Klein. I'm an attorney representing Jordan Lewis and his business entities, commonly known as Silver Peak Apothecary. With me is Mike Woods, one of Jordan's partners. Jordan was unable to be here today. You've covered a lot of ground and that we were going to talk about, and I think that's great. It's really helpful. We have 5 licenses presently at the facility in the Crystal River area, and one of them is coming up for renewal with the state in December. It doesn't come up for renewal in the county until that date in early March, but it could create some issues for us with renewing in the state if there's not a county program that license could plug into. There's also conversion of licenses between medical and retail and medical. From what I've learned, the market is trending more towards retail, as you can imagine. And as demand changes, activity at the storefronts, which are located outside the Crystal area, that changes. And the business needs flexibility to move back and forth between these two types of operations. In effect, what's going on now is that some of the retail activity is really subsidizing the medical activity, and my clients intend to continue medical operations. But there are some conversions that may need to take place as demand shifts and as retail facilities located, for example, in Aspen, a couple of medicals may convert to retail, and that is a licensing issue. Every time there's any kind of change, it triggers a licensing process. There's 11 different kinds of licenses for medical and 11 different kinds of licenses for retail. So it gets very complicated. Every activity requires a license. Every nuance in a change of activity requires a license. But on the ground, at that facility, nothing changes except some tags get moved around. And Mike can explain that, and he's brought some tags. I think it's helpful to actually see what's involved, because the number of plants doesn't necessarily change, and whatever the external impacts may be to the facility doesn't change. When a plant starts out, it's tagged for either the broad categories are either medical or retail, and then it also contains information as to which storefront it's identified with and what strain of product it is. So these are examples of some tags, and they can adjust their inventories based on demand by assigning tags to plants. And that's the way the state, as you know, it's highly regulated, and the state tracks the inventories from the point of their initial growth right up to the point of sale. And every step of the way is monitored very closely in real time. This is all computer feeds going back to the state. Every time there's a tag put on a plant, the state knows about it. So while we fully respect the intent of the caucus to take a step back and look and see what happens in the marketplace and what they may want to do, we have kind of a unique situation here. We have an existing facility that has ongoing operations. It has a very active storefront side, and it's trying to operate in a regulatory environment that's quite onerous. The language of the proposed ordinance is very broad, and it doesn't really address the actual operational needs of the business. If the intent is to shut them down, then the language in the ordinance is going to go a long way to doing that. We don't believe that's the intent, and we don't think that that's necessarily a good policy at this point. You've got an existing business. It employs a lot of people in the community. It serves clearly a need that vast majority, was it 75, 80% of our local population supports. And all we're asking for is an acknowledgement of the reality, the operational reality that the business needs to continue to operate. We are not intending to seek a new license for a new facility. We've really narrowed this down just to deal with renewals and conversions of licenses at an existing facility. And Mike is available. I don't know, Mike, if you want to comment further or if you have any further questions for us.
Well, Mike, you can give your public comment at this time if you'd like.
I concur with everything that Herb said, and I would, as we have these, the net impact at our farm, which is the grow area, is about 800 square feet. This is the impact. This plant gets this tag or it gets this tag. That is the sum of the total impact to the site of additional licenses. We have additional licenses that can be converted, and one we are in the process of converting right now with the state, and that'll come back around June 15th, and it will take one of the medical licenses that's in our current OPC and convert it to a retail. And under this scenario, under the language that's currently there, it doesn't look like that could be done, or if it is done, it might take 3 months to get it sorted out, and it's a problem for us. The season is upon us, and if we're going to do something, we need to be able to move on it. And when we put in the application to the state for the conversion, it was April 30th, and we had no idea that this was going on. So it was a surprise to us, and we just asked that it be that conversions and renewals be allowed. Herb brought up a point on the renewals that I'd like to clarify, and that is that we have licenses with the state right now that expire on 12/31/14, so at the end of this year. And we have to renew those 45 to 60 days in advance. So we're into, let's just call it November 1st when we go into the state for renewal. They will ask about they could ask. I mean, the rules are changing all the time with the state. And as we all know, this is an evolutionary process that we're engaged in. And when we go in, they'll say, oh, you have a lease on the property. It doesn't run through the entire term of the of the license. So you have to get the lease synced up with the licensing. So it's a 1-year license. The lease needs to cover the same amount of time. That could happen with the local licensing, because our local licensing only runs through, some of these run through March 15th, which is okay from a moratorium standpoint. But if we want to get our state licenses renewed before they expire, we may have to have a longer window. We may have to get the 2 licenses synced up. So.
Okay, just to stay in sync here with our public hearing, what I'm going to do is go through the rest of the public hearing on this, and then if commissioners have specific questions to individuals, we'll allow some leeway on those things. So anybody else at this point wishing to make a public comment on this public hearing, they may do so at this time.
Thank you.
Yes, please just come forward and state your name for the record.
Good afternoon. My name is Maureen Thompson, and I just wanted to take a minute to kind of maybe put a little bit of a face to the reality of the situation. I'm actually a special education teacher within the local school district, and I work for Silver Peak Apothecary as a consultant to do some trainings, and they've hired me to work for them. And to be honest with you, it's a livelihood for 20 to 25 local people in this community that if, Jordan's operation is to be shut down, we are not able to pay our bills, our mortgage, and we are hardworking people, and I just would like you to take that into consideration. Even as a full-time teacher, I'm still in need of supplemental income, and that's what this organization provides. And there are several other people here that could probably attest to that, and just wanted to put a face to a paycheck that really supports a lot of people in this community.
Thank you.
Thanks for your time.
Anybody else wishing to make public comment on this item, may do so at this time. Seeing none, I will close the public hearing and bring it back to the board for further discussion or questions. George?
John, Herb talked about there may be a problem for renewal with the state if the county, if there's a time lapse there. Would the state issue a renewal license and then just send it to the county for their approval or denial?
In the past, that's what the state has done. They've issued a license for a particular type of activity in a particular location to a particular licensee, but the license is contingent or conditional upon the successful completion of whatever the local jurisdiction has in place for authorizing that activity. If it's a licensing procedure, if it's an administrative sign-off, whatever it is that has been set up by the local jurisdiction has to be completed before a person can rely upon the state license. So the state license gets you half the way there. You still need local approval to be able to conduct the activity.
But the state wouldn't deny a license based on a current status?
I haven't seen that, but our experience is relatively small. And so I don't know if perhaps they're taking that into account now. I just don't know. All I can do is tell you in the past that they have not denied, they have issued it, but the issuance is conditional upon approval from the local jurisdiction.
At the last caucus meeting that I attended, Jordan was up there to do a presentation, and were you there as well?
Yes, sir.
Yeah, thank you. And to answer questions. My recollection, and correct me if I'm wrong, was that the focus was really on the issue of the renewals and the timing factor. The question or the proposition of a conversion from medical to retail, I don't believe came up because the discussion around retail was fairly unanimous that they did not want to see retail. They wanted to be able to participate in a moratorium as the other caucuses for retail, and there was not a discussion or the question about a conversion. So that's how I remember it.
Yes, and we had an hour's notice before we drove down there. I'm not sure our thoughts were as together as they.
So anyway, so caucus was not really aware that is another whole component in terms of discussion, but seeing a convergence from medical to retail, they just did not want to see retail.
Commissioner comments? Michael and then Steve?
Well, I mean, it's gotten very complicated, but the language that has been suggested here as a change seems fairly straightforward to me. And it's about, essentially about one facility that's changing tags. It's been explained by some of the public comment. And I'm not sure that is, I don't see that the intent of the Crystal River Caucus was to shut down this facility, but it was to prevent new facilities from occurring until after the moratorium. So I'm very comfortable with this language that they've suggested that exempts for this facility renewals or conversions. I think we should include it in the resolution.
Rachel?
Yeah, the one thing I didn't pick up on in this whole conversation yet was about the manufacturer, and if I could get some clarity on that, it would help me. Is there manufacture within the 800 square foot facility that is the medical grow facility currently?
We have a license for manufacturing. Haven't used it for several years.
Okay, so there is no manufacturing on site
There is
currently?
none is going on and hasn't since October of 12.
Okay.
But the license is there.
In terms of keeping the language of the license clear in my mind, and maybe it'll help the other commissioners, it's a manufacturing license for medical marijuana, which is very different than a manufacturing
Yes.
license for retail
Correct.
marijuana.
Correct.
They are
Yes.
two separate licenses. Like
They're
you
different
said, there are
licenses.
11 different licenses through this state or
Yeah.
whatever.
Yes.
Thank you.
Or whatever
You
it
could
is.
produce the exact same
So,
product, but you'd have to do it.
what we're talking about with this ordinance is retail marijuana moratorium. It has nothing to do with medical marijuana other than a conversion to, that something might be converted
Right.
from medical
I know.
to retail.
I just wanted to be
Yeah.
clear whether there was manufacturing now of any sort on the site, because I can certainly understand the community's concern about the safety and perhaps additional rigor of inspections necessary for a manufacturer facility of any sort. There's starting to be stories of folks doing it at home and not having the greatest success with fires and things like that. So I guess I'm in the general position that Michael is in. I don't think that there's an intent to create code that will step by step close this business or close this business at this time. I'd like to just bear in mind it's 800 square foot. And the issue for me, which is, just a business proposition, but if you have to renew a lease and you don't know, you're going to have to renew it for a year if you're going to be having to close down in, March of 2015, or whether you're going, how can you sign a year-long lease for 2015 and tell the state you have a year-long lease for the building and require someone basically to perhaps take it on the chin for 9 months worth of lease payment when they may have to close the facility. And I think that this is more appropriate to be more specific towards new retail or new medical licensing going forward. I realize we're only talking about one of them right now, but that seems to be the intent of the caucus. And, I would point out that from my recollection of reading the caucus's email, there were some pretty split votes there. It wasn't nearly as unanimous as the AMA caucus or the Snowmass Capital. And, I've heard from a few individuals to say, how come we have folks coming up to lobby us against this, and how much outside influence do we need in terms of making our own decisions? So I'm in the position with Michael in terms of being willing to modify the ordinance.
George?
I don't believe the intent of the caucus was to
I think they would have...
prohibit the current medical grow site. I think they understood it was there and they were comfortable with that. Again, the conversation never was presented to them that there was a possibility to actually convert the existing medical to a retail. And they did have a vote saying they did not want to have any retail. They wanted to participate in the moratorium. So there's a slight difference there in terms of what this would allow and what I believe the intent of the caucus is at this point.
And let me just ask again to be clear in my head here. The license in that location has already been converted
At the state
to
level.
retail.
No, not all of the licenses.
Well, one of the licenses, a license on that location has been converted to retail. So there is retail activity at that location,
Retail grow.
retail grow operation.
So then given that, then given Herb's wording, can we then limit it to what is actually existing and not to allow any future new licenses or new conversions?
I think that my view is what they're asking for is some freedom not to expand the business, not to increase the number of plants, but just essentially a paper shuffle or tag shuffle. That's, so the impacts are virtually the same. It's simply on paper you have a blue tag instead of a yellow tag. So I'm comfortable with that. And I think that the real issue for the Crystal River Caucus is they don't have a proliferation of new sites and of new operations. And this will prevent that from happening. But given that there is one in existence, it allows some flexibility within that one, but no expansion of that one. So I'm perfectly fine with it.
Yes.
I agree with Michael. A plant is a plant. And this isn't opening up retail locations in Redstone for sale retail, door-to-door retail. And as we're going through this, this is not any sort of long-term guarantee. When the full regs are in effect, and should a license be reissued in 2015, it doesn't mean that it wouldn't be denied in 2016 should there be an outcry and a packed chamber and neighbors upset and there's been issues. So it's a very short-term continuation of an existing operation of the existing number of plants and activities on that site. I think that it would be important for me that if we could to say that there will not be manufacture on that site. Because there's not now, and that would constitute a little bit of a new activity for the caucus to be concerned about. And if we're converting away from medical to recreational, then why should the site remain and use a medical manufacturing license? That would seem inappropriate to me. It's almost like you'd have to bring the medical plants from somewhere else up to, and that I think starts to raise some real red flags. So I'd like to see if this language can accomplish the goal of allowing the conversion of the medical plants to retail plants, no expansion of the number of plants or the 800 square foot, and allow the business to continue to employ folks and to make the appropriate decisions on their lease for the state license, and let it play out a little bit.
John?
I would offer one bit of further explanation. When the board first started to adopt into the regulation the recommendation of the various caucuses concerning different types of activity, the intent that the board expressed was, in so doing, was to allow the residents within the caucus areas some certainty as to what would happen so that into the future to at least a fixed point in time, so they wouldn't have to continually watch for the public notices for license applications and then appear and respond and that sort of thing. And also to put the people engaged in the business of marijuana cultivation and sale and so forth, either medical or retail, an advance notice, if you will, that this particular area is, at least for the time being, not available, so don't invest your time and money and so forth like that. By relaxing the prohibition as adopted in the emergency ordinance, what you're doing in effect is relaxing the prohibition. If a license comes in for review, it's not automatically prohibited, and it will be pursuant to the regulation referred to the appropriate caucus for comment. The board can review that license application as it sees fit and determine whether or not it should issue. It's not an automatic one way or the other. It simply allows the door to be open for the board to entertain that type of license, and then allows everybody to know that this is potentially available, be prepared to comment to the board one way or the other on whether it's advisable. So it's not an automatic. And Rachel, your comments on the manufacturing license, I don't know what the outcome would be on a request for a renewal. It involves facts that I just don't know of. I do know that the property was inspected by building and by the fire district, and found to be fine in both accounts. The license is still there and valid unless the licensee relinquishes the license. There hasn't been any activity upon which the county could move on to revoke the license prior to its natural.
I'm just giving a little bit of a heads up as we go into the renewals of all these, that just didn't seem fitting.
One of my thought process here is that, the difference between the retail and the medical is that we've written the application process for, and I think this is what you were kind of stating, we've written the regulations for the retail marijuana to the extent that we feel comfortable, and there is a great deal of leeway for approval or denial in that application process when the renewal comes up, when the new license comes up. And if we do add some language to this ordinance, I'd like to make it clear that it would be for consideration of renewal, not for renewal, because the reality is we can deny that renewal based on public input from the neighboring caucus areas, the neighbors, or whatnot, as we see fit. So at that point, the consideration would come before this board anyway. That consideration doesn't happen with this next item on our agenda, which is the medical marijuana, because we have not written the regulations to include the BOCC as part of that approval process. It's an administrative approval versus a hearing approval, which to me, part of this in my mind, and I'm speaking out loud for the rest of the board to have them know my thought process here, was trying to find some continuity between the two items that are in our confirmatory reading section on our agenda today. So I guess with that said, in my mind, I could agree to language of such, but I would add to that language that it would be for consideration of renewal as opposed to renewals allowed, which is really just stating the fact that it comes before us anyway. Steve? Whoops.
My intent totally would be not to shut down the existing operation on the Crystal River, but to prevent any new operations from opening there. And in order to provide certainty and sort of a good faith to the existing operation, I think that we need to change the wording to make it something that they're comfortable with, and not have them be, feeling this uncertainty that they might not be able to renew a license during the intervening months until February. So how we change the wording, since this is a confirmatory reading, is
Rachel?
something we have to decide.
Yeah, We cannot offer anyone assurance of a renewal of any license, whether it's liquor, marijuana, or anything like that. So we can do what we're doing here with this reading, but we can't go further than that. And I know John has that suggested language that Herb had submitted. Rob has made a small wording change to that. I'm just wondering if John Ely could read that language and where it would be changed in this ordinance, if to go where the majority of the board seemed to be heading.
My understanding would be that the language is as proposed.
But the public hasn't seen that language, so I'm hoping you could read that.
Oh, I see.
New-
Oh, actually,
okay.
again, Herb, do you have a copy of that? I'd like to give that to
George?
Rachel, aren't you suggesting that we add Rob's comments and your comments to that language
Well, my comment related to manufacturer,
and expansion?
yeah, clearly no expansion
Yeah.
allowed, conversion doesn't allow.
Right.
But I don't know that we could add manufacturer to this without changing the scope of the emergency ordinance too much, A. And then B, I think we've heard intent that there's not going to be manufacturer there, and that I don't think it would be looked upon favorably if it was set up for 2 months and then they had to come in for their renewal. So I think that that's been pretty well telegraphed without having to affect this ordinance. But I'd like to have John read the language,
Sure.
potential change, and then we can all see if we're agreeing with that, and then someone can make a so move.
And I realized I needed a hard copy too, just for Jeanette. I didn't want to rely on the emails that I'd had. The proposed addition that is being offered by Mr. Klein is an insertion, an interlineation in paragraph 1 of the ordinance language that would read, provided, however, that with respect to the Crystal River Caucus area, this prohibition, which is a prohibition against all and any retail marijuana licenses, this prohibition shall not apply to the renewal of a license for a retail marijuana establishment that is in existence as of the date of the adoption of this ordinance, or to a conversion of an existing medical marijuana optional premises cultivation, grow, facility, license to a retail marijuana cultivation facility license that will be located at a retail marijuana cultivation facility that is in existence as of the date of the adoption of this ordinance. And the addition that
That this shall not apply to the consideration of a renewal license or the consideration of, that's the language that I would add.
Conversion license.
okay.
That basically what I want to state in there with a little clarity is that a renewal is not just a renewal. A renewal is an application for a renewal that the board hears. And that's the way we wrote our retail marijuana licensing procedures. So, I mean, it's already implicit in our code, but I want to state it in this ordinance, just to be clear that for the people of the caucus area, that we will consider their input at that renewal hearing.
Right, and that also appears within the text of the balance of the retail marijuana license and regulations that require a referral to the appropriate caucus on any license.
Correct.
In addition to that, there was some discussion from the board having to do with the conversion opportunity not being prohibited, provided that there is no increase in the size of the operation, the number of plants, the size of the facility associated with the operation. I wasn't sure if you wanted to incorporate that in as well, or simply review that when an application is in front of you.
Rachel?
I'd like to include it. I think that that's been what we've discussed, and that would be, again, further assurance to the caucus that we're not expanding. As I said, a plant's a plant, but it's the same size facility, in my mind.
Okay.
Herb, you had a specific point to that
Yes.
language,
Yes.
since you presented it first.
Yeah. And I'm thinking instead of, consideration, because that's very kind of indefinite, if you could work in language, something like, if approved by the Board of County Commissioners, as opposed to,
Sure.
If
allowed
approved,
to be considered, because you're considering stuff right now, and it's not a licensing process, but have this same language, but then say, if approved by the Board of County Commissioners.
Yeah,
Sure.
if approved at a renewal hearing by the Board of County
Sure.
Commissioners.
Yes, Michael, quick, just to the point.
Is there language in there about the number of plants?
That's what we were considering adding, that we would have a non-growth clause in the moratorium,
Non-expansion.
non-expansion
Non-expansion.
clause in regards to
Yeah.
the total operation of the facility.
Okay, I think my point is, here is that the number of plants can vary, because you can have like a lot of clones starting out, and they all don't make it. So if anybody wants to...
Total allowable plants?
What's that?
No growth in the total allowable plants?
You know, for
getting complicated.
for me, an 800 square foot facility
That's
is
it.
only going to hold so
That's
much.
it. That's
So
it.
whatever stage of growth they're in or not,
Yeah,
so
some
be
are
it,
small,
you know.
some are big.
Right, so it's
Yeah.
whatever works in the 800
That's
square
correct.
foot.
Johnny, is that clear to you?
That's fine. The only other inquiry I have for the board is a determination of whether the board feels that this is a significant amendment that would require essentially an abandonment of the initial ordinance and an adoption of a new emergency ordinance, or if this is an insignificant amendment pursuant to the home rule charter and therefore can go forward. It is a determination of the board in its legislative capacity and based solely on your judgment.
I believe this to be a clarification of wording of the original emergency ordinance that was somewhat vague, and so I consider this insignificant.
Okay, if that can be incorporated within the motion.
I do too. I don't think it's a significant change, just a clarification.
Yes, I believe we have consensus on that.
I would move to approve an emergency ordinance of the Board of the County Commissioners of Pickens County, Colorado, amending the Pickens County retail marijuana licensing regulations to prohibit the issuance of retail marijuana licenses in the Crystal River Caucus area with an insignificant change to the original emergency ordinance for clarification purposes, now including language under item 1 of the now therefore be ordained portion of the measure with the language that has been read and refined by our attorney, John Ely.
Second.
You have a first and a second. Is there any further discussion? Seeing none, I will call the question. All those in favor say aye.
Aye.
Opposed? None.
All right.
Thank you. Next, John, we've got the confirmatory reading for the Pickens County medical marijuana license regulations to prohibit the issuance of medical marijuana licenses in the Woody Creek and Emma Caucus areas.
This is essentially in the same footing as the previous item. It is as an emergency resolution because the existing medical marijuana license regulations were adopted through resolution as opposed to ordinance. A change is being proposed and was accepted by the board on May 6th for the adoption of an emergency resolution that included within the scope of prohibitions the areas of the Woody Creek Caucus and the Emma Caucus. Both of those caucus areas have forwarded recommendations to the BOCC that medical marijuana licenses not be issued in either of their caucus areas. This would be consistent with the prohibition that the board has already put in place to the Frying Pan Caucus, as well as the existing prohibition for no optional premises cultivation licenses for the Snowmass Capital Caucus area, and no medical marijuana center licenses for the Village of Redstone within the Crystal Valley Caucus area.
Questions of staff at this time? Go ahead, Michael.
So caregivers aren't, they can continue to,
That's correct.
so they're not, but are they licensed, John, or it's a different type of?
There is no local license for caregivers.
There is no local license for caregivers. Is there a state license then?
There is a regulatory mechanism for caregivers such that they are I'm not sure if they use the term license or not, to be honest with you, but they are regulated through the state, and they are disclosed to the state, so the state knows where the activity is going on.
Okay.
But it is not pursuant to the state regulatory scheme, an activity that is licensed or approved through the local jurisdictions.
Okay, so,
So they are not affected by this.
okay.
Rachel?
John, just a curiosity, if you know, I know this last legislative session, there were some efforts to limit the number of patients a caretaker could have or total number of plants. Did that pass? Is there now some new standards there?
I'm not sure, to be honest with you. It was discussed for a while. I don't know.
You want to ask Lauren?
Well, it's up
that?
to you.
I can
Yeah,
answer
you can,
it.
if you can ask that direct question, thank you.
Rachel, yes.
Identify yourself for the
Oh, I'm
record,
sorry.
please.
Lauren Maiden, attorney, locally. That it has been passed, and what happened was the CDPHE, which is the one that is the registrant of caregivers and who they're caregiving for, has issued a statement to the doctors stating that if you are in fact going to issue a plant count above 6 plants, which as you know is kind of a stated norm, if they're going to do that, the amount of documentation that will be needed to be supplied not only to the doctor but then to CDPHE for their doctors to review is a huge turn in what's gone on. Huge.
So,
to the point where 60 plant counts, which were not atypical, but you'd see them on some sort of basis, are going to be so limited at this point that you're really going to be seeing mostly almost all exclusively 6 plant per patient counts. So the system is changing drastically.
So you're saying the bureaucracy has changed this to make it very difficult to have above 6 plants, is
They
what I...
basically added additional red tape so that if a doctor was going to provide that upward allotment, which is what it's called, then they were going to have significant proof.
Okay, but is a caretaker themselves limited from having 100 patients?
There are 5 patients, which is the norm.
Caretaker.
However, I have a client that has 80-some patients. He's in Mesa County where it's a dry county. So in our jurisdiction, in this valley, you are not going to see more than 5 patients because of our proximity to the available facilities.
Thank you.
Other questions of staff at this time? Steve?
Part of our discussion 2 weeks ago revolved around coming up with our new medical marijuana ordinance to match the other. And John, have you been working on those yet, or what's the anticipated date that those might be coming forward?
They're completed, and it's just for scheduling now, so as that fits into the board's schedule, it'll be in front of you.
Rachel?
Yeah, one last question. This is always a learning experience. I apologize. But does the state, in the issuance of its licenses, prohibit them from being issued to a caretaker? You can't have a caretaker growing their plants in a property owned by someone who has a retail facility or a medical facility, or, you know, how do they avoid crossover of those interests?
Well, I suppose the crossover is accommodated through the inventory tracking system, which was the ID, the barcode ID cards that we just looked at. I don't know if there's a prohibition against the same physical premises being used for caregivers as well as another licensed activity.
Okay. I think it'd be good to look into that as we go to the final regs and see if there's any, because, you know, I appreciate your knowledge in that, you know, we're different than other counties because we do have retail facilities for medical, but I'd hate to see a situation where someone is not, is now merging the two in a funny sense, you know.
They
so.
can't.
Okay.
You can be a primary caregiver and an owner of a business, but they can't be on the same licensed premises. So the same square footage that's being used for the commercial cannot be someone's own primary caregiving spot for growing.
Thank you.
So one question that I have, John, is in regards to some of the language that we added in the last ordinance. Are there existing medical marijuana licenses within these two caucus areas that might be coming up for renewal? Because this is affecting new licenses, and are there already existing licenses, and should we be treating this the same way? I'm giving that for the discussion of the board in terms of should we be treating it the same way, because as I stated earlier, the big difference between retail and medical is that we have taken the due diligence time to write the retail regulation, and part of the reason why we have a moratorium already in place for medical is, but I believe the moratorium does not include renewals that's in place. So the reason why we issued a moratorium on the medical was to allow us to rewrite those regulations, primarily with discussion about having a board review on those licenses. So I guess the first question, John, is to you in terms of, do you know of licenses that, any licenses that may be up for renewal in this area?
There are none in the Emma Caucus area. There have been applications within the Woody Creek Caucus area, but none have issued and are being relied upon.
Okay.
There was talk during one of our previous hearings about another grow site near the site that was in the Woody Creek area. And I don't know.
It's not within the Woody Creek Caucus.
It's not within the Woody Creek Caucus.
Is that down in Old Snowmass?
Oh, okay.
And since we are going to be able to start the hearing process on the code update,
Yeah.
I think any of those renewals would be subject to the public hearing, similar to the last one, in that there's no automatic renewals, and
Yeah.
we'll take the comment at that time.
Yeah. Any other questions or comments regarding the staff presentation? Steve?
Michael wasn't here at the last meeting, but at the last meeting, Michael, I voted against this ordinance because it did not have a sunshine date in it like the retail marijuana ordinance we passed. And others were not concerned because they felt that, we're going to be passing the new medical marijuana ordinance to more or less mirror the retail one. And the fact that's why I asked you that question, we're going to be dealing with that very shortly here. And since I have that certainty in myself that we will be discussing that and coming up with our medical marijuana, I feel like I can change my vote to support this. The important part of the ordinance is that we are supporting the wishes of the Woody Creek and Emma Caucus areas, and I definitely want to support their wishes in this matter.
Other comments or questions from commissioners at this time? Okay, this is a public hearing. Anybody wishing to speak on this item may do so at this time. Just come forward and state your name for the record.
Hi, Linda Wog. I'm a member of the Woody Creek Caucus. Excuse me. And I just want to reiterate that we did vote for a moratorium on any marijuana licensing whatsoever within the caucus area. Just reiterate.
Thank you. Anybody else wishing to speak? Lauren?
Thanks. Good afternoon. My name is Lauren Mayton, for the record. I am here to discuss this proposed emergency medical marijuana rule that was enacted May 6th, prohibiting marijuana licenses in Woody Creek and the Emma Caucasus until at least we have some public input today, and then we'll see what happens. As you know, the Pickens County medical marijuana ordinances were adopted June 27th, 2012. As adopted in 2012, an applicant's license was to be approved without public hearing upon the findings of the local licensing authority concerning their investigation on a huge number of issues. The other issue that had to be dispelled was whether or not the business was within the proposed caucus area that was in the Frying Pan Caucus or the Snowmass Capital Caucus in the town of Redstone. They voiced their opinion to the BOCC prior to June 27th of 2012. Prior to that enactment, the BOCC and the members of its staff solicited the caucuses repeatedly, held meetings with the caucuses. I was at numerous meetings with those caucuses, invited to come to the caucuses to speak with them. And then you ask them time and again whether they wanted to have that marijuana business in their caucus boundaries. As I just mentioned, the only caucuses you heard from after those repeated outreaches were the Frying Pan, Snowmass Cap, and Town of Redstone. After passage of the marijuana ordinances in 2012, nearly 2 years ago, the BOCC didn't stop with their solicitations, and they continued to urge the caucuses in the Pickens County area to vote for or against marijuana businesses. Why? Why all the urging? The BOCC has routinely held, and I've heard it, whether it was this hearing or marijuana hearings or other ones, that the caucus vote is only a recommendation. It appears today that the caucus, in fact, controls the BOCC. The caucus wants the BOCC to extinguish marijuana in its caucus area over 2 years after their vote was solicited on the very issue they're now putting forth, and requesting the BOCC adopt an emergency ordinance with no justification other than they finally got around to voting. Medical marijuana has existed in Colorado since 2000. It's 2014. The Pickens County medical ordinances were enacted in 2012. How can there be an emergency today? What is the emergency? More specifically, what is the mechanism that triggered the need for this emergency ordinance to be drafted and enacted May 6, 2014? There's no influx of applications. I just heard there was more than one. My understanding on May 6th, there was one pending application. One. You're not running out of time to act on the matter. There's no time constraint, forcing, like you haven't reserved a room for somebody that you've employed that you have to fill into that room, so you need to find some emergency money to make sure the person can go live in this housing unit that you've brought in to hire, or some other emergency trigger. If you claim there's a public health and safety issue necessitating the emergency, how can this be so? There's been a large-scale commercial grow on North River Road for 4 years with no threat or harm to the public health or safety. In fact, the neighbors had no clue that the grow even existed until, in fact, we mentioned it in public, and until there was a sprinkler incident. And I don't know how well that was publicized. Medical marijuana grows of various sizes have existed in the Woody Creek area for years. The Woody Creek and Emma caucuses were silent and inactive on this issue for many years. Stand up to their silence and inactivity. Just because they finally decided to vote doesn't translate into an emergency. The recommendation is not a dictate necessitating the emergency ordinance, but a recommendation that was due years ago if they wanted to have their wishes mandated into the ordinance. I applaud you for wanting to know the recommendations of your caucus areas. But to take the recommendation today and turn it into an emergency over 2 years after Pickens County solicited their opinion is deceitful and borderline corrupt. Commissioner Newman told Woody Creek publicly, repeatedly, more times than I really wanted to hear for sure, that Woody Creek should vote, should tell them what they felt. Make a decision regarding marijuana. And they didn't. Now the BOCC wants to apply the Woody Creek decision and the Emma decision to an application that is pending. Where's the integrity of this board? Where's the integrity of Pickens County to a pending application? You want to respect the wishes of the caucuses, but the caucuses didn't care enough to vote on the issue until 2014. Where is the respect the caucuses have for this BOCC and for the staff that the BOC directed to go get their opinions? Get your integrity back and don't enact this in ordinance or carve out a section for the pending applicants. And take the wishes of these caucuses as they are, as recommendations. And just as we just discussed about the previous ordinance, when this applicant's application is up for renewal, then the law applies, and the recommendations are great, and you need to follow them. They're your caucus areas. I don't have an issue with following a recommendation or weighing it in that public hearing that is going to be the new way to go about things for medical marijuana. I don't think that's the issue. It's the matter that you're affecting a single pending application in an emergency ordinance that's not an emergency. How can the caucuses claim to have this emergency? I don't know. The pending application needed only an approval without public hearing from the local licensing authority regarding their investigation on the application. And the result was that the applicant was compliant. At the direction of community development, the applicant further invested time and money and reliance on the direction provided by Pickens County. It's certain that the applicant continued to rely on the direction of Pickens County to his detriment. Instead of applying the Colorado statutory rule that's mandated statewide as it relates to pending applicants and their pending applications, that an application shall be heard under the rules and laws in effect at the time the application is filed, you want to claim that this applicant is different. You want to claim that you do not have to treat this applicant or his pending application with integrity and fair dealing, as is the mandate of the Colorado Revised Statute, specifically because it deals with marijuana. Where is the integrity? I understand your desire to honor the wishes of the caucus, but the emergency ordinance is not the proper mechanism. There is no grounds to trigger the crisis deserving of an emergency ordinance. Thank you.
Thank you. Does anybody else wish to add to the public comment of this public hearing? Seeing none, I will close the public hearing on this and bring it back to the board. Thank you. Rachel.
Yeah, I just want to respond briefly to the previous comments. This board has been, as the state has been, dealing with a cascading set of changes related to marijuana in Colorado. Medical marijuana may have been approved by the voters quite a while ago, but it really wasn't until the election of President Obama and a different point of view from the Drug Enforcement Administration that we began to see things called dispensaries, and we began to see the larger scale activities of marijuana merchandising in Colorado. We then saw the cascade following that of recreational marijuana being approved. These are sequential events. They weren't nice and smooth and laid out for us in advance. So developing the rules, developing the appropriate regulations for the general welfare, safety, and health of the public has taken time. It's new territory for all of us. And as they say in water management and water adaptation, sometimes you have to learn by doing. And I think this board has tried its best to be responsive to the public and to the industry as well in a fair and even-handed manner. Our goal in the emergency ordinance has been to synchronize our medical marijuana codes and our recreational marijuana codes. This ordinance was not, to my knowledge, asked for by any caucus area. It was the intentions that they brought forward to say this is what we would like in our final code. And it was the board's decision. I think Rob may have first brought it up to say, you know, we need a timeout period while we try to synchronize these codes. And as far as the charges of ethical behavior, I would like to point out that this is a licensing permitting activity. It is not a land use hearing. And the statutes relating to hearing a land use application under existing land use code, should there be a moratorium, is accurate. But a permitting decision for a license is not a land use decision and is entirely different. Thank you.
Commissioners?
Would you accept a motion, Rob?
Yeah, I'm going to ask a couple questions real quick, just of John, for clarification on some things that were said, if you wouldn't mind. First, the definition or guidelines of an emergency ordinance, is that written in our code somewhere or defined clearly?
It is premised upon the BOCC finding that a condition exists that would be addressed through the adoption of emergency resolution or ordinance. They're parallel criteria within the Home Rule Charter, that the action is necessary for the immediate preservation of public health, safety, and welfare of the citizens of Pickens County. And that recitation appears in paragraph number 6 of the emergency resolution.
Okay. And John, your interpretation of a little bit of what Rachel had said regarding the code or ordinances at the time of an application and how that applies to this versus a land use application?
State law, through the enactment of a statutory change, affected the requirement on local jurisdictions that applications for land use development reviews, or any type of application that would generate a site-specific development plan, as that term is then defined by local jurisdictions, must be reviewed consistent with the regulations and rules and code criteria in effect at the time an application is deemed complete. And that is a statute which applies to development applications or land use applications. It does not transfer to the issuance of a license or a license in regards to marijuana, any marijuana activity.
And then the only other comment that I had was, I also was in favor, although I voted for this last time, of what Steve said about having a sunset clause in this to some extent. I voted for it because I do feel confident that we will adopt the additional regulations for the medical marijuana licensing. And in comparison to the previous ordinance that we did before in terms of making an adjustment for an existing license, the big difference between that and this is that any renewal of licenses are going to be heard before this board, as opposed to an administrative process through a license designee, or county manager in the case of medical marijuana licenses. And this is the thing that I think nobody at this side of the table wants to say, but I'm gonna say it. And you know, it's a tough one. I don't think we got it right the first time around, the medical marijuana licensing regulations, and we don't get everything right the first time around. And that was the basis of me presenting the original emergency ordinance, which is in effect for medical marijuana licenses, although there was argument at the table at the time not to include existing licenses at that time. And I'm not sure we got that one right at that time either. So with that said, I'll accept a motion or further discussion.
Rob,
Yeah.
I've been thinking about Lauren's statement to us, and I was bothered by it too. I mean, she used the word corrupt, and she used deceitful. And that's painful for me because I don't think this board is corrupt in any way.
I did say borderline.
And I don't think we're deceitful in any way, and never have been. I think we all take our responsibilities very, very seriously. She mentioned integrity, implying that we'd somehow lost our integrity. And I think when you address people and your immediate address is to say they're corrupt, deceitful, and lack integrity, you're not going to get much sympathy. It's really not a particularly good strategy. I can understand having those thoughts, but I can also understand being more sophisticated than expressing those thoughts to the very people whose minds you're trying to change. That's the way I feel. So maybe in your next presentation to us, you'll forego the words corrupt, deceitful, and ask us to find some integrity. You just forego that, and you might get better results. I don't know. And in terms of the caucus being implored, if you were to rest on railroad tracks and the train is 100 miles away, you can have a nice nap. And if your decision is to get up when the railroad is 100 yards away, the train, that's a good decision. That's a very good decision. I don't think you should be impugned for that. And I don't think the caucus should be impugned for getting up and saying, we'd like a moratorium. I think that was probably a good decision. That's what they felt. That's what they expressed. At the time, the train seemed 100 miles away. But they got up when it was 100 yards away and made a good decision. So I don't think that you should impugn those caucuses either. I just think your approach was wrong. And it certainly didn't engender my sympathy, so I just had to say that.
Any other comment?
Make a motion.
Yes.
Where are we? Make a motion to approve an emergency resolution of the Board of County Commissioners of Pitkin County, Colorado, amending the Pitkin County medical marijuana licensing regulations to prohibit the issuance of medical marijuana licenses in the Woody Creek and Emma Caucus areas.
Second.
First and a second. Any discussion? One last element for me is that I just encourage John Ely to try to schedule the medical marijuana licensing regulations before us as promptly as possible. I know your office is taxed with a lot of issues and a lot of different things, but the sooner that we can sunset these, I mean, they're not sunsetted as part of the ordinance or regulation at this point, but the sooner that we can disenact these, the better off that we are. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Opposed?
Short break here?
Yes. I would like to take a 15-minute break. If we can come back at 2:05, I would appreciate it, and we will go into our public hearing second readings at that time. Thank you. Okay, welcome back, everybody. This is our Board of County Commissioners regular meeting, Wednesday, May 28th. We are going into our consent public hearing, second reading items 5 through 13 on our agenda. First is an ordinance approving a navigation easement with the Aspen Ski Company. And it says, I see Brian here, but it says Jeanette is here to present this, but I think you presented the first reading, so why don't you come up, just state your name for the record and give us a little brief.
Sure. Brian Griefey with the airport, Assistant Aviation Director for Administration. This is navigation easement offered by Aspen Skiing Company. Really, it was born out of their master plan approval process, recognizing that there is some development, at least proposed, for buttermilk that may or may not have impact on the airport. And this really sets up process in which they can evaluate if there is any obstructions. Also, second part of it is recognition, just formal recognition that there is an airport, there's going to be aircraft, there's going to be noise, and just formally essentially recognizing that.
We did go over this in the first reading. Is there any commissioner questions at this time? Seeing none, this is a public hearing. We'll open the public hearing at this time. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing on this item and bring it back to the board for a motion.
I would make a motion to approve the ordinance approving an navigation easement with the Aspen Skiing Company.
Second.
First and second, any discussion? Seeing none, all those in favor say aye.
Aye.
Aye. Thank you.
Thank you.
Next is a resolution approving an intergovernmental agreement for participation in the Emergency Fire Fund with the state of Colorado. And Valerie's here to present that.
Second reading for the Emergency Fire Fund, and essentially that fund is, well, it's a funding mechanism to help pay for wildland fires in Picken County. Picken County has participated in this fund since I can't remember if it's 64 or 66, and this is a 5-year intergovernmental agreement, just solidifying or formalizing our participation in the fund.
Valerie, could you state your name and position?
Valerie McDonald, Picken County Emergency Manager.
Thank you, Valerie. Any questions, Steve?
Yeah, Valerie, could you explain the funding? Do we put any money into this, or is it something where we could get money if we have to fight a fire here, or how does it work?
Both. We pay into that fund every year. I believe this year was $54,000. And if we had a wildland fire that went to the state and qualified for the Emergency Fire Fund, it would pay for the fire suppression costs.
So it's like an insurance policy?
Correct. That's the easiest way to explain
We
it.
pay $54,000 a year, and at some point we won't have to put out $5 or $10 million to fight a fire, kind of a thing.
Exactly.
Okay.
Other questions? This is a public hearing. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing on this item. Bring it back to the board for discussion or a motion. Steve?
I'd move to approve a resolution of the Board of County Commissioners of Picken County, Colorado, approving adoption of an intergovernmental agreement for participation in the Emergency Fire Fund, EFF, with the state of Colorado, Colorado Department of Public Safety.
Second.
We have a first and a second. Any discussion? Seeing none, all those in favor say aye.
Aye.
Aye. Thank you. And next, Bruce Romero is here to talk about a resolution approving an intergovernmental agreement with the City of Aspen, Town of Snowmass Village, Town of Basalt, Fire Protection District, Snowmass Wildcat Fire, Aspen Fire Protection District, Snowmass Wildcat Fire Protection District, Aspen Ambulance District, and the Carbondale and Rural Fire Protection District concerning continuing operations in Aspen County Communications Center.
Sorry, I keep making you say that. That's quite a
know,
mouthful.
it's a mouthful.
This was presented to you on May 14th for the first reading. There were no recommended changes from the board, so if there are any questions, I'd be happy to answer those.
Questions or a motion? Oh, I'll open the questions first. Sorry.
My only question is do you have ESP? How did you know when to come here to our meeting?
I watch it in my office, and as soon as it gets close, I start heading over here.
Okay, this is a public hearing. I'll open the public hearing on this item. Anybody wishing to speak may do so at this time. Seeing none, I will close the public hearing on this item and bring it back to the board for a motion.
I would move to approve this item.
First and a second. Any discussion? All those in favor say aye. Aye. Next, Bruce is also here to present on an item with as many parties to this as before. It's a resolution of the Board of County Commissioners, Pickens County, approving the intergovernmental agreement with the City of Aspen, Town of Snowmass Village, Town of Basalt, Aspen Fire Protection District, Snowmass Wildcat Fire Protection District, Basalt and Rural Fire Protection District, Aspen Ambulance District, and the Carbondale Rural Fire Protection District concerning the continuing operation of emergency telephone authority services.
And again, this one was presented to you on May 14th. There were no recommended changes from the board, so if you've come up with any questions since May 14th, I'd be happy to address those.
Any questions for staff? Steve?
I noticed that it says this started on September 11th, 1991. And is that where the actual numbers 911 came from when you dial 911?
Definitely not. It was actually, 911 actually began in 1968. I assume that they chose that date just for the
Because the
representation.
911 already existed.
Correct.
Huh. Okay.
Any additional questions at this time? Okay, this is a public hearing. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing on this item and bring it back to the board.
I'll move to approve this item too.
Second.
We have a first and a second. Any discussion? Seeing none, all those in favor say aye.
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 Thank you.
The next 5 items are...
4.
I'm sorry, 4 items, you're right, there's one stuck down in there on the bottom, are ordinances for request for a treasurer's deed on county-held tax certificate, directing the treasurer to issue said deed. And I don't, we did have discussion of these through our first reading. I'm not sure if we need continued discussion on any of them. If not, I will move through the public hearings on these if the commissioners have specific questions on any of them. Okay, on item number 9, which is the BOCC property, I will open the public hearing. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing and open a motion for item number 9.
I move to approve an ordinance authorizing a request for a treasurer's tax deed on the county-held tax certificate, directing the treasurer to issue said deed, BOCC.
I have a motion.
Second.
And a second from George. Any discussion? Seeing none, all those in favor say aye.
Aye.
The next is item number 10, the same issuing of deed for the Blue Ridge property. I will open the public hearing on this item. Anybody wishing to speak may do so at this time. Seeing none, I will close the public hearing on this item, bring it back to the board for a motion.
I would make a motion to approve the ordinance authorizing a request for treasurer's tax deeds and county-held tax certificates and directing the treasurer to issue said deed, Blue Ridge.
Second.
We have a first and from George, a second from Michael. Any discussion? Steve?
Just for the public's benefit, these properties referred to, which will become the property of Pickens County, are up in the Lincoln Creek area in the vicinity of Ruby. In the Independence Pass region, real close to the Independence ghost town, and up Castle Creek Road, somewhere way up Castle Creek Road.
Near the Lindley Hut.
Near Lindley Hut, okay.
Any further discussion? We have a motion and a second.
Public hearing on this?
Oh, sorry, did we move to the next one? Or we're still in the Blue Ridge?
We have to vote
Oh,
on
okay,
this.
you're right.
We did have a motion and a second. We had a
Yeah.
motion from George, a second from Michael.
Okay.
And we did do the public hearing. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Next is item number 11 on our agenda today. It is for the Frazier property? Frazier property. Is there any questions on this application? Seeing none, I will open the public hearing on this item. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing on this item and ask for a motion.
I move to approve the ordinance authorizing a request for a treasurer's tax deed on county-held tax certificate and directing the treasurer to issue said deed, Frazier.
Second. We have a motion and a second. Any discussion? Steve?
For the public's information, this is a triangle of land just opposite Shieldo Terraces on the other side of Snowmass Creek Road, and this land is actually, I think, contiguous with the open space land that was created in the Snowmass Creek bottom as part of the Wildcat land.
Any further discussion? Seeing none, I'll call the question. All those in favor say aye.
Aye.
Next is the Kreft property, ordinance number, or item number 12 on our item. Any questions on this item? Seeing none, I will open the public hearing. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing and bring it back to the board for a motion.
I'll move to approve an ordinance of the Board of County Commissioners authorizing a request for a treasurer's tax deed on a county-held tax certificate and directing the treasurer to issue said deed for the Kreft property.
Second. We have a first and a second. Any discussion? Seeing none, I will call the question. All those in favor say aye.
Aye.
The last item on our consent public hearing, second readings, is an ordinance authorizing the purchase of the Moore River parcel property. And Matt, our acquisition representative from Open Space and Trails, is here to present with a map that he's going to load up there. And Matt, if you just state your full name for the record.
Matt Adeletti, Land Acquisition Manager for Pickens County Open Space and Trails. See if I can get a map up here for you. Great. This went to the first reading on May 14th. This is the second reading and public hearing. Thanks.
Yeah, I thought that was a lot.
While John brings this up, this is the, like I said, the second reading and public hearing for the acquisition of the Moore River parcel. Yep. that's it. And the top one, please. What was the?
It'll get a little later.
Okay. This was a map I pulled from Google Earth. The other pictures, the maps I had were two-dimensional, but I wanted to give you something a little more three-dimensional, but when it comes in, maybe. And I will, yeah, there we go. The parcel is basically the majority of what you see here in this map. Because this is a 3D picture, it's looking to the west, so the parcel is approximately 36 acres, and it's basically a square, but because this is a 3D image, it's more like the western boundary you see right about here, and then the property is just like that. So you can see where it encompasses the Roaring Fork River and the Rio Grande Trail. It's vacant land. It's approximately 1 mile down valley of the airport, and the Open Space and Trails Board has unanimously approved the acquisition of this property. It's part of the Roaring Fork Management Plan, and I also talked to Tommy Moore and expressed the Board of County Commissioners' thanks to his family and appreciation for them selling this property to us to preserve in perpetuity. And I just ask that the County Commissioners approve this ordinance and this acquisition in the second reading.
Questions of staff at this time? Michael?
That white line map that we see going there, that's the Rio Grande Trail?
Correct.
And is that going to be paved, this portion going to be paved this spring?
That's a question for Lindsay. I'm not sure if it will or won't be. She knows the answer to that, though. I can find that out for you and let you know.
Okay.
Steve?
As I pointed out before, but you can really see it in the photograph, a couple of the other trails. Number one, the one going down along the Roaring Fork River.
Is that the one you mean there?
Well, no, that's the horse trail that goes up from the Roaring Fork River up to the Rio Grande Trail. That's a very good trail, by the way, that one angling up. Then the one going along the river, and then over on the left by the highway, you can see one of the fisherman trails going down. So this property actually has 4 different trails that go through it.
Yeah, it does. And part of this acquisition is to look at the different types of different management that we can do with it, and to improve some of those access areas and some of those trails. Some of those trails obviously are just informal trails, and so to create a better trail that's a little safer is part of the management of purchasing this.
Additional questions or comments at this time? I will open the public hearing on this item. If anybody wishes to speak on this item, they may do so at this time. Seeing none, I will close the public hearing on this item and bring it back to the board.
I would move to approve an ordinance of the Board of County Commissioners, Pickett County, Colorado, authorizing the acquisition of the Moore River parcel.
Second.
We have a motion and a second. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Thank you, Commissioners.
Thank you. Next, we have our land use consent public hearings. We have 2 items that need to be continued. The first is an American Tower Corporation Woody Creek Elam Special Review for Cellular Facility. And this is to be continued to 6/11/14. This is a public hearing. I will open the public hearing for this item at this time. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing, bring it back to the board for a motion to continue.
Can I ask?
Yes.
Lance, why was this continued?
Actually, I requested the applicant to continue it because of the celestial item on the agenda and the anticipation that this meeting could be quite lengthy.
Bless you. That's a little pessimistic.
We'll know soon if he is right.
Steve?
I move to continue this American Tower Corporation item until June 11th.
Second.
First and a second, any discussion? Seeing none, all those in favor say aye.
Aye.
Next is an American Tower Corporation Highway 82 Snowmass Canyon Special Review for Cellular Facility to be continued on to the same date, 6/11/2014. This is a public hearing. Anybody wishing to speak on this item may do so at this time. Seeing none, I will close the public hearing on this item and bring it back to the board for a motion to continue.
So moved.
Second.
We have a first and a second. Any discussion? Seeing none, all those in favor say aye.
Aye.
We are now into our land use public hearing section of our agenda. The first item is a Woody Creek Subdivision Metro District Service Plan, second reading, continued from 5/14/2014. And Lance Clark, I believe, is here to present on this item.
Yes, I will. From the staff perspective, Rhonda Basil is representing the applicant, and I don't see her in the room yet.
Someone's
Perhaps
pointing.
she's on the way, but perhaps not. She does know it's happening, however. But I can start if you would like, or...
Well, I think, Lance, you should give your presentation. She was here to present on our first one. Hopefully she will show up to represent the Metro District.
Can someone give her a quick phone call?
Yeah.
Have it up the top.
925-787.
Well, seeing that we will probably be doing a lot of sitting for the next couple hours, I won't jinx us either there, George, but why don't we take a 10-minute break and come back at 2:40, and hopefully we will have some information as to whether or not she will be here to represent her Metro District at that time. So 2:40, grassroots. Welcome back, everybody. Today is Wednesday, May 28, 2014. This is our regular meeting of the Board of County Commissioners, Pickens County, Colorado, and we are into our land use public hearing section of our agenda. First on that is our Woody Creek Subdivision Metro District Service Plan second reading. And Lance Clark is here to present for the staff.
Yes.
And Rhonda Basil's here to present as a representative of the Metro District. Lance.
So, fairly briefly, since we do have Rhonda here and some residents and homeowners from the Woody Creek subdivision, this is the second reading on a resolution where the board would have the opportunity to approve the Metropolitan District Service Plan that's proposed for the Woody Creek subdivision. This is an application that was brought forward to the Board of County Commissioners by the Homeowners Association Board of Directors. This is an application from the Woody Creek Subdivision Homeowners Association. It's an application to create the Metropolitan Taxing District to help provide a permanent funding mechanism for all of the public improvements that have been added to the Woody Creek subdivision in the past 4 or 5 years, and to continue making those types of public improvements, and to maintain and have a solid funding source for the maintenance of public improvements over the long term. You'll recall that this item goes back actually 5 or 6 years now. When the Woody Creek subdivision was formed, when the Pickens County and the Housing Authority assisted the residents of what was called the Woody Creek Mobile Home Park. When the county assisted them in the process to purchase their own lots and to become homeowners, they undertook a extremely ambitious program of public improvements to upgrade their water system, to upgrade their sewer system, to build all new roads, new street lighting, new drainage, landscaping. It was a tremendous undertaking, and as you'll recall, there were problems in the implementation of that undertaking. There were time delays, there were cost overruns, and the subdivision came to the county seeking assistance of some type to try to complete this obligation that they had made to themselves and their homeowners to create a very viable community, which has happened. What the Board of County Commissioners offered at that time, some years ago, was the board said, we don't really have the ability to give you a cash subsidy or to pay for these improvements ourselves, but we can help you come up with a permanent financing source, and we think that one of those options, and perhaps the best option, would be the creation of a metropolitan taxing district. So the Board of County Commissioners agreed to fund the studies that would be required to create a metro district. Board of County Commissioners retained Rhonda to act as an attorney and as the lead person. Also involved was an economic feasibility study. And the county has funded that over the past 4 or 5 years. It's taken quite a bit of time to get it all together, but it has now come together. It is before you. You did approve it on first reading several weeks ago. This is the second reading. The important thing to have on the record, and for the people from the subdivision are here, is to make it very clear that what the Board of County Commissioners does by approving a service plan is enable the process to go forward if the homeowners desire it to go forward. Your action today, if you were to approve this Metropolitan District Service Plan on second reading, does not create the Metropolitan District, but enables the homeowners to move forward with the next step, which essentially the next important step is to have an election to have their own vote of the property owners in the subdivision, the 58 homeowners, to determine whether or not they want to establish a metropolitan district. And then if they do, they establish their own board of directors for the metropolitan district, and they set their metropolitan district ad valorem tax rate that they feel is required to move forward with funding the improvements that have already been done and the ones that are to be done in the future. And this is all provided for in state statute. There's a specific process. The preparation of the Metropolitan District Service Plan has specific standards in it. It's required to go before the Planning and Zoning Commission to make sure that there's nothing that is being proposed that would run afoul of any comprehensive planning in the county. The Planning Commission did review this on April 1st, and by a 5-0 vote found that it would be appropriate to move this on to the Board of County Commissioners. There are some specific standards that the Board of County Commissioners is to use in making a determination as to whether or not a proposed special district is appropriate. I've outlined what those are in my memo to you. You looked at that at first reading. We feel that those state standards, in this case, have been met, and that it would be appropriate for the Board of County Commissioners to authorize approval of the Woody Creek Subdivision Metropolitan District Service Plan, and we've presented for you the appropriate resolution for your consideration.
Questions of staff at this time? Rhonda, did you want to make a presentation to add to staff's comments? Or?
I won't repeat the presentation that I made at first reading, but I will provide you with a little bit of additional information about some comments that I have received from homeowners since the first reading. First and foremost, I want to let you know that we heard the message from you loud and clear that you were looking to have the Metropolitan District have professional management, and I think that the Homeowners Association has operated for as many years as we are aware of, just on a break-even basis. So I think this is really a good time for them to make that shift to professional management once the district is in place. One of the issues I think that you will hear concerns about today is about the financial feasibility analysis. That is performed to comply with a couple of the criteria under the statute that we have to show that the district is capable of providing economical and sufficient service and the financial ability of the district to provide those services. So the feasibility analysis is sort of a snapshot in time. It is not a budget. It can be amended and changed as we go forward. Two things were included in that financial feasibility analysis that are no longer in play, and one of those was an anticipated $100,000 for completion of the construction. The district was assumed that they would go forward and get a loan in that amount, and the Homeowners Association now has some funds available that they can complete construction with. So that loan is no longer necessary. There was also a $50,000 balance due on a loan to community banks that was for construction cost overruns, and that has been paid off as well. So based on those two amounts, the anticipated mill levy under the financial feasibility analysis would raise an additional about $9,700 a year. Obviously, as the district is formed, that mill levy can be reduced or it can be left in place, and then it's up to the board to decide as it goes forward whether it needs that additional income. But the analysis was done at the time those two expenses were in place. So those are still in place. And again, what the district will provide here is another way for the homeowners to raise funds for their improvements and for their capital reserve fund. Right now, they don't have any ability to tax their homeowners. They can charge annual homeowners association fees or monthly fees. They can charge usage fees for water and sewer use. There are no meters on any of the properties other than the 2 commercial properties out there. So if they wanted to charge expenses based on usage, they would have to install meters on each of the residences. But it's just another opportunity for the homeowners out there to provide a sound financial basis for their infrastructure as they go forward. So that's all I have for you.
Any questions for Rhonda Blas? Okay, this is a public hearing. I will open the public hearing on this item. At this point, anybody wishing to speak on this item may do so at this time. I do believe there's a good handful of homeowners here, so just be considerate of keeping your comments to 3 or 4 minutes. And just state your name for the record as you stand up and
March Henley, homeowner. First, I just want to make a thank you. I have something here that was prepared for me by John Peacock's office, an intern, which is a full spreadsheet of different case scenarios and what each homeowner would owe, which is what we've been asking for 4 years. We've just wanted to know, what was it going to cost everybody? And they were nice enough to provide that, and it's been cut and pasted and available for anybody to look at. It is not a cookie-cutter neighborhood. There is a very wide range of property values, and an assessment situation, it's going to be very lopsided, where 11 homes are going to be responsible for paying the cost of this capital reserve. And it's a big cost. We were paying $160 a month for this $454,000 loan that we had from community banks, and everybody was required to pay it. Now there's 11 of us that are going to be paying that and more per month indefinitely. It goes up in 5 years, it goes up in 9 years, it goes up in 13 years. Basically what we're paying for right now is a utility and capital reserve, which is why I've made this outcry for metered usage. We also asked for 4 years for the Woody Creek Community Center, which is a nonprofit entity, to not be levied the same amount of tax as the tavern. And it was, so we can't do that with the Metro Tax District, can't do that with the Metro Tax District. Finally, all of a sudden, they're in a metered situation with a percentage being added to pay for the capital reserve. And so it would be logical for me to ask, then why can't we do that? Well, if meters cost $2,000, that would be 1 year's worth of taxes for me, not 13 years worth of extra taxes. We're basically paying for a utility. What if we were paying Comcast and gas and electric on our assessed values? So I'm finding that this is not palatable to me and to at least 11 other homeowners, and I would like to request that this be allowed to be put to a vote to the community with a one house, one vote basis before it goes to an election, because it was also described to us at the meeting that we had in April that it was going to be only Colorado registered voters that could vote. So tenants of houses in our owner-occupied area, which is now overrun with tenants, now all those people get to vote, and not all the owners are going to get to vote unless you are a registered voter in the state of Colorado. A tenant who proves his residency and has Colorado voting privileges will be able to vote. And I'll be darned if somebody in a triplex across the street from me gets to tell me what I'm going to pay and they're going to pay less. And I just respectfully, please, beg of you to let it go to a one house, one vote, in community vote before we look at new figures, which will not include the loan and the request for funds to complete the project. Before we see those figures, I would like to get a straw poll vote in an official capacity from our homeowners. Thank you.
Thank you. Anybody else wishing to speak on this item? Up front here.
I just want to thank the county for the support and for
Just
Alex.
state your name for the record.
Peg
Thank you.
O'Brien, Woody Creek. And I'm just here in support of the Met District, having gone through, not speaking to the details. I understand the difficulties there for some, but as a whole, I think the Metro District is very important for our community, for the ongoing financial stability. The precariousness of the last phase is something that this neighborhood does not want to go through again, may not tolerate. So thank you for helping us move this forward.
Anybody else wishing to speak in the back there?
My name's John Edwards, and I'm in support of having the election for the Metro District for the reasons it gives us options for funding future expenses, and I wanted to share that with the commissioners and just appreciate that their process and contribution in this process. So thank you.
Thank you. Anybody else wishing to speak on this item? In the back, in the green.
Gus Phillips, HOA resident and president of the HOA. I appreciate all the work that Rhonda has done on it and the experts that they put into this. Understand that the service plan as it is doesn't exactly reflect our financial situation at the time, at this present time, but we're still in tenuous financial situation that with frugality and common sense, we can work our way through it and improve if Metro District passes, which I am supportive of. Moving forward, we can tweak it. It is a controllable vehicle, as I understand it, that we can tweak it so it fits the community and is a positive means moving forward. And we really appreciate the county's help, staff's help, Rhonda's help, and bringing this to forward. And we'll see how the vote of the community goes, and then how the official vote goes if it moves forward. So as we move forward, we appreciate everybody's work on it.
Thank you. Hi, yes?
Hi, Dan Kenny, 212 Woody Creek Plaza, and I'm pretty much in support of Marsh Henley. I think there's a spreadsheet doesn't really give a lot of us a lot of the information that we need to really make this decision. It's just a set of numbers. What hasn't been really explained to us very well are the reasons behind it, the support of the numbers that are used, et cetera, et cetera. So I think that's one of the reasons why we need an inter-community association vote on this first, so that perhaps it'll give us some time to get further explanations on how the numbers were, how they were come to be. Items such as, I mean, there's a lot of miscommunication. Things have not been communicated with us very well. There was a meeting that was held, I think it was in April, that I wasn't even made aware of. Nobody told me that there was a meeting on a Monday that Rhonda Basil was going to be at the board, that we can listen to. Nobody bothered to tell me about it, and a lot of us didn't get that. So there's a lot of these kind of things that need to be discussed before I'm going to feel comfortable supporting the Metro Tax District. Thank you.
Anybody else wishing to speak on this item? Seeing none, I will close the public hearing on this item and bring it back to the board for further discussion. Anybody have any comments or questions at this time? Rachel?
Yeah. Thank you for your attendance here today, all of you. And I would be the first to acknowledge that it's a mixed neighborhood with different concerns and different issues. However, I really have a pretty stark memory of first getting on this board and having people come in here in desperation over ability to pay the debts and to finish the requirements that were associated with the land use approvals. And just facing a very dire future. And I'm kind of glad to see there's more participation now when there wasn't that level of participation during the construction and the cost overruns and the budgeting problems that began in the past. And I see this formation vote, just having the formation vote, not predicting the outcome, as being a real step in the maturity of the park and a step forward in managing with closer oversight the day-to-day operations and issues. And I'll be the first to say I live at Hunter Creek Condominiums. I don't participate in the homeowners association that much. I accept their decisions as they go down, but I wish I had an ability to take so many of my maintenance fees and upkeep and special assessments for repairs on a 40-year-old building off of my property taxes. And that is one of the key features that a metro district will give every resident who itemizes their taxes across that board. Some residents might not itemize, and they might not have that same benefit that others do. There will be a metro vote, and I'm not going to predetermine or guess the outcome of that. And then there will be a vote for those board of directors. And then there will be direct influence on those board of directors. So there's a chance to refine the budget, to move the budget around, to work towards appropriate service levels. But this will deal with the future financing needs. It creates a deductibility of certain expenses. And I think that one of the most important elements that no one should overlook is that it stabilizes the market for the resale of homes in Woody Creek Mobile Home Park. There has been a tremendous hesitation by anyone to step into the shoes of current sellers or others to invest there because of the uncertainty with the stability of that organization. And I think that stabilizing and having the security of the Metro District and active involvement by all the residents in that district is going to benefit that resale market and all the homeowners in turn. It's a neighborhood in transition, and while there may be 11 who have put in modulars or more expensive homes have higher assessments now, I would predict that in short order there will be more investment and more homes that continue to have those higher values. So the Metro District numbers are just a snapshot in time. They were a snapshot in time when there was a certain debt load. They're a snapshot in time based on today's valuations. There'll be a snapshot in time in the future based on future replacement with different homes. So I'm happy to see this go forward, and I think that it's a community, individualized community discussion at this point to continue to try to reach fairness and balance.
Other comments, Michael?
Yeah, Lance mentioned some history of the park, and I have a fair amount of history with it. One of my first recollections is that the former owner of the park, in order to solve a deficient septic system that served the park, put more dirt on top of the leach field because we were having effluent coming out of the septic system. That was his solution. He got to make it by himself. And he made it without regard to the health of anybody in that park or anybody in the county. And at that point, people decided things could be better. We could own that park. We could be the governance of that park. We wouldn't have to rely on one owner whose judgment dictated covering a deficient septic system with dirt in order to make it look better. So this is part of that maturation process, and it's part of the choices that the park has made about its own governance. And it's not going to be governed by the commissioners. It's not going to be governed by anybody else, by an owner. It's going to be governed by a collection of owners who make those decisions. And people should be thrilled that they have that choice today. Whether they make it or not, that's up to them. But they should be thrilled that the choice of governance is theirs now, not anybody else's.
Steve?
I hope nobody takes any offense, but the first time I drove through that trailer park, I felt like I was in a third world country.
And when I drive through there today, it is so much, I mean, it's so much nicer. The residents there have like pulled themselves up by the bootstraps, really, and, you know, made great improvements to the park, and it's really a lovely neighborhood. You had mentioned the thing about the cost of the water meters, and the town of Snowmass Village just got a grant to put in, I don't know if they metered the whole town of Snowmass Village, but they got a grant, I believe it was through the state, Rachel, it was through the CWC, the Colorado Water Conservation District, Water Board, and I think they got $3,000 per meter in order to install meters. So that would be a way you could actually get meters and not have the homeowners have to pay for them. There are grants out there. And that might be something that you should consider, but well-spoken words by both of you. It's the residents' chance to run, you know, have their elected board to make those decisions, and it's really democracy at the grassroots level at work.
Other commissioner comments, questions? I have a question just for my understanding, and I feel there were good words said by the other commissioners to this point. But I'm just curious, because it was said by someone in the public hearing about the voting of this HOA and how that aligns. I mean, this is going to be a metro tax district if it moves forward with a vote of the HOA. So I guess my question is, how is the voting of the HOA happen in the creation of this? Is it one vote per residence, or is it per unit, or is it, you know, that's the way my HOA votes, or is it as a taxing district, it would be voting residency, I would guess. So potentially you could have, you know, 10, 15 people registered to vote in one bedroom.
There's,
I'm asking, the question is not
but that's not
implying
even
anything.
illegal. So it's a voter fraud type of tidbit, and no, there's maximum occupancies in all residentials.
Okay, well, you could have more than one person per bedroom.
Yes.
As where another one couldn't. So I'm just asking how it's set up with the, as Lance said, that there is a vote, to create this metro district. We are voting to enable them to create the metro district. And then there is a balance of power if the metro district gets created. Part of that balance of power is on the board of directors, I'm assuming, and part of that balance of power is through the residents, voters, through voter registration numbers. I'm just asking, for my knowledge, how it's set up.
So Colorado statutes guides how the election takes place for the formation of a district. Once the court order is issued setting an election time, it's qualified electors who are entitled to vote for the formation of the district. And that means anyone who lives within the boundaries of the district, who is registered to vote, or who owns real property within the district also need to be registered to vote. So yes, you have to be a Colorado registered voter.
So
and it's all guided by statute.
So the first election and the second election are the same voting pool, or no?
Yeah. So Rob, maybe where the confusion came in, if you don't mind me jumping in.
Yeah, please. I'm just
so the recommendation, the recommendation to forward this service plan to the board was made by the HOA board. Okay, so that is the HOA board of directors. There isn't a further vote then. There isn't a further vote either through the HOA or through homeowners. That this would go to a vote then, as Rhonda was explaining, of all registered voters within the proposed district. And I think, you know, one of the concerns that the residents have raised is that, well, there may be a property owner who isn't a registered voter, so they wouldn't be allowed to vote in that election. And I think that's the concern that you're hearing during the public hearing phase. That's governed by state law, and that's no different from
Any taxing district.
any other, electoral process. But for the purposes of this item coming before you, it was forwarded through a vote of the homeowners association at that meeting. I believe it was in April, that was also referred to. And so a majority of the officers on the homeowners association board voted in favor of forwarding this service plan so that a vote of all registered voters within the proposed district could move forward upon your approval.
That explains what I was naive about. So I wasn't trying to imply anything. I was just trying to understand it. Any further questions or comments of commissioners? I will entertain a motion if there is
I
one.
move to approve a resolution of the Board of the County Commissioners of Pitkin County, Colorado, approving the Woody Creek Subdivision Metropolitan District Service Plan.
Second.
We have a first and a second. Any further discussion? Rachel?
Yeah, just briefly, not related to your issue per se, but we will often hear, oh, it's taxation without representation, because I have my second home here and I don't get to vote on the taxes. It's everyone's choice, if they're a U.S. citizen, where they want to register to vote. And you can declare Colorado your home state and register to vote there. And if you're not, for some other reason, I don't understand, other than if you're not a U.S. citizen, how you can have a second home outside the area and the affordable housing. But it is someone's choice as to where they choose to register to vote and declare their residence. And secondly, the question of whether you have to own property to vote was settled way back in the formation of this country. The taxes that will be levied by a metro district would be passed along to a renter-tenant, just as they would to a property owner. And it is in their interest to be able to vote on service plans, whether it's up at the base of Highlands or at Aspen Village or anywhere else. And that question was settled a long time ago. You do not need to be a property owner to vote in an area where taxes will be passed along to you, or directly or indirectly, even if you don't own the property.
Any further discussion? See none, I'll call the question. All those in favor say aye.
Aye.
Aye. Opposed? None.
Thank you.
Thank you.
Okay. I'm just going to use the restroom while they set up. They're going to need much time, but the room's going to clear. I'll be back.
Okay, while we have a little transition here, let's take a 10-minute break. That would be 3:23. And if the applicants can come to the front and start their setup at this time.
Lance, are you sticking around for this? Or do you want me to?
Thank you.
Oh, you're welcome.
Okay, welcome everybody back. Today is Wednesday, May 28, 2014. This is our regular meeting, Board of County Commissioners, Pickens County, Colorado. Making sure everyone's in the right place. We are on our last agenda item before open discussion and adjournment. Our last agenda item is the Celestial Land Company LTD activity envelope, site plan review, special review, and GMQS exemption modification of hearing officer's determination. We have had a couple of discussions in the last couple of weeks as to the process of this re-examination of modification of the hearing officers after an appeal. This was sent back to the BOCC for the BOCC's decision and a rehearing of information previously gathered and submitted. In the previous weeks, we have, and apologize, I'm just kind of putting all this a little bit together in my mind as I'm going. Being the chair of this meeting is a little challenging, so and my first time being chair on the BOCC. We have had some discussions as to the protocol of this hearing through the advice of our attorney's office. We do realize that we have a little bit of leeway, and we have set out some guidelines for this meeting. As chair of the Board of County Commissioner right now, I have set up a guideline for how this is going to be, and really my determination has been that we will follow the public hearing process as has always been stated on our wall, with one slight adjustment given the fact that we are in this position because of a upholding of an appeal by a group of neighbors. So the hearing shall go as follows, and I will point out what I consider the slight amendment to the procedure that's up on the wall. We will have a staff presentation. We'll have questions from the BOCC on the staff presentation. We will have a Celestial or the applicant's presentation. We will have questions from the BOCC of the applicant's presentation. At that point, we will open the public hearing. Here's where I am making a slight amendment to our normal agenda because we are in this position primarily because of an upholding of an appeal of a neighbors group. The neighbors group will be permitted to make a presentation as part of their public hearing. We are hoping that they can keep that presentation to hopefully not a lot longer than 30 minutes. We will also hear they may have a few people present during that presentation. We will also hear from other public during that public hearing process. At that point, we will have an opportunity for Celestial to comment on the public hearing process. This is also a adjustment, and it's an adjustment based on giving that neighbor group that half an hour time frame to make a additional presentation that normally wouldn't be part of the public hearing. We will have we will then bring it back to the board for deliberation and discussion on the board, perhaps additional questions at that time, and then we will I'm sorry, I guess before that we will close the public hearing, and then we will bring it back to the board and have a discussion and hopefully a determination at that time. I will ask the board at this time if there's any questions or comments on my agenda for this hearing. George.
Did you accept the motion?
Okay.
It's going to be a long afternoon.
Yeah, I know.
I'll just restate for the record that I thought we should have a longer time from all involved and just hear it if it takes till midnight, but that's just me.
And of course, as chair, there will be some leeway in terms of presentation, additional questions from board members of presenters regarding additional information that they may need, whether it be from someone in the public or an expert, some sort of expert witness that may, or expert on a field in the public, and we'll go from there. Because that will allow for additional time in terms of making sure that we get the information. If you feel that there's something that you haven't heard fully, certainly ask the question to the individual,
Okay.
and I will allow for leeway along those lines.
Thank you.
With that said, the staff presentation, and Suzanne is going to, is it you that's going to be giving the staff presentation?
It's me. So I think you laid the scene for the request in front of you. It was regards the Celestial Land Company limited activity envelope and site plan review, special review and GMQS exemption for TDR receiver site, modification of hearing officer determination 04/2013. I think I don't need to go through all the background that's in the memo, and I think you've heard it a few times now. But the most recent action by the board was upholding the appeal pursuant to resolution 026/2014, and it was found to be appropriate pursuant to the land use code for the board to consider this to modify the hearing officer determination based on the code at a duly noticed public hearing, which is what is happening today. That allows the BOCC to consider the application in its entirety and hear testimony and argument with regard to the application without being limited to the prior record upon which the hearing officer determination was based, which was the case during the appeal hearings. So that's what brings this before you today. Additional information was submitted by both Celestial and the applicants. That was included in your packet for today. All of the prior information that's been submitted throughout the review of this back to 2009 is considered a part of this record. So this is basically a continuation of the original application that was submitted back in, I think, February of 2009. For the review for today's hearing, we've essentially limited our review to the additional information that was submitted into the record in April, and looked at it as how that would affect the determination that was made by the hearing officer. So we kind of used that as our base, finding that a lot of the findings made in that determination satisfied the provisions of the code, but wanted to look at it in terms of the new information that had been submitted. There were a couple of conditions in that hearing officer determination that were basically addressed bringing the site plan into compliance with the code, and those primarily related to location of improvements in the red avalanche hazard zone and on slopes greater than 45%. So in terms of the avalanche hazard zone, the applicant did revise the site plan and all the mitigation features in order to site them all outside of the red zone. So there would be no improvements or mitigation in the red zone. This does still include mitigation measures that were seen in the original or in the prior application, including an avalanche protection wall and an avalanche trench. I think looking at some of the maps today, and I'm sure you'll see that more as the applicant goes through their presentation, where those are located. We can talk a lot about that on the site today as well. So I think you have a sense of the mitigation measures that are proposed. The applicant, or the neighbors in their information that they'd submitted, have proposed that development is proposed within the highest impact portions of the avalanche blue zone, adjacent to that red blue zone boundary. I think everybody agrees that development will occur on this site within the blue zone, that it cannot be avoided within the blue zone, but a debate about sort of that proximity to the red and blue zone and where is the most appropriate location. In the findings in the hearing officer determination, excuse me, I'm afraid I'll do that a lot because unfortunately my voice isn't great today. The hearing officer had found that obviously there are multiple hazards that affect here, had to look at how you weigh those out in terms of avalanche hazard and debris flow. Felt that the avalanche hazard only affects this property in terms of actual, when you look at those mapped areas, they do not extend onto the adjacent properties, they're only on this property. The debris flow hazard does extend onto other properties. So whereas avalanche might be more of a hazard to life and safety, it's only impacting the people on this site, whereas the debris flow also affects users of the adjacent properties. So that was one of the important findings I think he felt in terms of looking at the mitigation of the avalanche hazard and the debris flow. In the language in the code regarding development within the blue zone, it does say development shall be restricted to the least hazardous area of a project site. When you look at the definition of the blue zone in the definitions of the code, it says avalanche frequency and impact pressures decrease toward the outer limits of this zone. When large avalanches occur and run to the boundaries of the zone, they can be very destructive in spite of their reduced probability and pressures. So the way we've looked at that language is that it's very difficult to determine what's less hazardous. And there is a hazard throughout the blue zone, and I think that is substantiated through the comments from the Colorado Geological Survey. It's very difficult to make that measurement about where is it less hazardous. It is hazardous throughout the blue zone, and mitigation is required throughout the blue zone. So I think that language in the code supports that there is a hazard. It is, the avalanche can be destructive even out to the edge of the blue zone that's away from the red zone. There's a hazard throughout there. So staff had supported the findings that had been made by the hearing officer with regard to the avalanche hazard. The applicant did respond to the condition requiring elimination of development from the red zone, and no development would occur in that area. With regard to the steep slopes I mentioned, it appears that there is still some grading that extends up into areas that are on slopes of greater than 45%. That would have to be reworked to avoid those areas. And again, the activity envelope amended accordingly, but those have been incorporated in the draft conditions of approval. The proposed debris flow mitigation on the site plan was also revised based on the changes to avoid the red avalanche hazard zone. It did affect shifting some of those mitigation measures, but again, the mitigation is similar to what had been previously proposed and approved by the hearing officer, including that debris and avalanche protection wall, the avalanche trough, and the debris basin. Again, all of those were things that we looked at on site today. The neighbors in their submittal assert that the proposal does not avoid the source of the debris flow hazards to the maximum extent possible. They proposed the alternative site, again, that they can present to you on the site, which they feel has less of a hazard. Again, from the hearing officer findings about the alluvial fan hazard, mitigation would be required anywhere on this fan. It says, while it may seem to be common sense to locate development as far from the apex of the fan as possible, there's no evidence of any standards for making this determination or quantification of relative risk and risk reduction away from the proposed site. The alternative site, and again, that statement, there was a different alternative site that was originally proposed by the applicant. What they proposed in the April materials is in a slightly different location and a refinement of the alternative site they had previously submitted. So just to be clear that the alternative site that had been seen by the hearing officer is different than the one you are seeing today, and has not been shown to represent a material improvement of any over the proposed site. As with the avalanche hazard and consistent with prior conclusions, Karen Berry with the Colorado Geological Survey continues to assert that the proposed development and mitigation is feasible, with obviously further design level drawings at the time before they come in for a building permit. For the special review for TDR receiver site, some of the new information presented by the applicant provided a depiction of a 13,250 square foot house as requested, an 8,250 square foot house to provide a comparison of the two and the impacts and the siting. I'm sure that's part of their presentation, so I'll let them cover that base. The neighbors continue to argue that it's not appropriate to land additional TDRs on this site, not consistent with the special review criteria regarding avoidance, where they said their statements about the special review were that hazard areas have not been avoided to the extent practical, development will endanger the public health, safety, or welfare, and development is not in harmony with the surrounding area. Staff, based on, again, some of those findings from the hearing officer, we felt that those findings, we supported those findings, and that this was consistent with the special review criteria in the code. The neighbors raised a question about whether the 2002 and 2006 approvals are still in effect. They asserted that the prior approvals for use of 2 TDRs to establish the initial development right of up to 8,250 square feet were issued in error because the avalanche hazard was not considered at that time and should be revoked. Staff does not agree with that position. Even though the avalanche hazard was not considered during the prior reviews, the originally approved building envelope did contain was within both the blue and red avalanche zones based on the current mapping we've been provided, but the current development proposal does comply with the code by avoiding the red hazard zone and mitigating for development in the blue zone, which is what is allowed by the code. So we don't feel that that really has a basis for revocation of those prior approvals. That issue has been addressed as part of the current application. I think that's it for our presentation. So we recommended approval. We've provided additional conditions of approval that would supplement the findings and conditions of the hearing officer determination. And that's it for you.
Questions?
Yeah,
George?
thanks, Suzanne. So it sounds like what we're going to be talking about today is location, hazards, and size. My question is regarding size. So one of your last points in terms of special review for TDR receiver site, your memo states that I'll put in quotes, and is compatible with the character of the immediate vicinity and in harmony with the surrounding area in terms of utilizing the 3 TDRs. So when you look at the compatibility with the character of the immediate vicinity, are we talking about Buckley Drive and the homes right along there? And I'm just trying to get a sense in terms of how you view the compatibility with the other homes nearby. I mean, you look at size, you look at, how do you determine that?
I've looked more broadly than just Buckley Road, in terms of just right there. I mean, this is a small area in terms of sort of the residential development up Maroon Creek Road that's beyond Highlands, essentially. So I think that's what forms the basis of the surrounding area here. We did look at size in terms of just, pure house size. Obviously, the neighboring house is the largest in the area. And that was approximately 13,000 square feet. The others aren't as large if you go around the area, which is not to say that they don't have the potential, to go through the process to be larger. But that's also limited just to pure size. The applicants actually, I think in their presentation, the hearing officer provided a lot of evidence in terms of looking more broadly at what is the impact, how much area is disturbed, other pieces like that to look at that broader piece. And again, I guess that was mostly a comparison with the adjacent, directly adjacent property. But if you look purely at size, in my prior memo, I had said, basically we're in a range of 2,200 to 7,500 heated square feet, again using assessor records. And again, that's that broader neighborhood area, not just the directly adjacent properties. And then the one house at 13,000 square feet.
Okay, thank you.
Rachel.
Yeah, but just to follow up on that, Suzanne, all the lots in the area would be entitled to the 5750, and all the lots in that neighborhood have a potential through TDR acquisition to go to
15,000 square feet. The zoning would allow 15,000 square feet. So through the use of TDRs, through asking a special review request for TDRs or competing in growth management, the zoning, allows potentially up to 15,000 square feet.
Has there been requests from that neighborhood area to institute a downzoning by this board to eliminate that potential or create some sort of cap of 8,200?
There was not, I mean, at this point, we're going back to the master plan that was adopted in 2003, which is the most current master plan for the area. And they did not at that time recommend a cap, as did other, caucus areas at that time. The master plan does include language regarding, when TDRs and what to look at. I mean, it seemed like one of the primary concerns was visual impact from the public roads for the Castle-Marin area.
Okay, thank you.
Other questions from the board?
I have one more, but, although it varies from those three topics George had put out. One of the building materials is zinc, and I was just wondering, does that meet our non-reflectivity code for roofing materials and siding materials? And does it have its own kind of low light, even without reflecting? I mean, does it?
I don't think I can answer that question. I don't know if
We'll be happy to respond to that.
Okay, thank you.
My question, I guess, is from John Ely, because I don't fully understand it, but in our email packet, hopefully every commissioner got it, we got a motion to strike the hearing officer's determination filed by the neighboring group, and I'm just curious as to how that might affect this hearing today, or what. I mean, really what they're talking about is not using any of the hearing officer's determinations as evidence or part of the review process, or...
Well, it could affect the conduct of the hearing if the board rules favorably in response to the request. The striking of the hearing officer's decision would certainly change the ability to generate an ultimate decision probably today. It's up to the board, Rob, when you want to consider this matter, you might want to consider it up front just to resolve it, or wait until to these particular individual neighbor representatives want to present that to you. We need to resolve it at some point today. I know that I received it by hand delivery yesterday. I'm not sure if the applicant has received it. I haven't seen a response from that side of the table.
So it's something that we would take determination on as a board as to whether or not we uphold this motion or not uphold this motion?
Yeah.
And then proceed accordingly based on the information that we're considering in our decision. So, I mean, it seems to me like that decision should be made up front. I don't know where the rest of the board stands on that.
I would agree with making the decision, but I'm curious as to when did the applicants get a chance to respond, and have they seen that request?
I don't know.
You have to ask the applicant.
Yeah.
Well, as John Ely pointed out, it was tendered at the 11th hour, and we received it at the 11th hour plus some, and we certainly have a response to it as part of our presentation, but we were not in a position to make a formal response in advance of this hearing, to the hearing.
So I suppose...
And obviously we object.
So I would propose to the board to address that motion directly at, yes?
I might have missed that. I don't know if I received it.
It came in by email last night. I know I forwarded it to John because I didn't see his name on the email list, but...
So I don't think I ever saw it.
John, your advice?
It seems logical to me to deal with it up front and get it resolved and move forward with the hearing.
We need that back.
In a manner appropriate with the board's decision.
Okay.
Maybe for the public's benefit, and George as well, John could outline the nature of the request, the legal grounds or standing to make such a motion, and, you know, have we ever seen things like that before, or, you know, process. Where are we? What are we? What's the request?
The request has been made by the representatives for the Roaring Fork Land and Cattle Company, the Bruce E. Carlson Trust, the James Bulkley Family Trust, and JM Skyways, Inc. And the request is directed to the BOCC, that reference to and the hearing officer's determination itself be stricken from the record of consideration by the BOCC. The request, I think, better speaks for itself than I could recap. Occasionally we do receive requests to include items or to limit the inclusion of items into the record. It's not frequent by any means, but occasionally they do come up. Have to deal with it.
So, John, I'm assuming that my interpretation of this request, and correct me if I'm wrong, is to not take into consideration the hearing officer's determination, but could that be potentially just limited to the determination, not the evidence around the hearing officer, in the sense that the reason we're here is because we have found that there was a conflict of interest with the hearing officer, and that the determination needs to be readdressed. But it doesn't really, I mean, I would say it doesn't really say as to the findings of the information around the hearing officers.
Yes, it seems to me to be fairly worded to address the determination itself and reference to and utilization of that determination later in Suzanne's memo, and not in regards to the proceedings in front of the hearing officer. So the information deduced and produced at that time.
So I would propose to the board, which is what I think we're basically doing here with rehearing this, is to disregard the hearing officer's final decision, but not necessarily disregard information around the hearing officer's procedure of information within this application.
That's the request. It does make it somewhat cumbersome in the fact that we are here, as Suzanne went over in response to an appeal filed by a neighborhood group, as we loosely referred to those four parties that I mentioned in regard to this motion, so to speak. The application that is in front of the board and before the county for ultimate determination is the amended application that was filed 2012 off of an original application filed in 2009. Upon the determination of the appeal by the BOCC determined that the next step, rather than remanding it, the issue and the application back to the hearing officer, or simply reversing the action of the hearing officer, which would in effect take it back to the hearing officer for additional proceedings, would be, given the fact that this application has already been through two different hearing officers, that the BOCC would maintain control of the application and determine whether or not to modify the decision of the hearing officer. And if so, if the modification is appropriate, how to modify it. So to strike the actual decision of the hearing officer seems a bit incongruous with the request, given that that's our point of departure, at least for this point of the meeting. Not only does the board get to rely upon the record of the previous proceedings, but we are, in effect, based on the board's decision at the appeal, building off of that and going forward. So to not reference the actual decision or to limit Suzanne from referring to it particularly would build in, I think, just excessive time on an already protracted application process, where we would Suzanne would rework her recommendation rather than relating it to the previous hearing officer determination to just come up with a new proposed resolution for the board to consider. To me, I think that the board can entertain argument and comments from the opposers, neighborhood group, if you will, or anybody who wants to present public comment as to why or why not the board should rely upon the hearing officer, or why not the hearing officer determination was well founded in the evidence presented, and the board can make a determination and go forward. But to twist too long on whether or not to exclude the actual hearing officer determination, to me, seems just a fruitless exercise.
George.
This is all part of the public record, and if, for instance, this moves on if we have a determination at this level, if this moves on to a different level vis-a-vis a lawsuit in the court, they will then still take into account the entire record.
The court will review the record as produced for it on review. If the parties agree that the 2009 application and hearing officer determination is not germane or relevant to the ultimate resolution of the application, and that might not go to the court, for example. But my guess would be that it all is going to go over to the court.
And so when we normally get in any land use applications, recommendations starting from the P&Z up to staff, we then still, I believe, as we listen to the presentations, I believe we still take an impartial view, and many times we have modified or changed or not agreed with either P&Z's position or staff's position. So this is really no different than that.
Correct.
Okay, thank you.
So the question goes to the board whether or not we want to uphold or deny the motion to strike the hearing officer's determination.
You may, Rob, want to afford the parties, at least the representatives of the parties who filed the motion and the applicants an opportunity to address the board briefly. Given that there might be something that they want to point out that has not been part of this dialogue. And you
Okay.
can fold that into their presentation or
Well, I'd like to have a determination of this before we get into the presentations,
Right.
would be my preference. Right. So I would I'd like to have a 2-minute explanation from Glenn Horn, who presented this, or his representative, and then a rebuttal from the applicant on this determination, on this motion.
2 minutes? Okay.
2.5.
Not a problem.
We've read the determination, we've read the motion, so, you know, reading it again isn't going to help us much.
I'll keep it as brief as possible. Mark Hamilton, Holland and Hart, attorney representative for the neighbor group. First of all, we apologize for the timing. We agreed this came in, it was filed yesterday morning. It was emailed to the applicant team promptly after the hand delivery to the county, but we acknowledge that occurred just a little over 24 hours ago. The staff report was not received until Friday at 9 a.m. and that's really where we had an opportunity to read the proposed resolution and the staff's recommendation to the board, and had significant question about the relying on Tom Smith's decision as sort of a starting point and looking forward. The resolution that your board issued coming out of the conflict of interest discussion talks about not being limited to the prior record, which, as I think John said a minute ago, would take us back to 2009. And the staff report and the resolution seem to just be a checklist on whether Tom Smith was right or wrong on various points, or whether they should be modified. In a case where conflict of interest is the reason for the granting of the appeal, we think it's inappropriate for the board and improper for the board to rely on either we're not questioning the evidence that was submitted to Tom Smith, the exhibits, the transcripts. There's no request that your board ignore that information. What we're simply asking would be that the board engage in a decision-making process today that is based on its own weighing of the facts as applied to the code, and not, as John Ely mentioned a minute ago, relying upon Tom Smith doing that, because that process was invalidated for conflict of interest. And so, anyway, there was no, the last point is just simply there was no ruling out of the neighbor's appeal on the substantive issues. Those substantive issues are all still alive. And rather than refer this to a hearing officer to determine those, which could then be appealed back to you, your resolution directed that, in our view, that you would serve as the fact finder. We have not objected to your serving in that role, but we'd ask that you act as a fact finder and not as an appeal body, which would be along the lines of reviewing the propriety of Tom Smith's decision making. Thank you.
Mr. Rittner, may I?
Yes, please.
Mr. Chairman. John Fagnani on behalf of Celestial Land Company. The motion is a very interesting one for a number of reasons. Number one, it's been offered the day before the hearing. We've had no opportunity, obviously, to respond to it formally. Number two, it attacks the very fundamental premise of this hearing. Number three, it does not cite completely to or quote completely from the resolution that you decided in February of this year. And number four, it simply is wrong-headed, because in that resolution you specifically tie the effort here today to a section of the code that refers to the modification of a hearing officer's determination. So if you go back to the resolution that you issued in February, that resolution says, and I quote, "Now therefore be it resolved by the BOCC that it hereby upholds the neighbor's appeal of hearing officer determination number 04/2013 and determines that it is appropriate pursuant to section 2-20-180H1 of the code for the BOCC to modify the decision based on the applicable provisions of the land use code at a duly notified notice public hearing, at which time the BOCC can consider the application in its entirety and hear testimony and argument with regard to the application without being limited to the prior record." It says nowhere you're going to eliminate the prior record, first of all, but that you can take additional testimony on top of the prior record and then deal with the application in its entirety. But the resolution does not make one reference to the modification of the hearing officer's determination that's specifically referenced in the resolution. The motion makes no reference to the modification of the order. And if you go back and you look at section 2-20-180H, it refers specifically to the modification of an order or a decision that's been issued by the hearing officer. That's the fundamental premise of this hearing, and that's the legal basis for this hearing. And to attack this the day before the hearing seems unconscionable. That ship has sailed. This resolution was issued 3 months ago. The other thing is it's quite clear, number one, that the recusal basis for the grant of the appeal with regard to Tom Smith's determination was not tied at all to the substantive issues. There's no indication that he made a wrong decision on the substantive issues. But more importantly, the staff has already made a decision on the substantive issues, and it didn't tie its decision to his determination. The staff's told us before that we can't develop in the red zone. The staff has told us before we can't develop on 45-degree slopes. So the fact that they referred to the determination, I don't think somehow is a fatal flaw for the recommendation.
Thank you. So my thought process is, and we'll see if the board agrees with this, is that our being here today is in fact a modification of the hearing officer's determination. Therefore, taking the hearing officer's determination out of this completely is kind of not all that doable, and I would move to deny the motion to strike the hearing officer's determination at this point.
I would agree. Do we have to have a motion on this, or?
You're not really striking the,
I'm-
going the other direction.
I'm denying this motion,
Do we
is
need
what
a-
I'm doing.
Do we need a motion or just a discussion?
Well,
You need
the
something for the
motion makes
record.
it a clean decision point for the board, and that's
Okay,
an
so you
appropriate
made
way
it.
to affect the decision.
Michael.
I'd like to have some advice from our attorney and executive.
Okay, we have I will table my motion at this point, and we have a motion from Michael to go into executive session.
Second.
We have a second. Any discussion?
This would, excuse me,
Pursuant to-
just to insert, this would be pursuant to CRS 24-64024B, the consultation with counsel in regard to this particular issue.
We have a first and a second. All those in favor say aye.
Aye.
So why don't you tell the audience what you're going into this?
Yeah, so we're going into, thank you, Michael. We're going into an executive session. I don't propose that it'll be that long, probably 10, maybe 15 minutes. We have a room that we can adjourn to here, so you guys can all stay in this room. Apologize for this brief delay, I guess.
It's going to be a lot easier.
Back, everybody. We're continuing our regular meeting Wednesday, May 28th, 2014. We're in our celestial land redetermination of the hearing officer's determination. We had just had an executive session, and I had tabled a motion, and I'd like to bring back that motion. I make a motion to deny the motion to strike the hearing officer's determination as presented by the Bulkley Family Trust, the JM Skyways Inc., Bruce E. Carlson Trust, and the Roaring Fork Land and Cattle Company.
I'll second it.
We have a motion and a second. Is there any further discussion? Michael?
Yeah, I'd rather continue this and have the parties look at this. It's not usual for us to get motions in these here. In fact, I don't think I've had one since I've been here. So I would need more time for myself and more time for the parties involved. I'm not going to make a motion for continuance, but that's my preference. And I just the difficulty of this hearing is compounded by this request for a motion. And I guess I'm hoping for a more direct hearing than we've had already. I mean, we're 45 minutes into it. And I think the engine started, but I'm not sure. So it's tough for me.
George?
I would just say we sit here as a quasi-judicial board, and I think at this point we may, if we don't hear this application today, and perhaps hopefully make a determination, we may see additional motions that one may see in a court. And because of that, I think the ruling that we made to get to this point in terms of looking at the ability to modify the hearing officer's hearing does not taint me, certainly, at all, and I'm sure it doesn't taint the rest of the board to be able to hear and make a judgment impartially. So with that, I would support moving forward on this presentation, and as I seconded the motion to deny.
Further discussion?
Well, I actually am kind of more in Michael's camp. This is a very unusual process, and I frequently like to have a written staff analysis of things like this and how they would weigh our options and prerogatives and things like that. And this really just seems very much on the fly. I really only looked at it last night at about 9 p.m. when I checked my email, and so it's kind of surprising to see something new. I forwarded it to John Ely just because I didn't see his name on the forward list. I'm sure others did as well, but it wasn't even 24 hours ago, and that, to me, that is a process flaw.
I'll say my piece. I believe that we're in this position because we had decided as a board that the hearing officer had a conflict of interest and remanded this back to the BOCC for a modification or re-examination of all the findings. In essence, we are looking at the hearing officer's information and determination with that in mind. So, in essence, we're kind of doing that in the sense that we didn't potentially 100% agree because of that conflict of interest. So, with that, I feel that the last-minute motion to strike the hearing officer's determination doesn't really play merit on my decision-making. That's my thought process moving forward. So, and I don't know, Steve, if you want to say anything. We're in discussion. We have a motion and a second on the table.
I would agree with your viewpoint, Rob, in the sense that, you know, I could actually take hearing officer's decision as, you know, consider it, and then in relation to other things, I would have much rather had the staff resolution written, not continually referring back to the hearing officer's determination, but just putting out the fact that staff says, you know, staff says this, staff says that, instead of the hearing officer, we're doing it different than the hearing officer. And that might be the ultimate resolution, as we decide, you know, we have to rewrite the resolution in different wording. I am concerned that if we proceed without dealing with this motion and giving the applicant time to respond to it, that this could end up tainting this whole proceeding that we're going through now, and maybe that's would make us do it all over again if we don't do this right legally, because the request from the neighbors group did refer to different court rulings along similar cases. So
the motion on the table right now is to deny the motion to strike the hearing officer's determination, which would, in essence, I think, be in line with the preference of the applicant. If that motion fails, then we can decide how to move forward, but the applicant, if the motion passes, the applicant doesn't necessarily need to respond to that, in the sense that I think that's the outcome that the applicant wants, given their 2.5 minute presentation. George.
I hate to prolong this, but one of your last statements, Steve, I wanted to have John comment on, because you said that it could be contested legally, because we may be tainted. I don't want to put words in your mouth, but something I heard raise a red flag that didn't make sense to me, so I just wanted John to respond. If you could just perhaps just tell John just what you just said.
Well, I think what Steve was saying was that we have not given the applicant a chance to respond to this. Would that open us up to some sort of legal battle?
And I also inferred from Steve's comments that the action of the board in addressing this matter currently, as opposed to delaying consideration for a more thoughtful response, might invite error into the decision of the board, and by implication taint the rest of the proceeding in review of this recommendation as put forward by staff. And that's certainly possible. I think the board is going to be confronted with a series of decision points. The most fundamental, I suppose, is the location of the building envelope and the size of the structure that will be put there. However, to get there, you'll certainly be confronted with other decisions to make. For example, this one. And every one of those decision points and every action that the board takes will be available for review and comment and determination and other actions appropriate by a court of competent jurisdiction. And so that is a consequence of being where we are and doing this particular job.
And we can't really limit the potential that future motions of whatever nature may come before us if we continue this process.
There may be subsequent requests for additional items, and they may come as presented in this written format or simply verbally in the conduct of the presentations in front of the board.
So, any further discussion from the board? Michael?
Well, I agree that that it needs consideration more than what we're giving it here. And I agree that that the applicant and their representatives needs to look at this motion. So I'm not sure I would support the motion as it stands now.
Mr. Chair?
Yes. Briefly. I guess the question is, does the applicant need to respond to this motion before we take a vote on the motion that's on the table, which
The
is...
applicant has responded to the motion and said that they believe the motion is without any merit. On the other hand, it is a terrible and destructive delaying tactic to turn something in that creates this kind of deliberation at the 11th hour. And it could happen again if we postpone. I will tell you that we will tell you everything about this project that makes us feel that you should approve it. And that the opponents will tell you everything about this project that makes you feel that you shouldn't approve it. And based on that, you will come to a conclusion. And actually, I don't really care how much the prior hearing officer's determination is introduced. We certainly have it as a fact that twice this board has approved this building envelope, and twice the hearing officer has approved this building envelope and the associated TDRs. But beyond that, you're going to listen to the facts from us, you're going to listen to the facts from them, and as Commissioner Newman pointed out, you're going to make your own determination. So I would hope that we can simply move forward on this, because we've got a bunch of people assembled here, and it's really unfortunate to feel that we needed to postpone it at this time.
Okay, we have a motion and a second on the table. I'd like to call the question. All those in favor say aye.
Aye.
All those opposed? Michael? Motion carries to deny the motion to strike the hearing officer's determination as presented by the neighboring group last night.
So, Rob?
Yes, Michael?
Can we define, are we going to accept motions, or are we going to accept requests? What exactly is going to govern this proceeding going forward? I mean, this was very unusual. Are we going to continue to do this?
At this point, the process that I'm going to follow is the process that was outlined to the parties involved and outlined at the beginning of this meeting regarding a public hearing application process, which is staff presentation. This arose during a question to staff regarding an email that was sent last night. After we finish with questions to staff, we'll have the celestial presentation, questions to them, the public hearing, the opportunity for rebuttal, the deliberation by the BOCC, the closing of the public hearing, and the hopefully a determination of some sort.
Okay, so the way you've outlined it is that this is going to be a public hearing, and that we really, part of that public hearing is going to be listening to requests. Is that what you're saying, or no?
Part of that public hearing will be public comment. So there potentially will be requests, as there always are during public comment, to do one thing or another. So at this point, we are at the questions of staff, given the presentation, or our legal counsel, or anything else at this time. Seeing none, we will move on to the presentation by the applicant. And Stan Clausen is here to present for the applicant, and take it away.
Thank you, sir. For the record, Stan Clausen Associates, representing the applicant. I think the main issues before this board are based in the land use code and based in your own desire to have public health and safety as a paramount consideration. So the main questions that you're going to be wanting to answer are, is this a safer site? And does this application meet the code? Is there a safer site than the one we're proposing? And does this application meet the code? And in doing that, particularly with reference to the code, you're going to look at code for avalanche, and alluvial fan and debris flow, and probably for visibility relative to portions of the master plan with respect to the TDR request and the architecture. So the three key portions of the code are for avalanche, alluvial fan and debris flow, and the TDR receiver site. And we believe in each case those conditions are met, and I'll go through them. With respect to avalanche, moderate hazard development within a moderate hazard avalanche zone may be permitted under the following circumstances. If an entire property is affected by the moderate hazard avalanche zone, development may be permitted if the hazard can be adequately mitigated to ensure public safety, pursuant to standards in subsection 3, and I'll come to subsection 3 in a moment. In event that development outside of the moderate hazard zone will result in significant incursions or impacts on constrained areas, the county may approve such development with adequate mitigation measures to ensure the safety of the occupants. And finally, the third section here under avalanche, if the county finds that other hazards are present on a property outweigh the risks associated with development in the moderate hazard avalanche zone, the county may, in its discretion, grant approval to such a project, subject to compliance with the mitigation measures specified in subsection 3. And here it is. Subsection 3 says, development shall be restricted to the least hazardous area of a project site. And we will show you why we believe that the proposed location is in fact the least hazardous area. If structural avalanche defenses are required to protect people or structures, they shall be designed by a certified professional engineer licensed in the state of Colorado to withstand avalanche impact forces. And we have a team of certified professional engineers and experts to do that. And by the way, with respect to number B, or letter B, it doesn't say a consensus of engineers or a group of engineers debating the issue. It just says, if a certified professional engineer comes to you or comes to the county with an appropriate design that he is prepared or she is prepared to put their stamp on, that is sufficient within the land use code. There are other provisions, clear cutting or other large-scale removal of vegetation, which is not occurring. There are no extractive operations. Utility lines would, of course, be underground, and roads would be protected. Warning signs could be placed, not actually essential in this case. And finally, the property owner shall bear the cost of any avalanche control measures that are required. This is what your code says needs to happen, and we believe you'll be seeing as our presentation unfolds. This is exactly what is being presented in our site. Now the next one is the alluvial fan and debris flow hazard. If there is no hazard-free area on the site, development may continue because, and before I go on to that, I want to say that I think there is agreement among everyone, including the opponents, that there is not a hazard-free area on the site. Development is located and designed in accordance with a site evaluation recommendation of a qualified professional engineer licensed in the state of Colorado. Again, not a team, not a consensus, but if an engineer comes forward and says, we've analyzed this, here is our analysis, here is our remediation and mitigation, that is what the code says is sufficient. Is protected by channelizing, damming, or diverting potential mud or debris flow, utilizing engineering structures designed by a professional engineer, etc., licensed in the state of Colorado. And that is, of course, what is presented as part of our application and was shown to you as part of your site visit earlier. And avoids disturbance, the final thing is avoids disturbance in the drainage basin above the fan and we all saw where the initiation of the fan was, and that this certainly is nowhere near providing any disturbance in the drainage basin above the fan. So these provisions of the land use code are met. Now, with respect to criteria for receiving sites, very clear. When used to increase the base maximum floor area, which is the purpose of a TDR in this respect, any receiving site can't exceed the maximum size for structures in the zone district. And you heard Suzanne's testimony that the zone district allows 15,000 square foot houses. Additional floor area shall not be available in any receiving site where the underlying zone district contains a floor area ratio restriction. And that is not the case here. So from the standpoint of criteria for a receiving site, and it's all presented here, we meet the criteria. The other criterion is something that can be taken from the master plan itself, which is an issue of visibility and whether there is a visible impact for the development. While that's not directly in the land use code, that is part of the master plan, and we'll show you that visibility is not significantly impacted by this request for TDRs. With respect to site plan and activity envelope, 701050B, which we think is the key provision here, Celestial has met the requirement that an applicant minimize impacts on surrounding properties. Not only will we minimize the impacts on surrounding properties, but the mitigation proposed will actually improve the condition with respect to impacts on surrounding properties, and maximize compliance with the requirements of the development standards and comprehensive plan goals. Yes, this will occur. Now, the opponents have postulated 70-10-60, priorities in locating activity or development. And if you read this section of the code, basically it says, well, if you can't comply with the land use code, then you're going to have to minimize or move or do something special to reduce the proposed development. But I want to emphasize those words that are underlined here. When the property contains constrained areas where proposed activity or development could not comply with this land use code, then there is an order of priority for reduction or relocation. However, Code 70-10-60 does not apply because the proposed development fully complies with the land use code and with the Maroon Castle Creek Comprehensive Plan. There is engineered mitigation. All mitigation is certified effective for the 100-year event as a standard of analysis. This is a higher standard than the land use code provides for and has never been imposed on an applicant, and Celestial Land Company meets this higher standard. Alternate site mitigation for this so-called alternate site that has been now elaborately developed by the opponents does not offer a comparable level of protection for Celestial or a benefit to the neighbors. So we have three things before us. We have the request as tendered for 13,250 square feet, a house that would include an underground auto court, which largely uses up the bulk of that additional square footage, an alternate that I suppose might be seen as an 8250 house on that site, and then the alternative site. And moving through, we see that really the 13250 house meets all the objectives of the land use code with respect to avalanche, using a worst case scenario for its modeling, nothing is in the red zone, and has the least impactful protection angle for any debris flow walls or avalanche control walls, because they are with the flow rather than in opposition to it. And that will be presented later in the technical discussion. Same with debris flow. It's the best location to provide protection to downfan neighbors and roads because it will actually protect portions of the Pritzker property, and it will take into this debris flow mitigation some of the flow that has in the past overrun the road, Bulkley Drive. Further mitigates all geologic hazards. Its quiet architecture, significant below-grade areas, nestles into the landscape, minimally visual, and increased 1041 safety for neighbors, and no greater construction impacts than 8250. You can read what the 8250 house provides. The main significant portion is that on view protection, the loss of the covered auto court causes greater development visibility to the neighbors. To the neighbors, not the Maroon Creek Road. The alternative site, however, still requires mitigation, and the orientation requires taller and more visible walls. It provides reduced protection for down-fan properties. It's lower on the fan, but that does not necessarily make it safer, as you will hear from the technical discussion. And the mitigation has not been engineered, it has just been invented. There is increased visibility relative to the neighbors. And finally, we've done a cut and fill analysis. The 13250 house, which has the covered auto court, will use most all of the excavated material on the site for the avalanche trench and for other excavations. It will be all generally placed on the site. There may be some export, but very minimal. When we come to the 82 site, there is some additional export from the site. However, the alternative site cannot balance cut and fill, and there will be a significant need to remove material from the site. What is this really about? And here I'm going to take a moment to qualify myself. I've been involved in planning for over 35 years. I've been a planning director for 2 municipalities. I've been involved with other municipalities as well. I've been an AICP certified planner since 1984. I've never seen a project quite like this, where an influential and wealthy neighbor has chosen to disingenuously posit safety as an issue when what is really at stake is their desire not to have another house in their view. And that's what this is about. It is not about safety. They are not concerned about the occupants of some house that might be built on Celestial's property. Why would they be? Why would John Bennett be concerned about that? It is because these neighbors are concerned about their privatized view and want to keep it that way. It is a wonderful view. It was established by their architect, and it looks towards Pyramid Peak, and they don't want a house there. But they know if they came to you and said, we don't like this house and we want you to turn it down because it will be in our view, you would not accept that as a code basis for denying an application. You might say, we'll ask the applicant to put some screening in so that the house that they're proposing is screened from you, but you would not say, you can't build there to the applicant because of somebody else's view interests. And we all know that. So there has been this elaborate discussion of safety, which has been largely mythical and based on really their one concern. And I would ask you to keep that in mind as you hear the presentations. The order presentation is going to be first an expert in avalanche, Andrew Gleason. Then Andrew Earls from Wright Water Engineering will talk about debris flow and his own peer review of engineering that was done previously. John Cottle from CCY Architects will talk about the visual impression of the building. And by the way, the original project design won an AIA West award for design quality. And finally, John Fognani will make a concluding statement with respect to the record of review. So with that, I'm going to make a brief switch, and we change the PowerPoint for Mr. Gleason.
Mr. Chairman, may I make a request?
Question, yeah.
I'd like to just introduce Mr. David Bohm, who's here from Celestial. And
yeah, as part of your presentation, sure, if you want to introduce one of your, who is the applicant.
As you said, I just want to build a simple house.
Thank you, Mr. Chairman. I just wanted to to say a few words before the technical presentation starts. Firstly, to express my appreciation for Pitkin County to consider my application. I know how hard the Board of County Commissioners have been working on this application for quite some time, and the staff at Pitkin County have been doing an equal determined effort to assess it as fairly as they can based on the code. I came here several years ago, and my primary place of residence is in Hong Kong. I have properties, I have residences in China, in Thailand, in Australia, in Singapore, other parts of the world. And I must say, when I first came here and saw this beautiful place that you have, I never dreamed it would take at least 3 years or more, and counting. Well, 5, John's correcting me, sorry. 3 years since I've been last here, to get approval to what I would think is a fairly simple house. I mean, I know there's lots of issues raised by the other side, and I'm a good neighbour to everybody. I'm a neighbour all around the world, and I intend to be a good neighbour here as well. And I just wanted to say that my application is just to build a house. We have made every effort to employ the best consultants, the best architects, the best planners to take care of all the concerns that you may have as a board, to take care of all the concerns that the neighbours may have. And as I said, I'm determined to be a good neighbour in this part of the world as I am elsewhere. And since I'm the one since I'm the reason that we're all here today, and there's a lot of people in this room, I just wanted to introduce myself, because I know there's been some articles in the local press, and I thought I should come. I flew over from Hong Kong yesterday, specifically to be here today, just so you could all see there is actually someone who is actually wanting to build a house. It's not just legal teams and consulting teams and architects and engineers. And my main purpose of just getting up briefly to say, to address you all, is to say thank you for your consideration, thank you for your time, and I hope that we can come to some favourable conclusion that everyone is satisfied with, including our good friend, the Pritzkers right next door. Thank you very much, Chairman.
It's okay. Hello, my name is Andy Gleason. I work for Troutner Geotech. I thought I'd give you a little bit of my background in avalanche. I was an avalanche forecaster for the Colorado Avalanche Information Center for 11 years on Red Mountain Pass, the most avalanche-prone highway in the United States. I was a land use specialist for the Colorado Geological Survey for 9 years. I worked with Karen Berry as well. I currently teach at Fort Lewis College, teach geology and snow science down there. I have a master's degree from Montana State in geology, specializing in avalanche terrain parameters of starting zones. I was a research scientist for the Institute of Arctic and Alpine Research at the University of Colorado. I received a NASA grant to look at snow for 4 years with them. I've forecasted in Montana and Chile, and I was on the executive board of the American Avalanche Association for 10 years. So what I'd like to do is run you through the avalanche hazard analysis that we conducted for this area.
Can we turn one of the lights off?
We can't.
No, that's right. I'm sorry, forgot.
So, our analysis is based on extensive field work, including dendrochronology, where we cord trees and we look at the tree ring analysis to determine the age of the trees in the avalanche path. We can actually tell if an avalanche has hit a tree looking at the reaction wood and the cellular structure of the wood. We use digital elevation models and orthophotos to conduct some avalanche modeling as well, using a couple different kinds of avalanche modeling that I'll talk about in my presentation. And we use the most conservative velocity, snow height, and impact pressure results for the mitigation calculations. We ran a couple different models, and they had fairly different results. So we used the ones that showed the fastest avalanche with the highest snow heights and the most impact pressures for all of our calculations, just to ensure that it was as safe as possible. So let me run you through this avalanche path. This is an avalanche path. It's a two-part avalanche path. It's got a left channel and a right channel. Comes down here. It has to make a zigzag, and then it comes out right at the apex where we're standing. Has a starting zone at the top where the avalanche initiates, a track where it accelerates, and the starting or the run-out zone where it decelerates and deposits. So let's take a look at this. Here's the upper left starting zone from the mid-track. And you can see there's a lot of cliff areas. Avalanches generally occur from about 30 to 45 degrees. That's where they start. Anything above 45 degrees, and the snow continuously sloughs off, so it can't build up into the dangerous slab avalanche. We've got a number of areas up here where it just cliffs out and it's very steep. So we'd have continuous sloughing throughout the winter. Here's the upper right starting zone. As you can see, it's heavily vegetated, which increases the friction and inhibits initiation of the starting zone. Here's some trees in the track of the right-hand starting zone, and once again you can see that they would inhibit the friction or inhibit the movement of the avalanche. Here's some trees in the left side of the avalanche path near the top. Here we are looking down at the avalanche path. Here's the Pritzker barn here. Here's a rough area of where the building envelope was, where we were today. And the avalanche comes down like this, has to go through the trees, zigzag a bit through here, and then come out into the avalanche, or into the alluvial fan area. So here's some selected trees that I showed in the report that you have. And down at the bottom, we have a tree that's about 107 years old, right near the apex of the fan. This one's about 105. Mid-track is about 70. Up near the top, it's 40 to 55 years old, which makes sense because most avalanches, the most frequent ones will be up at the top. Very few have gotten down to the bottom. So we're not talking about an avalanche that comes back every year. We're talking about something with a return period on the order of 50 to 100 years, which means that it has a 1 to 2% probability of occurring every year. Incidentally, I did look at a couple of the large aspen trees right where the house site is today, and I measured one that was about 79 years old, one about 85 years old in the site itself. So we did some avalanche modeling. And avalanche models, we use the latest and greatest. It's called RAMS. It's a two-dimensional, state-of-the-art numerical simulation model. It's to calculate the motion of snow avalanches. We also use an Aval 1D model, which is an older version, which is one-dimensional. It's important to note with the RAMS that it's a two-dimensional model, even though it's draped onto three-dimensional digital elevation model. So it's draped onto 3 dimensions, but it's only looked at in 2 dimensions. We got slightly different results from the RAMS and the Aval 1D. The Aval 1D showed slightly higher velocities, higher snow heights, higher impact pressures. So that's the numbers that we use to calculate our avalanche walls and all the mitigation, just because it's a little bit safer. So for this RAMS model, we input the digital elevation model and some ortho photos to define the path. We input the snow depths of the starting zones and densities. We input the friction of the avalanche path, and we input all the forested areas. Based on our extensive field work up there, I hiked up and down there a dozen times. So here's a simulation where you can see it flowing down the avalanche path and goes down to the area of the building envelope. So once again, here's our mitigation wall with in place. You can put mitigation into the model, and you can see it run next to the wall, and the colors represent the height of the snow. So this is in meters. It's a European program, so it's in meters. So this is 4 meters in red, down to blue, which is about a half meter. So this is 2 to 3 feet on the fringes. Here are the snow flow heights based on the model. And this is once again in meters on the side, the color scale. So the middle would be about 4 meters deep. On the edge, where a building envelope is over here, is in the blue area, less than 1 meter, so 1 to 3 feet of snow height. Here is the same snow flow heights with the deflection wall in place. So the proposed house would be on this side of the wall, and you can see that it builds up next to it, but we've accounted for that with the size of the wall. Now, with any kind of model, they have limitations. It's a model. It doesn't tell you exactly what's going to happen. And according to RAMS, it says the deflecting or catching dams can neither be designed directly, nor can the residual risk below the dams be calculated directly with RAMS. So we use it as approximation, but we calculate it based on the snow velocities that we get, the snow heights. Here are some of the velocities. These are in meters per second here. So by the time we get down to here, 10 meters per second is about 22 miles an hour. So in our building envelope, we're down below 5, which is about 11 miles an hour. That's the kind of velocities we can expect from the debris once it gets down to the snow, to the house site. Here's some impact pressures, and these are based on kilopascals. And we use 30 because the red zone and the blue zone are basically differentiated based on about 30 kilopascals. It's about 625 pounds per square foot. Above that is a red zone, below that would be the blue zone. So in this case, where it's red, this is what the RAMS model says would be the red zone. Anything below that, including the green and the blue, would be considered the blue hazard zone under Pitkin County regulations. We also used AVIL 1D. This is the older model, but it also gives you output of impact pressures, speeds, and velocities. And once again, these were a little more conservative. They were higher numbers, faster speeds, so this is what we used to calculate our mitigation. So when I drew my initial red zone and blue zone, and once again, the blue zone is the moderate hazard zone, the red zone is the high hazard zone. I think you're very familiar with that. This is what I drew. Then Art Mears, who is the avalanche consultant for the neighbors, he came up with one as well. And his are the solid lines here in blue and red zones, and mine are the dashed lines. And what's interesting to note here is that they're very similar. We came up with very similar red and blue zones within a margin of error for these kinds of models. And his was a little further out here on the red zone. Mine was a little further out on the blue zone. So at the last meeting, we decided, or at the continuation hearing last year, we decided to accept Mr. Mears' red zone here and our blue zone. And that's what we've decided on. You can see that mine go further back. And if we overlay the blue zone that we've agreed upon and the red zone that we've agreed upon with my original red zones, which are here, and if we look at the RAMS modeling, which shows the red zones much further back up, you can see that the RAMS model, which takes terrain into account much better, so as it zigzags, it slows it down, that it's further back. So if there's any question about the uncertainty in the red zone, and as the Colorado Geologic Survey said, there is some uncertainty with red and blue zone lines, that in this case, I think the uncertainty would be uphill further from the house, based on what I see. So here is a diagram that shows our mitigation. And it seems a little complicated, but it's pretty standard for mitigating houses in the blue zone. So here's the proposed house location. Here's the extent of the red zone. Here's the extent of the blue zone. And here's our avalanche deflection wall. And it's about 14 feet high down here, up to 16 feet at the top. We use here's the direction of flow of the avalanche here. We used a trough for the avalanche in order to gain the maximum wall height across the zone. Note that it doesn't start until out of the red zone because they asked us to limit all construction to outside of the red zone. The debris flow basin, which is constructed at the bottom, will also help to mitigate avalanche debris at the driveway. The estimated snow height of the driveway with no mitigation at all is about 2 feet deep. With the mitigation of the trough and the debris flow basin, it's 0 to 0.5 feet. So we feel that the driveway is well mitigated. Here is the frequency-consequence relationship for avalanche risk analysis taken from Art Mears' report that he submitted on April 21st. And what this shows is the return period, avalanche return period, which is very similar to a flood return period. And it shows the CLC site here well within the blue or moderate frequency and consequences for risk analysis. It's well within the blue zone here. Here's the alternate site. He showed another graph as well with some Canadian regulations, but what I'd like to point out is that even the neighbors show that our site is well within the blue or moderate risk zone. So here are some avalanche walls that I'm going to show you. I'm going to show you some of ours and some others further down the fan. So here's avalanche wall that we've come up with. And it's 14 feet, but it's 14 feet at the bottom, a little higher at the top. and the impact pressure is about 200 pounds per square foot. This is based on the angle of the flow from the avalanche. So when an avalanche comes down, if your mitigation wall is more parallel to the flow, it will be lower than if it is more perpendicular. So as it becomes more perpendicular, the wall height has to increase, no matter where you are on the fan. So we have our wall here, and then if you turn that wall in this direction, which is more perpendicular to the flow, it goes up to 25 feet tall and has an impact pressure of 575 pounds per square foot. When we look at the proposed alternate site that we were given from the opponents in April, we look at some of these walls. So when we look at this wall, it's 21 feet high. We look at this one, it's 24 feet high. And that's because it changes direction compared to the angle of the flow. As you get more perpendicular, the pressures increase, the heights increase because you get run-up of the avalanche. Down further, in order to protect the road, we'd have to have it at about 14 feet. And they did put in some trough, a trough as well, so that you can decrease the height of the wall based on the depth of the trough. That's pretty standard practice for avalanche mitigation. So just to reiterate, when your wall just deflects, an avalanche deflection wall, it changes the course of an avalanche. The less angle you change it, the smaller it can be. The steeper it is, the higher it has to be. So further down the fan, even though the impact pressures in general might be less, if you turn the wall, they can increase because of that angle. So a couple of bullet points on this area. We've recognized the avalanche hazard. I've worked with avalanches for many, many years, and we recognize it's an avalanche path. We recognize it's mitigable. Building in the blue or moderate hazard zone is typical in mountain communities in the United States. It's been done in Pitkin County. It's been done throughout Colorado. Avalanche mitigation for the site includes a deflection berm and wall and a trough that channels the debris away from the proposed structure. The trough adjacent to the avalanche deflection wall was designed in order to accommodate the overall wall height for the avalanche debris calculations, so the house wouldn't have to be so high up in the air. It can go further down. Now, the opposite side, their hazard zones are very close to ours, within a margin of error for these kinds of models. And so we've agreed to use the more conservative of the two, and even with that, we're able to mitigate the avalanche hazard. So with the trough and the deflection wall, we feel that the property is well mitigated. So once again, here is our mitigation. Here's the red zone, here's our mitigation wall, here's the trough to create the depth necessary, because you have to have a certain depth next to your wall so that when it does build up, it'll keep flowing down. And we have our debris flow catchment zone. And it goes down here, and then this, in essence, creates a small little wall next to the driveway, which will be enough to contain that 2 feet of flow height. So, some final thoughts. The proposed house location is in the blue or moderate hazard zone. Code doesn't say you have to be anywhere within the blue or moderate hazard zone. It doesn't say you can't build near the fringe of the blue zone. It just says you can build in the blue zone, and we are in the blue zone. These lines are conservative. The RAMS model reinforces our original red zone, which is further away from the house. So once we got the latest and greatest model, it went actually even further upslope away from the house than what we originally conducted. But we realize the limitations of the models, but I do think that it reinforces our original zones. Pitkin County allows mitigated development in the blue zone. The proposed mitigation takes into account both avalanche paths. Every time we ran the model, we took both paths running at the same time. The powder avalanche pressures, which are above the dense flow of the avalanche. So avalanches have a dense flow at the bottom. They have what's called a saltation layer, kind of a middle layer. And then they have a powder layer at the top. The powder layer would go over the avalanche wall. The pressures are pretty small compared to the actual debris, and they're well within the mitigation capacity for reinforced windows. The alternate site, as it's proposed, would have very large mitigation walls due to the angle of deflection to the flow direction of the debris. Because it's further down the path, doesn't necessarily mean that it's going to be less hazardous, because it's going to pile up because it's perpendicular to the flow. So Karen Berry from the Colorado Geologic Survey, who's the interim state geologist, said in a letter to Ms. Wolf on May 21st, as with debris flows, the relative risks are generally greater closer to the apex of the alluvial fan, but avalanche hazards at both building sites can be mitigated. So they say, in summary, the CGS continues to believe the proposed development and mitigation is feasible, but additional design and analysis will be needed before site plans, grading plans, or building permits are approved, which is standard. We're at the preliminary plat phase. We don't have everything completed, all the plans, so of course there will be more plans to come. So, in conclusion, I worked for the Colorado Geologic Survey doing this exact same thing, and I've done it here in Pitkin County. I worked with Ms. Wolf when I was a land use specialist with them. And when a engineer comes up with mitigation plan and they stamp it, we say, okay, that's what we asked for. We asked for a stamped engineer's approval for the mitigation, and then the Geologic Survey accepted it. That's what we've done here. I believe that it's mitigable. It's fairly standard. It's been done a lot of places. Yes, there's an avalanche hazard. Yes, it could be significant. But our client has the resources to build the mitigation. Some people don't have those kind of resources. People in Aspen have those kind of resources. So they can build this kind of mitigation to adequately protect the proposed house. Thank you very much.
Which one's the slide? Well, thank you all. For the record, my name is Andrew Earls. I'm Vice President of Water Resources with Wright Water Engineers, and I'm a registered professional engineer in Colorado and several other states. Really appreciate the opportunity to be here today to tell you all about alluvial fan hazards and the mitigation that's proposed. Just for a little background, I have been working on alluvial fan and mud flow issues for many years here in Colorado and in New Mexico. We've addressed them for alluvial fans. We've addressed them for post-fire, which is another place where you see debris flows. And I've been working in the Roaring Fork Valley since I got out of grad school and got my current job in 1999. So I know the area. I actually work with the City of Aspen and have helped to develop the Urban Runoff Management Plan, which is the criteria manual that's applicable in the City of Aspen. And I was the primary author of the mud flow chapter in that. Now, as you've heard, Tetra Tech began their analysis in 2008. I was actually brought in 2010 as a peer reviewer. And the reason I'm presenting this here today is to give you an overview of all of the mud and debris flow issues, rather than having Tetra Tech provide the presentation again that they've given several times. I was brought in to take a look because I know Aspen, because I know mud flow issues in Aspen, and to serve as a reviewer and to basically raise my hand if Tetra Tech wasn't doing things the right way, to help give them ideas and comments, and that's exactly what we've done for the past several years. Throughout the whole process, I've really found the work that Tetra Tech has done, their engineering, has been really exemplary. They have done a very thorough job of analyzing the debris flow on this alluvial fan and a very thorough job with the mitigation. So as a peer reviewer, I'm going to do my best job to give you a brief overview of about 3 years worth of work in the next 30 minutes or so. So where I wanted to start was with some reasonable questions, and these are all reasonable questions. They're the types of questions the neighbors would ask, the types of questions I'm sure that you all are asking, and the types of questions that as the applicant's engineers that we need to ask and answer to be able to make recommendations on this alluvial fan. And what I hope to do in the presentation today is to go through and answer many of these questions, if not all of them, related to the science behind the debris flows and the engineering behind it, as well as the mitigation. Those were a lot of tricky questions, but Celestial Land Company assembled a great project team to address them. They're not easy questions. They require experts to be able to address them, and that's exactly who Celestial hired. They hired Tetra Tech and Elena Smith out of their Breckenridge office, as well as Peggy Bailey, are both experienced engineers. This is not the first time they've used the Flow 2D model or the first time they've been out in the field looking at alluvial fans. They do this kind of work, and actually Tetra Tech out of that office has quite a national, I would say, and regional reputation for debris flow expertise, because it used to be called Flow Engineering, FLO, before it was bought by Tetra Tech. And that FLO stood for the 3 letters, the names of the guys that invented that model. And the third one on the list here, Jim O'Brien, Dr. Jim O'Brien, was the O in Flow. One of the other guys still works up there in the Breckenridge office with Tetra Tech, Jim Lanzotti. And Jim O'Brien was involved early on. He developed Flow 2D. He also studied sediment and alluvial fan hazards at Colorado State University, so he was educated here. This is his home territory. And he was a project advisor. He spent time in the field with Elena. And then, as I mentioned, I've been brought on as a peer reviewer. And I haven't just done this as Andrew Earls myself doing peer review. I also have asked for expert help. And I have gone to Ken Wright, who's my boss. He's 83 now. He's been running a successful engineering company for 53 years now. He's dealt with a lot of fans. He has dealt with Aspen Music School. He was involved in that, as well as others in the Valley. And we also had John Rold. And John, sadly, is deceased now. It's one indication of how long this has all gone on. But John was the state geologist for many, many years. And when he retired, he began to work adjunctly with our firm. And so we brought him in on this when he was still in good health before he declined. And we had him look at it and presented it to him and got his input as well. So I think that a very, very high standard of peer review and engineering and the project team has been assembled here. It's like the applicant himself just said a few minutes ago. I mean, they've taken great care to hire the best consultants that they can to try and do this work. And as a peer reviewer, I can tell you that it's been very good. I wanted to show you this just as one example of Tetra Tech's expertise with mud and debris flows. This is in Glenwood Springs. This is behind their hospital. I mean, a hospital, a critical facility on an alluvial fan. And you better believe that there is development down gradient from this as well. This is a debris basin. This view actually here is looking, oh, sorry, what did I just do? This view right here is looking from a hill down at the hospital. And if you were actually standing in this parking lot near these cars, this would be the view back. They're actually using this as kind of a laydown area for some stuff right now, and there's an outlet over here. So they're common practices in the valley. In this case, we're talking about a critical facility that serves a very, very vulnerable population, patients, people in wheelchairs, etc. It's not a single-family residential home, which is what we're talking about for Celestial. So it has been a very qualified team of experts. In fact, for Flow 2D analysis in the Valley, many consultants actually call Tetra Tech when they need help with that. Many consultants in the Roaring Fork Valley, because they know that Tetra Tech is the firm that knows how to use this and apply it. So what I'm going to do today is to work through and present 5 facts that I would like, hopefully, to have you understand why that I'm done with this presentation. The first one, that alluvial fans are common in the western U.S. and Pitkin County. Number 2, that the analysis has been very thorough. Number 3, the entire site is constrained. That's important because that's in the code. Number 4, that the hazards can be mitigated using proven measures. I mean, we're not going outside of the box here to invent something new that's never been tested. We know this will work. There's not a question about whether it will work or not. And finally, that the proposed mitigation really addresses all of the concerns, whether it's with displacement, impact pressures of boulders rolling into walls, or with its channel avulsion, the channel damming and moving to a new location. So we're going to address all of those in the next few slides. The first one is that alluvial fans are very common in the western U.S. and Pitkin County. This is USGS mapping for the area. You can see the city of Aspen here, Castle Creek coming down here, Maroon Creek here. You can see the Roaring Fork. And I know this is a little fuzzy, but everything that's in purple is an alluvial fan. So you'll see them all along Castle Creek, a number of locations here along Maroon Creek, along the Roaring Fork as well. And I wanted to point your attention right here to this, right here at Aspen. I mean, the city of Aspen itself sits on an alluvial fan. So they are ubiquitous. Development does occur on alluvial fans, and that's something that I'm going to show you here. The other thing that I wanted to point out while I was on this slide, just because it's been in the news lately, is you'll see some other colors. Look at this, for example, the orange. These are landslide areas. Okay, landslides are a very real geologic hazard in Colorado. I think everybody's seen the news on the Colburn slide. That landslide, it was just massive. And what I wanted to tell you all, Oso, Washington, another one, they are true geologic hazards, but they're a different phenomena than what we're dealing with here at Celestial. We are dealing with an alluvial fan with a limited drainage area. It is not a mapped landslide hazard. It's an alluvial fan. They're like cats and dogs. They're two different animals. So I wanted to be sure that we understand that going in, because I know in some of the neighbors' submittals, they've referenced some of these other events, and certainly they're shocking, and certainly they're disasters, but they're not the same thing we're talking about at the Celestial Land Company site. It is a different, fundamentally a different phenomena. So I mentioned that Aspen sits on alluvial fan. Well, this is the city of Aspen's mud flow mapping that's in the manual right now. And what this shows, oriented to the north, this is the toe of the mountain, and in blue, what you can see here are areas that are anywhere from 2 to 8 feet in depth. It's, of course, the mountain is the source area for this alluvial fan, and it comes down. These highlighted yellow areas that you see here are depths that are 2 feet or greater. So they're little pockets, and I'll show you where these shading is derived from when I go to the next slide. But the really important thing here is that development has occurred in these areas on this alluvial fan. Redevelopment continues. There are examples of mitigation for debris flow right in these areas. Top of Mill is one of them at the upper end of Mill Street. So in a dense urban area like Aspen, you can mitigate for this, and you can do it. In fact, the city of Aspen, if you're outside of this 2-foot zone, it's just not a non-issue. I mean, you still need to have good engineering and a good site design and get your finished floor elevation set in the right spot, but you're not jumping through hoops or performing analysis. It's shallow mud flow, and they have set that bar at 2 feet. Initially, when I wrote the chapter on mud flow for the city of Aspen, we had defined zones as being 1 foot and greater, and I think apparently, as we'll see from this next slide, this is the 1 foot line and greater, another figure. I think the city must have figured that they'd be regulating every construction project in the city practically if they went down to 1 foot. So they actually went in and they defined those yellow areas based on some of this line work that you see here where they have the deeper depths. So if you're outside of these deep zones, you're free to develop. If you're in the zones, it's not like you can't develop. You can, but you need to perform analysis using the same criteria that we've been applying for Celestial Land Company's site to demonstrate that you're not going to impact your neighbors and cause problems for them. So that's exactly what we have done. And this mapping is from a master plan that was done around 99 to 2000 by WRC Engineering, who also are fairly experienced with the Flow 2D model. While we're talking about just how common these things are in Pitkin County, it's useful to just look down valley. This is the Pritzker residence. As I think everybody knows, the Pritzker property is just down valley, and the Pritzkers are one of the members of the groups of neighbors who are opposing this application. This is Flow 2D analysis. Tetra Tech did the same thing on this site to look at it, and I'll come back and revisit this a little bit about some of the area calculations. But when we look at this, this is a part of their site too, this green meadow, fully unconstrained. In this case, there is a least hazardous location available or a much less hazardous location available, but instead it's situated right in between these two watersheds that come together and form an alluvial fan. It's a good thing that there's freeboard in the mitigation design and that you do have mitigation, because this would be a very hazardous location if you were not mitigated for it. So once again, not the least hazardous portion, but this is an example just right down valley by the people who are opposing this application, yet they've done more or less the exact same thing. On to fact number 2, which is that CLC's consultants, Tetra Tech, and the other consultants who've been working on this, Andy as well, and myself in the peer review, have used the best available information to thoroughly analyze this. And I can tell you that I've been involved in a lot of site plan applications. I've evaluated a number of alluvial fans, and I've never had one that's kind of gotten drawn out and gone into this detail. I think that there is a value in that, and the value is that we really have thoroughly understood this fan. We have thoroughly analyzed it in different ways, and we've come up with a good plan based on all of that. And what I really want to emphasize here, because some past hearings and motions have been related to the modeling of Flow 2D, and when you hear other people, the neighbors, present that, you would think that the only thing we did was push buttons and run a model. That couldn't be further from the case. Tetra Tech spent time in the field. What you're seeing right here, this is actually an excavated test pit. They did multiple test pits. This is how we learn the history of the fan. It's by looking at these different layers of deposition, looking at when they were deposited, how thick they are, how they were laid down, that we get an idea for how frequently this fan operates, which we do believe is probably roughly in a 10 to 25 year frequency, even though we're designing for a big event, the 100-year event. Tetra Tech also looked at things. Here they looked at like scars on trees. That can also tell you. You can look at just the size of the trees too. I mean, the tree aging data that Andy presented earlier is very useful. It does tell you something. If a massive debris flow comes through there, it will take out trees and they'll become part of the debris flow. So when you have large standing trees, it's a good indication that you haven't had really major events for some time. And Tetra Tech reviewed historical accounts in addition to this. So really, there has been a big field component and a reality check component to all of this. Now what I want to do here for just a minute is to start talking a little bit to explain what 20% concentration and 40% concentration are. And I've got a little visual here for you all. I'll pass these around. You might not want to shake them yourself, or you might get a little water on you. I think the lids are on. I mixed these up yesterday. This is soil from the CLC site, from that channel that we all walked over today. And we were walking up. I went in there with the spade, dug it up, got some rocks. This is more or less 20%. And the thing that you'll notice, I'll pass it to you, Mr. Child, first, it settles out pretty quick. I mean, when you're going down a steep hill, this just kind of rolls along. So 20%. Note how heavy it is as you're looking at it. I mean, it looks like muddy water, really, doesn't it? More or less. And you've got the sediments in the bottom and some rocks. What we're really worried about for 20%, because it is much more like a fluid, much more like water, it tends to spread out more. And this is, I'll show you in just a minute, is the reason the whole fan is constrained. What we're talking about in this jar, and you can kind of see the rough level here, this is about 45%. There are a few big rocks in here too. These are all plus or minus too.
Did you find any gold?
Pardon me? Gold.
Find any gold?
Oh, see, look, 45%. This stuff doesn't even want to drop into solution. And this, see, the 45%, it's leaking along. I apologize. Try not to get it on you. The 45% is a lot more like mud when it gets mixed up, though. That's the point I want to show you here. It's heavier. I mean, if you weigh these two in one hand or the other, that is considerably heavier. It has more than 2 times the sediment in it, right? So when we're designing for the 45%, we're designing for the impact, the spread. It doesn't, not the spread, the impact of the force of it. In a lot of ways, you can almost think of this like the red and blue zones for an avalanche. If you think about the red zone being the 45% concentration, you know, that's where it's the greatest pressures, the greatest impact forces, the highest velocities. When we talked about the 20%, it spreads out a little more, it's shallow, more analogous to the blue zone. So that's just a little primer to show you the type of stuff we're talking about. And thankfully, I didn't make too much of a mess. But I want to show you a few photos. These are some photos showing you what roughly a 20% concentration. We all walked by here today. This is where you can see this is leading down to the Willow Creek Ditch. This is the Willow Creek Ditch down here. This area right up here, we saw a culvert that actually had kind of a wire frame over the end of it. At the time these photos were taken, it actually had a standard grate on it. And you can imagine if you tried to pour one of those containers through a standard grate, it's going to start to plug up with rocks and stuff. So that was retrofit. But what these photos are showing is when it did plug up, runs down Bulkley Road, and it was causing erosion coming here into the Willow Creek Ditch or Willow Ditch. So I wanted to show you a little bit about the 20%. This is Flow 2D modeling of the 20%. And once again, if Flow 2D is a model, and like any model, it's a representation of reality. It's not reality. So you have to have someone who's qualified running the model and interpreting the results and comparing it with what's on the ground. And that's exactly what's happened here. But what you can see when you run the 20% analysis, as you'd expect from some pretty fluid stuff, it does spread out. And there is not a section on here that is not constrained by the 20% 100-year storm. This is showing you the proposed conditions. Still the activity envelope, the wall, and what it does is it protects this from the 20%. This little geometric feature you see here, everything in Flow 2D is a grid, so it doesn't look exactly like the shape, but that's the debris flow basin. And that's what provides the benefits down fan. And you can see this wall and debris flow basin really create a shadow, and it actually reduces the depths downstream at the barn and the caretaker unit. It reduces the depths on Bulkley Road, and that's how it's protecting CLC and improving conditions for the neighbors. We'll come back to this in a little bit in a minute. But the main conclusions for the 20% are the entire site is constrained, the 20% is shallower depths, more spread than the 45%, and that the mitigation will take care of this as well as the 45%. Let's look at the 45% for a minute. This is showing you the 45%. If you compare this to the 20% one I just showed you, you'll see the 20% one covered the whole envelope. Just like the red zone doesn't cover the whole building envelope here, it just covers a portion of it. The 45% covers just a portion of it. And you can see the depths here in the active channel coming down the fan. When we're up here on the building envelope portion, the depths are much shallower, typically less than a foot at the 45% concentration. And for most of the parts of the building envelope, we're talking, if you look at the depth of water in one of those containers I passed around, I tried to measure it so it was more or less about 6 inches. That's the depth we're talking about. I mean, you guys just passed the hazard around the table. We're talking about 6 inches of mud, 6 inches of muddy water in some of these cases. So that's the 45% 100 year. This is actually interesting because this is the 25-year 45% concentration. And the reason I'm showing you this is because this is actually what we are avoiding. If you want to talk about frequency, you know, from the age of the trees there, this thing hasn't seen a 100-year mud flow in quite some time because we've got some big trees. The evidence that's been analyzed, the test pits, all of the data typically indicates that a 10 to 25-year frequency is what drives this system. And so what we decided to do, what Tetra Tech and Celestial decided to do, is to stay the heck out of the 25-year boundary. If you have a 25-year event, 45% concentration, it would just come up to the wall. It wouldn't be. We'd essentially be avoiding the hazard in this case. So again, this is what has a higher probability of happening. So in conclusion, for the 45%, we're outside of the 25-year boundary. The building envelope in the house is in the fringe of the 100-year boundary, but we're talking about very shallow depths. And the mitigation accounts for displacement as well as impact forces. And for the 20%, it provides some attenuation. So I wanted to show this slide too, just to show you that the story doesn't end with modeling. This field verification was really important. There were several events in the past 20 years. 2011 was one of the most recent ones. Jack Kaufman, who is familiar with the site and is the Celestial site manager, I would suppose, is very familiar, and he has seen a few on this one as well. What we did is we went out and we mapped. We looked at boulders. You look at a lot of different, the more frequent flows to figure out how the fan is operating. And what that does is it just gives you greater confidence that you're getting it right. I mean, we know that we're not going to be exact with what we're doing with this model because we cannot represent reality and something that's so uncertain with this, but it lets us know if we're in the right magnitude. And what we want to be sure is that we're of the right magnitude and that we're on the conservative side of it. And I can tell you, having peer-reviewed this, there is no doubt that we are doing this correctly and that it's conservatively designed and conservatively sized. Wanted to show you a little more analysis. Again, we're on the topic. This has been very thoroughly analyzed. We didn't stop at Flow 2D and field work. This is detailed site drainage analysis. And I believe what this figure is, it's actually showing you debris flow basin sizing. This site plan is a little funny because the orientation is a little different than the last ones I showed you. But the reason I've shown this, and you can see the activity envelope, is if you see these dashed lines, this is the local drainage, we call it. This is not coming down the fan. It's not a mud and debris flow. It's just from the area around the house. So we've accounted for that in the debris flow too. And what this says is this is a hydrograph. So on the x-axis you have time, on the right axis you have flow. This was done in a pond routing model, which is a common model that we use as engineers to size ponds. It was the information from Flow 2D was taken and put in this model, and then this model was run to determine the sizing. I also independently had some of my folks do checks in Flow 2D. By identifying some different cross sections and looking at the fluxes through them, and it all checks out. And what you can see here is the blue. This is the inflow hydrograph, or mud and debris flow hydrograph, and the red is the outflow. And what this debris flow basin really does, it doesn't completely retain this. I mean, we haven't talked about completely retaining the 20% ever. That's not the strategy. I mean, this historically, it flows through the site and it goes down to the willow ditch. What we want to do is to let it continue to do that as much as we can, but we don't want to put anything more onto the neighbors or cause problems. In fact, we want to try and help them. And that's what this does. If you can look right here, you can see this discharge is limited to a little more than 40 cubic feet per second. That is at or below the existing discharge that would be coming from that area. So the storage that's provided by this, which is 50,000 cubic feet, so more than an acre-foot of storage in this debris basin, that's represented as the area between these two lines. And it will store 50,000 cubic feet of debris. It will also have an outlet that will allow, as it's filling with debris, for it to release water, and that allows it to attenuate flows and release it downstream in a controlled manner. And the result is this is the site that has been engineered. It's been extensively reviewed. It uses proven methods. You have the trough, you have the debris flow basin, you have a deflection wall. The discharge is going to the historic location, to the Willow Ditch. There will be a spillway for large flows that would exceed the capacity of the basin, which is just standard practice. You always put in a spillway. Yeah, as I mentioned, there are more than 50,000 cubic feet of storage. So it's a very effective plan. And the other thing, one of the things that makes it effective for debris flow as well is the orientation. You know, when debris is coming down, and if you see this is the intermittent drainage, I believe this is probably roughly the area where that diversion point is, although I could be a little off, I think it's about it. But you know, the flow is coming down this way. And even if you had it coming across gradient on the fan, it's still going to strike this wall at an angle. And the same thing that applies to avalanche walls and snow applies to mud and debris flow. I mean, if you want to see a big run-up, and boy, I've seen them like 8 to 10 feet in Manitou Springs and debris flows, all you need to do is put something perpendicular to that flow. It's just not smart. You want to angle it to the flow so that you're protecting what's behind the wall, but at the same time you're not causing extensive run-up or super elevation that's going to drive the wall to be much higher than it needs to be. Fact number 3, the entire site is constrained. I don't know, hopefully I don't have to spend too much on this, I think we agree on it. This is the 20% analysis. I mean, with this is a fact from that analysis. If you don't believe the model, all you have to do is look on Google Earth and see this photo. I mean, looking at this, there's no doubt that this landform is an alluvial fan. It would be apparent to anybody that that's taken an introductory class in geology. You can see a few features. This is a really neat view, kind of an oblique view from Google Earth. And you can see this area up here is where it's coming out. We were walking up here today, and it comes down, and you can see the main active channel comes right down here. This is where we walked up today. It has kind of split off up here, and there's been a little spill down through this way, and that's part of what we walked across today as well. But this gives you a good overview. Now what I want to show you, this is approximately where the deflection wall and the berm located that's going to provide the protection for the debris flow and the avalanche. And while we're looking at this, I mean, a lot of arguments and a lot of papers been spent saying that this site is proximate to the apex. Well, proximate it may mean different things to different people, but this slide kind of puts it in perspective for me. If we want to look at proximity to the hazard, not just the apex, but to the hazard, because honestly, this active channel, that's the part where you have the deep flow depths, you have high velocities, you have boulders coming down there. We want to talk about proximity to the hazard, and we look at the apex. We start up here at the apex. And the first thing that you notice is that it actually is slightly angled away from Celestial at the apex. I mean, that dictates when you're coming out of that channelized area with the high banks, that's where the water and the debris has momentum. I mean, it takes something to change that momentum. You would have to take a hard left turn out of that to come back on Celestial. You could have plugging, it could happen, that's why we're mitigating. I'm not saying that it can't, but the angle is significant. And really, the angle actually does aim it right down the major drainage, which is where it's been going. And if you look at the Celestial property, the Celestial residence and the wall are more than 180 feet from the active channel. It was moved further away in response to earlier hearings. I believe it was moved an additional 80 feet in response to moving it away from that intermittent drainage. So that's something that has been responsive to the comments and moved it further away. But if you really want to look at a hazardous location, I mean, look at the Murdoch property right here. That is within 100 feet of this active channel. It's no wonder that Bulkley and Murdoch have both constructed their own non-engineered mitigation. I'd probably do the same thing if I lived that close to a hazard. Another comment just briefly on the hazards and the presence of hazards. This is the Pritzker residence. I showed you some Flow 2D results before. And what I wanted to, point I wanted to make on this, if you see this right behind here, you know what this is. This is a big deflection wall. Sitting right in the middle of the fan. It's oriented perpendicular to it. But it is a deflection wall that's intended to protect this residence. Now one thing I want to show you, there are two drainages that come down and form this. The west drainage is about 40 acres, the east drainage is about 60 acres. So you've got about 100 acres total coming down here. This is what was submitted originally when the analysis was done. And the reason I show this is because if you look at Basin B, which is the one, incidentally, that comes in closest to where the residence is, that hazard was underestimated by a factor of more than 2. They estimated that it was 15 acres. And Glenn Horn's been in this room, and he's told you all that it was 15 acres. It's 40 acres. This was a mistake. It's a good thing that engineers build freeboard into this. I mean, I have not analyzed the full details of how much freeboard is available for the Pritzker factor. I don't think they've had any problems that I've known of, and there's certainly, not that I know of, have been any 100-year mitigation events. But when Tetra Tech ran the Flow 2D for this, when the original application went in, the estimate on the debris flow volume for this system was about 160 cubic yards. If it were analyzed using the same methods that have been provided to Celestial Land Company, it would be more than 10 times that. And the reason I say that is, number one, with Celestial, we have not made a mistake. We haven't misidentified drainage areas. We've been very thorough. Everything has been checked. It's not only been checked by Elena and Peggy, Tetra Tech's done internal peer review, and then I have reviewed it after that, and I've gotten input from others too. It's been very thoroughly reviewed. We have not underestimated the hazard. And the criteria that are being used really far surpass what's been applied at any other site. And these are criteria: the 100-year event with 100% availability of sediment, 45 and 20%. The CGS told us these are the criteria to use. We'd already been using them, but the CGS actually affirmed in a letter that those are appropriate criteria. But to my knowledge, this mitigation was not based in any way on those criteria, because I can't imagine how you could only calculate 160 cubic yards from an area of nearly 100 acres. Okay, fact number 4. We're getting through these, and I know it's been a long day for you all. Number 4, hazards from alluvial fan can be mitigated using accepted, proven engineering methods. I wanted to show you just a few photos here. The two at the top, these are actually Jones Gulch deflection berms in Keystone. This is a project, and the reason I've included these because this is another alluvial fan, Keystone Jones Gulch, where there is existing development on the fan. I mean, this would be a lot easier if there were no existing development on the fan, because then you do what you want, protect yourself, and you don't have to worry about impacting others. But in this case, and in the case for Jones Gulch, there was other development. We've actually been involved with this. We assessed this, started after I began peer review for CLC. We assessed it, we worked with the CGS, we got approval, and these things have been constructed. These are in the field. They were constructed last fall, and we're seeing how they are. So this is another example of mitigation on an alluvial fan with neighbors. Aspen Music School is one that I imagine you all are familiar with. And then this deflection wall, this is one you guys saw it here today, right down near where we parked. If you go up to the barn and the caretaker unit, has a big concrete wall right behind it too. And the one from the barn and the caretaker unit goes exactly where all of the runoff from debris and mud flow goes here, which is to the Willow Ditch, which is exactly what we're proposing to send the runoff from our debris flow basin to. Want to talk briefly about some of the neighbors' protection measures. This is on the Bulkley property. This is one of the neighbors further up Bulkley Road on the fan. And this is a channel or a berm. Really, a channel and a berm can be used just about interchangeably. It redirects water and causes it to flow. So this is protection. You can see the carport kind of back in here roughly, I believe. And then this is Murdoch. We actually saw this today, their retaining wall. And the thing that I wanted to point out about these is that they are the same concepts we're talking about. I mean, we're talking about channelizing, we're talking about deflection walls. They don't have any sort of a debris flow basin to mitigate where they dump all this stuff. It just ends up on Bulkley Road. But what I would like to point out is that these things do actually have effects on deposition on the fan. I mean, these are not without consequences. And you can see one of the consequences right here, which is more mud and debris on Bulkley Road because of the non-engineered, non-permitted measures that these folks have constructed. In fact, Tetra Tech actually did some analysis of this using Flow 2D, and they found that, that there are roughly 2 feet of greater depth at the driveways for Bulkley and CLC due to the combination of these different factors. I mean, a 30-inch retaining wall doesn't sound like a lot, but it's cutting off anything below that where the flow could go, and it just so happens that it keeps it all right on Bulkley Road. This is actually showing you some of the results. Remember the berm channel I showed you? Okay, this is where that comes down. This is after July 2011, and this flowed from that constructed channel. It was diverted, rocks, mud, and debris. You can see the carport back here. This is continuing the flow path. This is looking uphill, standing on Bulkley Road at the area where it was diverted. And then this is Bulkley Road, where it dumped it out. So clearly, these modifications have affected others on the fan. I mean, these have been small events, but if you did have a 100-year event, you'd have much more significant consequences from these non-engineered designs. And in conclusion on this point, I wanted to just briefly quote the Colorado Geological Survey, Karen Berry again, and just about every letter she has issued for a long, long time has said this. She did us the favor in her most recent letter of actually highlighting this quote right up front so that nobody could misunderstand it. And it's what you've heard already. The mitigation is feasible. Additional analysis and design will be needed. Site plans, grading plans are approved. We couldn't agree more. I mean, at this level, you're just trying to get the entitlements to build the house. Before the client spends, what may be tens, if not hundreds of thousands of dollars on detailed engineering for this system, they want to know whether they're going to be able to build their house or not. So clearly, those are the next steps. We're very happy to share all the information with Karen Berry. We will provide her with whatever she needs for the models. I'll even go downtown and meet with her in Denver if I need to help explain things to her. We're very committed to working with her, and this is pretty standard for CGS. So fact number 5, and this is one where I talk a little about the mitigation and the different things that it addresses, because it really is not a one-trick pony. It does multiple things. And these are 2 of the primary objections raised by the opponents. I'm sure the folks here will tell you a few more too, but these are really technically with mud and debris flow, 2 of the main ones. Number 1 is the concern that the volume that would have deposited on the fan where the Celestial residence will be can no longer be deposited there. It has to go somewhere else. And the way we've dealt with that is with the debris flow basin, which provides storage and releases flows at or below pre-development levels. The second concern is related to channel avulsion, and that is by putting this wall on this mitigation system. What happens on alluvial fans, they're formed like a fan because that channel moves back and forth across over time, and it moves this way and that way. It's completely unpredictable. So what the opponents have said is that by building this wall, you're taking a portion of this fan where that could never avulse, or you could never have the channel move there again. And really the answer to that is we've got an engineered channel. If it ever comes over there, that channel's going to have a real good home in the channel that we've designed coming down into the debris flow basin. So let's talk about these for a minute, and this is one I really do want to address head on. I apologize, it's such a busy slide, but I've heard this now at 2 different hearings, and frankly, it is just wrong. One of the consultants for the neighbors has contended that the debris flow basin is missized by a factor of 5. They've never provided any supporting calculations. This is from the memo, and we have to guess at their assumptions: a relatively uniform distribution of flow, a generalized example, and they come up with 3.8 acre feet. Okay, the only way I can come up with 3.8 acre feet, and I can do it, I've tried it a lot of different ways, but if I take the debris flow wall and I take the 20% concentration and I basically look at everything that's back behind that wall and I multiply it all by 1 foot. Okay, now I think I know where they might have made the mistake. Okay, if you want to assume 1 foot, we've shown you, with the 20% concentration, remember the whole area looked blue, right, from the figure that I showed you. Well, this is the scale that's on there, and you can see that blue is anything from 0 up to a little more than 1 foot in the blue color. Now I know for a fact that Mr. Pfeiffer with Resource Engineering has never run this model, so I know that he's never looked at the output for it. The best thing that I can guess is he said it's blue. Let's call it a foot. Multiply 1 foot by this whole area and you get that. Well, in fact, when you look at the output, you find out that many of those blue areas are actually more like 0.2 feet. Okay? The difference between 0.2 feet and 1 foot is a factor of 5. Now that's the best explanation I have. The other thing is that when he's interpreting it from those figures, it's not showing the deposition volume. What it's showing you is the maximum depth at any given time. So that's not a proper way to calculate it. The proper way to calculate it and to calculate displacement in Flow 2D is to add cross-sections in, and I did exactly that. I added in cross-sections. You can't get them exactly perfect because it sells at different elevations, but you can get it close enough to be sure that things make sense. And I evaluated each of those cross-sections coming down on a mass balance basis, and it all checks out. Then you couple that with Peggy Bailey's routing that she did, which has been checked also. This pond is adequately sized. It's conservatively sized. It's sized for 50,000 cubic feet. It will provide attenuation for the 20% event, and it will contain debris from the 45% event. So again, I don't know how they came up with this factor of 3.8 acre feet. They've never provided any calculations. I just know that it's wrong, and we have checked it multiple ways and had multiple people look at it to confirm that it is wrong. So on the other hand, what's right? Well, this is the analysis that Tetra Tech has done, and they've evaluated 100-year scenarios. This is exactly what CGS directed. Flow 2D, we did that conceptual mass balance check, and Tetra Tech has really used standard methods. I would like to comment this CUHP design storm. It's a 2-hour design storm. It's what we used down on the Front Range for this. When we were doing the Aspen manual, we had a lot of debate about whether this is the right design storm for Pitkin and Aspen too. And the answer is we don't have anything better, but it's a very conservative design storm. It's a very intense design storm. It has 80% of the rainfall in the first hour of the storm. As a matter of fact, I've been actually analyzing a lot of stuff from the September flooding back in Colorado. That 1,000-year rainfall, you all remember that. Well, I've been looking at the runoff and the rainfall, And what we see is that even though you had 1,000-year precipitation to 24-hour level, at a 2-hour level, we didn't have a 100-year flood in most of these drainages. We had a 25 or a 50-year flood. And that tells you a lot about how conservative that design storm is. We just didn't, we never got up to the rainfall intensities in the design storm, despite probably having the biggest rainfall event that occurred in the past 50 years or more in Denver. So it is a very conservative design storm. And the debris storage is approximately 50,000 cubic feet. That is nothing to sneeze at. It is a significant amount of storage. And it's something that our client is very well committed to maintaining. I mean, that is something critical for all of these. Maintenance to make this work is going to happen. And our client has the resources to make that happen, the commitment to make it happen, and the BOCC can be assured that it will happen, and there will be assurances for that. So the last topic I wanted to talk about is avulsion. And what avulsion is it's what makes alluvial fans so interesting and so tricky. It's completely unpredictable. It's what happens if you have something that plugs or a big boulder or a tree gets stuck and the flow builds up behind it until it spreads out and cuts another channel. Okay, a lot of this stuff on an alluvial fan is not really consolidated sediment, so when you have water running down a slope like that, it tends to cut its own channel, and it moves a lot of sediment in the process. That's what channel avulsion really is. Channel avulsion is unpredictable, and it has the potential to affect both sites, the proposed site, the alternate site, in addition to the neighbors who live on the fan. It has high potential to affect some of those folks who live very close to the active channel. This is a figure from Mr. Mears' report, hypothetical alluvial fan, that just illustrates the point. This would be, if we were looking at the celestial fan, we could think of this as being the current active channel. If you had some blockage up here, this is kind of the sheeting debris flow, which is more what Flow 2D does. But if you were to have a blockage over here, it can cut a brand new channel. And you'll notice that this extends all the way to the bottom of the fan. I mean, there is no safer location on the fan because of this. So we can say the whole thing is constrained because of the 20%, but really a much more compelling argument that the whole fan is constrained is the risk of avulsion. And this is a quote from FEMA, a flow path uncertainty so great that it cannot be set aside in realistic assessments of flood risk. That's why we can't say this location is less risky than this one, or this is more risky than this one. We can talk about mitigation and how effective it is in these different locations, and the mitigation is far more effective in the proposed location. But in terms of risk, I mean, this is straight out of Mears' report and straight from FEMA. There is too much uncertainty to be able to say that one location is less risky or more risky than another. A few considerations for avulsion. Okay, we all walked up close to the apex today. Remember how channelized that was? You're much less likely to have an avulsion there. Where avulsion happens is when you start to get further down on the fan. It can happen anywhere you have blockages, but it is more braiding and more opportunities for avulsion the further you get down. They typically occur, if they do occur up near the apex, as I mentioned, you kind of take a hard left turn to get to our debris flow wall, but the direction of the flow is going to be more or less parallel to our debris flow wall. It's going to deflect it. It's not going to run right into it, which is what you want to try and avoid with deflection walls. It's called a deflection wall, not a blocking wall. And finally, if there were to self-dam and you did have big boulders coming down to CLC or at CLC, that's exactly what the mitigation system is designed for. I mean, whether structural engineers, geotechnical engineers, water engineers, very conservatively designed and sized, and this is exactly what we plan on. A few more, an avulsion could affect any location, could affect the neighbor's properties, it could affect the alternate site. The proposed debris wall that we have proposed has a minimum of 3 foot of freeboard. Part of that is to account for that uncertainty that occurs with alluvial fans and with the potential for avulsion. And finally, really, and this is where the argument that we're somehow cutting off part of the fan for future avulsion, sure, it's not going to avulse and come on the other side of our deflection wall, but if it ever does make it over there, this is an engineered channel. And remember when we were out there on the site and we were talking about how it's going to be cut down? I mean, if the channel does make it over there, it's not going to go back because this is going to geographically, topographically be sunk down, and it's going to be an engineered channel specifically designed to convey flows to that debris flow basin. So although it can't continue on further, if it does get over there, it's going to stay there. And this is showing you the grading of the rundown. I think you've seen this enough times now, but that's the whole idea. I mean, if this intermittent drainage somehow does manage to make it over here, I mean, just look at those contours. I mean, we're way down, and it's not going to have the opportunity to avulse and come back over. So if it does get over here, we've captured it. Finally, I wanted to leave you with just a few comments, and I will have a couple conclusions, but on this alternate site plan, just a few brief comments on this and a few things, to note. One thing that I find interesting is that really this debris flow location, the discharge location, this is no different than what we're proposing. I mean, in fact, it actually tends to show you that this is a good location for a debris flow basin. If you move it much over here, it's not protecting the road. It's not doing much. It also shows you that apparently the neighbors and their consultants understand that this is where the historic drainage is gone and this is the outfall. So really, if you're standing downgrading of the property and down here, say at the corner of Bulkley Road and the turnoff for CLC, this thing's going to work. I mean, it's more or less going to function the same way that the proposed site does. Only it has a few drawbacks to it. And the drawbacks that I want to point out to you are these bends in the channel. You know, water doesn't like to take a turn, especially water with mud in it. It doesn't take a turn at will, and it loses a lot of energy when it goes around turns. And from those jars that I passed around, I shook them up really well. Before I even handed it to Mr. Child, some of the stuff had started to settle out. Okay, if you're trying to make water turn, that's where stuff's going to settle out. It's not an efficient channel. The second thing that I wanted to point out is that we haven't seen any sort of calculations. You know, we use 3 feet of freeboard when we're planning this, and the reason you use 3 feet of freeboard is for that uncertainty. We have no idea what level of freeboard has been used by the people that came up with this design. I don't know if it's 3 feet or 1 foot. A lot of people use 1 foot, but that is not what I would use on an alluvial fan. And then finally, the other thing that I really wanted to point out on this is, do you see all these steep slopes? I mean, these are some very steep slopes here up on the fan. And this whole area here is an area where the channel could migrate or avulse over time. You know, what's going to happen if you have an avulsion and it comes into the basin right here on this steep slope? Well, what's going to happen is it's going to erode the heck out of it. It's probably going to deposit a lot of stuff here, and it's just going to be a nightmare because this channel could really do that anywhere along this whole channel or the basin. Again, note the orientation. Perpendicular to the flow instead of parallel to it. I can tell you that if something does reach the wall that we have proposed, the deflection wall, there's nothing that's going to slow it down. It's not going to settle out and drop out at bends. It's also not going to have to worry about run-up because we're running parallel to the wall. It's going to efficiently convey it to the debris flow basin, which has been properly sized and designed, and then it will be released downstream. Moving on to conclusions, I'm almost done. The entire buildable site is constrained. I think that, again, I do think this is something that probably we all agree on. The neighbors' sites are similarly constrained. They're on alluvial fans. They were built on anyway, with little or no mitigation, certainly no engineered mitigation. CL site's no more hazardous than many others that have been developed in Pitkin County. And in the city of Aspen. I mean, if you're up at the toe of the mountain in Aspen, I mean, less than a mile from here, probably a half a mile from here, you're in a location that's more hazardous than where Celestial's proposing to put their site. CLC's proposed development meets or exceeds the standards. I've done a lot of these, and this is a very high standard of analysis, very thorough analysis, very protective criteria. I mean, if I were designing a house like this, I would want to design something that I wouldn't be afraid to let my kids sleep in during a big rainstorm. I would have no reservations letting my entire family, my kids, my pets, you name it, sleep in this house during a heavy rainstorm because I have very high confidence in this mitigation. It's not a question of will it work. It will work, and it will be maintained. Finally, they are tried and true measures, and they will protect CLC. And the other thing is that it will actually benefit the neighbors. I mean, it will, the caretaker unit, which is where somebody can live, and the barn that's on the Pritzker property, I mean, that's down fan, and this definitely helps that. It also helps the mud depths on Bulkley Road. So the last fact that I'll leave you with is that based on all of the available analysis of mud flow issues, more than 3 years of it, extensive analysis by multiple qualified consultants, there's no doubt that there's a hazard on the site. But there's also no doubt that it can be mitigated using proven methods that have successfully been implemented elsewhere in Pitkin County, even on the neighbors' properties with varying degrees of engineering behind them, and that these measures will protect CLC and they will benefit the neighboring properties. Thank you very much.
Stretch your legs. So why don't we take a 10-minute break and come back?
Have a 5-minute break.
I want to use the restroom too, but okay. I mean, well, it's a
9-minute break. Come back at 6. Everybody, we're going to continue with our celestial hearing. We are about an hour and 45 minutes into the applicant's presentation, just to make them aware of that. We spent about an hour on additional information before that. So we're about 2 hours and 45 minutes into this hearing process. We definitely want to give it its due process, but we definitely want to keep moving along. So,
thank you. I will try and be cognizant of that. For the record, I'm John Cottle with CCY Architects, and I've been an owner of that firm and practicing in Pitkin County and Aspen since 1983. We've got 5 parts for the presentation, and you guys can read, and so we'll get into it. As we've said a lot of times, the entire site is constrained, the entire envelope. What that means in an architectural standpoint, an architectural way, is that anywhere within this area we need debris and avalanche walls, period. So clicking through in terms of other site analysis, there is a slight ridge that runs down here, and that's very important when we get to the architecture. That allows us to tuck the house into the hill and reduce the visual impacts. In terms of debris flow, it also adjusts the debris flow a little bit, but in terms of this, that's not super important. We do site analysis on all our projects. We do quite extensive ones. This is a compilation of a lot of elements. So obviously we see the little green. The darkest areas are the steepest parts of the site. They're over 25%. You can see where the driveway. The gray areas are undesirable or unreachable. Unreachable, we can't get to this part of the site. Undesirable, and we'll spend a lot of time talking about this. Every site analysis we do has an area that is a bad place to build, whether it's proximity to neighbors, proximity to driveway, impacts of neighbors, bad views, and this is our analysis showing where the where the good areas are and where the bad areas are. When you put our wall in that, the area that is protected and what we consider a good spot to build, and you can see it's really small. It's about 15% of the activity envelope. So concurrently with that, with working with Tetra Tech, and that we're also working with Andy Gleason. And Andy Gleason walked you through some of these slides, but I want to point out a couple. Obviously, the important part is this is the line, the red line we're using. These are the alternative ones. There are other ones up here. This direction of flow is really important, and the blue zone. I want to take a little bit of a detour, but it's a really important one to talk about the process of how an architect and a structural engineer and an avalanche consultant work together. This is in Castle Creek Valley Ranch. This is a house that we did with Art Mears, and we've worked with Art in the past, and we will probably work with Art in the future. You can see this house is located right on the edge of the blue zone. And just like our site, this avalanche is contained on our site, this avalanche blue zone. And this client hired us as the architect. We hired a structural engineer, and they hired the owner hired the avalanche consultant. We all work together, but it's been said a couple times, but it's really important. Working on a site like this, or like the site that we're talking about in Celestial site, there is not a team and a group peer review to the structural engineer and the analysis. I know this is a site plan review, so that opens a little bit, but we worked with one avalanche consultant, Art Mears, one structural engineer. They're both licensed, they're really competent, and we designed the house. It's also a very iterative process. So just like we've done this already on our site and identified the pressures, and we've started to already identify the walls and design the walls. So this is another page from Mears' report. And you can see, the avalanche direction, the structure on, or the pressures on the wall. And you can't quite read that. That says 165 pounds per square foot. This is a 12-foot high wall. It's 12 inches of concrete. And this is also from Mears' report showing that, he just understands what he's talking about and where the pressures are acting on the house. And it's an iterative process, and you go back and forth. For instance, you can see at this part, he said uplift on the eaves is not shown. So that's a detail that the structural engineer and the avalanche consultant need to work out. Notice the windows. This is all avalanche wall. The biggest window in this avalanche wall, and it's right over here into the breakfast room, and it's 10.5 feet wide and 5.5 feet high. And the glass is protected, protected and withstands the load. And the connections to the concrete wall and all of the sills were reviewed by Art Mears and reviewed by the structural engineer. So,
Point of order, Rob. Are we talking about the subject house now?
yeah, no, Castle Creek Valley Ranch still. I'm talking about how, I just want to make sure that you understand, because this is really important. And pardon me, Rachel, if I'm too far afield. How about this? I'll go back to this. I just wanted to talk about how we work together. It's really important. So this is, Andy already walked you through the slides, 206 pounds per square foot. Putting that in context, we're doing a hotel in Mammoth that has 300 pounds per square foot of snow load right above our site, and our site with 24 buildings on it in Mammoth, 230 pounds per square foot compared to 206. And as I said, we've already had the structural engineer size this. Andy walked you through this. I just wanted to point out how far that is down to the edge of the blue zone. And Michael, I think you had mentioned in the last one, said, why not just start moving it down? And I think this starts to get at that. This pressure is 2.5 times the pressure in our wall. And Andy walked you through this. So I now want to talk about the alternative site and start to compare, because it's really important to compare apples to apples. And the alternative site has been discussed a lot. So first thing, our site plan provides driveway protection. This is the site wall that's required for drive protection. Somebody asked about that on the site wall. The site walk today, it's 196 feet long. I think it's important to show proximity and where neighbors are with this too. The other thing, the septic field, and it might fit here. This is a big deal on this site. If it won't fit here, and we've had Jim Lanzotti already look at this, he's questioning whether it'll fit there. If it won't, because these cuts are so steep, this is a 24-foot cut right here. A septic field has to be 96 feet above this cut, or 64 feet above this cut. That puts it in the red zone. So we're not sure if the septic field works at all, but being a little optimistic, we left it there. We're proposing a geothermal field, so there's and it's really important. It's a really good feature. And again, I think it's important to show things in the size they really need to be. That is the fire truck required by our jurisdiction.
Where's that, John?
Right here.
Okay.
So it really has to cut into the hill. I mean, you've got to have a required fire truck. And then comparing apples to apples, because this was in the application, making this sound like this was quite large, 2.7. When you put in the other factors in this, this is 2.3. Neither of these, by the way, are really out of the ordinary. Neither of those are very, very large areas of disturbance. This is where it starts to get really, really interesting. We talked about this before. Stan mentioned it. Export. So that is the amount of dirt hauled off the site. If we can do the 13250 house, we will export 1,500 cubic yards. 8250, 2,500. This number is pretty amazing. And we triple checked this with Stan's office. We went back on both of these sites. And the 13,400 cubic yards is all of the excavation plus the area for the house. Putting that in context, that's 1,340 dump trucks. That is 3 trucks per hour, 8 hours a day, 11 weeks to haul the excess off of that site. 8 hours a day, 3 trucks an hour. Last fact of this, required walls. Our wall is 220 feet. This is almost 400 feet of walls. And I'm going to show you how tall they are. These are also, a lot of them are quite a bit taller than our walls. And I said we've been working with Andy really closely. We have been working with Andy really closely. And what you do here is you cut a section through the direction of flow, and then you analyze each one of these faces. This is the alternative site. And we broke it into face number 1, and you can see the pressures. Face number 2, pressures, 3. And the ones we've highlighted in yellow, except for this very bottom one, which is 201, all the rest of those are considerably higher than the pressures on our wall. And look at some of the height on this. This wall number 3, 21 feet. Number 5, 24 feet. Number 8, 8's down to 8 feet. And you can see how they get low when they're parallel to the flow. So this is a really impactful site. We also were shown some really nice visual simulations. But I'm sorry, these don't show the required avalanche walls. And these walls are required. They're not optional. They're not, hey, maybe we'll make them go away. So if you start taking, and we've shown in a little key down here, which walls are being added. And I can show you each one if you have a question. That is number 5. That's 24 feet high. Comes across, and then this last one is number 8. Clicking to the other view, and again, this is a nice rendering, but it's not factual. These walls are required. That's the 24-foot high one again. And it keeps going. So this is the rendering showed as the alternative site being a nice-looking building. That is required for avalanche protection. And I think it's really essential to understand apples to apples when we're talking about what an alternative site can hold. So our site plan. Again, kind of 101, but it's really important. This is our site plan. You guys have seen it 100 times. This is the area that we're cutting. And we're cutting into some of these. We talked about it today, 22, 24 feet. And I'll show that in context a little bit. But what makes this site work is those are the areas where we are filling. In between is the house. And we wrote here, balanced cut and fill. It's not quite. We just showed you the numbers. But this site area is really required to start to balance the site, cut and fill. And we just saw what happens when you squish it in the corner. There's no room. First of all, the walls don't get shorter. Some of them get taller, but there's no room to actually try and balance the site. And obviously, that's a huge issue. All right, the illustrative site plan. I'm just going to walk you through this. And first of all, this is the 8250 house shown. That's a placeholder. And for orientation, obviously, this is the driveway we walked up. This is the intermittent stream. Rob, this is the place we've been showing. That this is the debris basin with a really shallow reflecting pool in it. We've done this a number of times. That can be a hard bottom, but it's 2 to 4 inches of water. It can be really fantastic. In the avalanche trough, there's an amenity stream coming through there. And there's been a lot of talk about the visual impacts of this and how much cut there is in fill. This is a 24-foot cut, and I want to, within our activity envelope, from there to there, there's 80 feet of drop. It's an 88-story building. And when we're walking up the driveway here, I'm sure you guys all looked up to the ridge line. The ridge line is, I don't know if it's 800 feet or 1,000 feet, but 20-foot banks with rocks and planting in them is what is 800 feet up from the site. It's really completely in keeping and in context with what this site allows. So I think it's in context of this site, they are really quite reasonable cuts and fills. And we'll show it, by the way, we'll show the impact of that later. One thing since our last meeting, what has changed is this wall has moved slightly because it's obviously moved out of the red zone, and the house has gotten even more compact. There were 3 pavilions, now there's one larger articulated one. Also, the other impact is this wall has been reduced significantly, the avalanche wall. Previously, it was about 300 feet, and it's 220 feet now. And what we'll see is this avalanche trough and this wall and this house are now completely integrated together, and you'll see that in the visual simulations. And the location of the house, and I've said it for a lot, on this ridge line allows it to be tucked into the hill, and that's really important for keeping the the height down. And this location provides protection for the house, the driveway, and the neighbors, and of course the septic and the geothermal. So the advantages of this site plan. There's far fewer walls than the alternative site. And I'm sorry, this is not quite accurate. No export required. That was before we had checked all the things. And this is also not. That is now 1,340 truckloads at the alternative site. Moving the house downhill does not reduce the wall heights and can actually increase them. This site location provides protection for the neighbors. This site location obviously allows for all of the things that are required to happen on the site. And we have looked at this site for a long time, and there is no better location for a house on this site. It's extremely responsible in how well it's integrated. Architectural design. I hope everybody can see this. I think this is quite gorgeous, but it's a little hard to see in this light. This is the new house, the revised house. It's still tucked very much into the hill. Red sandstone. And Rachel, you asked about zinc. We're showing a dark zinc, and there are non-reflective, I don't want to say charcoal gray because they come that deep, but they don't have to be that deep. I don't think they should be. But non-reflective zinc, it really picks up the gray band in the gray bands in the cliffs behind. And this, again, is a little hard to see in this room, but right there is the end of the house. You can see the avalanche wall and the house are completely integrated and completely designed together. And right here, when we were saying this was the midpoint of the wall, it was 14 feet high, really what we're saying is the house is 14, and it's a little higher than that, 16. But it's amazingly low and compact. And because of the trough, which is in between this viewpoint in here, these open decks are protected from the avalanche, and that you can still get to enjoy the air and all of that. But they're really, look at how low and compact that is. It's really, okay, I'm biased, but it's fantastic. Again, another view, sorry, this is the 8250 house, so you can see the auto court, and you can just see over here, you can see this is all in Revit in computer modeling, but you can see the avalanche trough there. What happens, this is a view, if you could stand on Maroon Creek Road, and there was no planting in the way, there was no barn in the way, and you had 20 power binoculars, this is approximately the view you'd see. And what I'm trying to point out with this, the avalanche trough is right down there. And all you can see, and this is even being a little too open, you see this ridge would continue. What happens, the view plane, the trough is excavated, you can't see it. And we've got some other simulations to show that later on. By the way, all of these are showing the 8250 house, and I want to make sure that is placed. So there is the outer court. This is the elevation. It's still very similar to what you've seen in the past. That's the height limit. It's fantastic. There's still big pieces of it that are very low and very tucked into the hill. Visual impacts. So going back to Jim True, hearing officer number 1, when he approved this site, said, I want you to come back with a footprint less than 8,000 square feet. And so we came back with a footprint, and we've continued to make it smaller and smaller, but the celestial footprint, 5,600 square feet. So that's 30% less than Jim True asked us to do, however many years ago that was. The neighborhood average is 6,940 square feet. I think if you look at that, we're the second smallest. It's a really responsible, tight footprint. Smaller than the neighborhood average by far. There's another, I love it. It's so one-on-one. How long is the house? It's a really good measurement of how. So you can see again, we are 138 feet. The average is 182. We're the second shortest. And for some comparison, and I apologize if I've mentioned this before, but my house in Old Town Basalt is 3,200 square feet. It's 115 feet long. It's not that much difference. It's about the difference of this room from this house that we're proposing. It's really quite compact. There's also just what are the other measurements of how big things are in the neighborhood? And George, you had mentioned this, and we'll fly around a little bit. So this is the neighbor's barn, and that is about a 220-foot barn and another 200 feet or so there. By the way, here's another. This is the Pritzker's pond, and this is another example of what our avalanche trough and debris basin will look like. I'm sure you guys, when you drove out today, you drove out on this road and you looked back at the site. You looked across the Pritzker's field, and you couldn't see that pond at all. And that pond could have been 300 feet deep or 3 feet deep, or didn't matter. Because of the view angle, the ridge, the edge of the lake, pond, precludes you from seeing that. And the same thing's happening on ours, and again, I'll show you. Continuing around the neighborhood, this house is longer than our house, it's taller than our house, and it has a significantly bigger footprint. And you can see where we are. We're just down the hill a little bit. We know this one is longer, taller, and has a bigger footprint. But all over, George, getting to you, we don't have access to a ton of houses, but there are a lot of houses in there. This is one that's backed up against the hill. It's just down Maroon Creek. And this is not untypical. This is up to the height limit, and actually I think it is. That would be 28 feet. We know these are just about 24 feet because those are 2 stories. So that's a 24-foot wall, 24-foot wall, 28-foot wall, big wall in the middle, big wall behind, and another wall behind that. There are a lot of very substantial, visually impactful houses in the neighborhood. Ours is smaller, physically smaller in every way than most of these. But there is a codified way to measure this. And again, guys, this is a little hard to see, but you've seen these in your packets before. The code specifically says view planes from public roads. So this is Maroon Creek Road. It's only visible from 2 areas. This is viewpoint number 1, looking to the house, right over, you can see the barn, and viewpoint number 2. That's the only place from anywhere you can see it. And especially with these lights, this is going to be hard. But this, by the way, I want to point out, this is enlarged 200%. You can see the barn, you can barely see the house. And we thought of outlining, and outlining the length of the barn and outlining the house. This is barely visible, especially with the color palette we're talking about, because that's what it looks like with the real eye. This is enlarged 200%. That's what it looks like from the real eye. And of course, there's been a lot made of the debris basin. So we put this site, and again, you guys have seen it. These are all topographic lines. So this is in software called Revit. You put the whole mountain in the Revit. This is existing. And then you put in the debris basin. And again, you can't see it very much, so I'm going to enlarge it. And you now get a sense. This is the lip of it. We walked right along the driveway, and this lip, it was 4 feet above us as we walked along there, and relatively horizontal. It slopes a little bit. And this green area behind there is where the debris basin and the trough is. Now you can see a tiny bit of the back edge of it. But we've all walked up, gun hiking and walk up to high alpine lakes, and you're tired and you're grumpy and you can't find the lake, and then you take 3 more steps and you're standing on top of it. That's what this view plane's like, and it's similar to the Pritzker Lake. This is so not visible from the road. And there's been a lot of comments about views from neighborhoods. We tried to get as good of a view as we could get from Maroon Creek Ranch. Again, it's over the horizon over there. And same thing. I can't swear that you can't see it from Maroon Creek Ranch, but holy smokes, I don't think you can. So summarizing, 5,060. This is all for the 8250 house, 5,600 square foot footprint, smaller than the neighborhood average, built into the hill. Very difficult to see from Maroon Creek Road, and the avalanche and debris mitigation cannot be seen from the road. So that's all with the 8250 house. And this is, again, the aerial of the 8250 house. This is the aerial of the 13250 house. And just to review, this is the ground floor plan of the 13250 house. That is the underground auto court and the driveway. And this much is all underground or built into the hill. And as you guys know, that counts as floor area. And it's invisible. And this, by the way, the underground auto court and drive are almost 2,000 square feet. It's a really significant part of what we're asking for. And the owner's willing to use a lot of floor area, which not many people are, and a lot of money for a design that benefits everybody and gets cars completely out of the way and cover them with a planted living roof. And I think it would be a fantastic exemplary move to spend TDRs to do that, by the way. This is, again, the elevation of the 13250 house, showing how much of it is underground or built into the hill. And this is the comparison. And what actually happens is the 13250 house has measurably, either the same or measurably smaller impact. So it still has 5,600 square foot footprint. It's still smaller than the neighborhood average, still less than the neighborhood average in length. It reduces the impervious surfaces by almost 3,000 square feet in here. That's pretty fantastic. And it also reduces the environmental impact in terms of there's more area that's subgrade. It's really an underground. And again, I wish everybody could really see this. So this is an aerial, obviously, of the 8250 house. And that is the 13250. And that tells the story, I just think, better than anything else. You know, this is not bad. Everybody in Pitkin County sees auto courts and cars and noise and that. But, I mean, I know that if every one of you, if you live next door to this, you would rather see this than that. It's really fantastic. And I'm sorry, somebody in our office he said, how's that? Anyway, it's fantastic. It's doing something that I think would be exemplary in Pitkin County. So the 13250 house has measurably, because we start to cover walls, 1,500 square feet less exposed wall than the 8250 house. Over 40% of the area is underground or built into the hill. Then you've heard these 5,600 square foot less length, reduces the impervious surface, also has 1,000 cubic yards less export than the 8250 house, and it's because we can then grade over this, measurably reduces the visual impact. And I think, to me, uses TDRs in a obviously unique and really exemplary way. And I'm struck, I have one more slide, but this is the comprehensive plan, and I spent a lot of time reading this. Page 8, comprehensive plan. There are 8 places that mention visual impacts in terms of TDR receiver sites. The criteria for TDR receiver sites, especially the visual impacts from roads and adjacent properties. I think it's exemplary. So thank you very much for your time. Appreciate it. Let me get out of the way. Here's your clicker. Oh, by the way, we have 3 boards if you need to refer to them. And it's just because I know there are a lot of slides here. It's a comparison of 13250 with 8250. It is the comparison of the 2 sites. Comparison of the 2 sites. And I just can't, I'd love to have them up on the easel, but we're kind of tight on space. And that kind of 101 avalanche, what happens to the walls as they move down the hill. We also have, if anyone wants, the kind of our field notes from the walk today, the location from the walk. Pardon me? Thank you.
Yeah, good.
Thank you.
The summation, Stan? Is this the summation?
Summation.
Mr. Chairman and member of the boards, just for the record again, my name is John Fagnani on behalf of Celestial Land Company. I had planned to give about a 30 to 40 minute presentation, but being mindful of the time and also respecting your admonition, Mr. Chairman, about moving things along, I'll try to just hit high points and then save whatever time I have for rebuttal later on. I think you can understand, having made the site visit with us, why we're so excited about building this house in this location. It has a magnificent view of Pyramid Peak, and it's something we think can be done quite compatibly with the neighbors. in the neighborhood and tucked into the landscape in a very unobtrusive way. And I think you can appreciate at this point, certainly having heard all of the scientific and technical evaluations and testimony today, and not only today but previously, that we've got a very good plan. The fact that we have, over the past 5 years since we filed our amended application, or the new application in 2009, been challenged at almost every point, has made this a much stronger project for us. I think we've got an impeccably good project, well-reasoned, well-engineered, well-designed. It's an award-winning design, and we're hopeful that we can build a house. I mean, when David Bohm came here, he said, all I want to really do is build a house at this location. So we're hopeful we can do that. We've had a lot of criticism over the past 5 years about our plans. We've fine-tuned them. We've heard from the board. We've heard from the staff. We've certainly heard from the neighbors in spades. And we tried to fine-tune everything that we've done to the design and the engineering aspects of this project that we have today. And I know we constantly refer to the Pritzker project, and I realize that that might offend some, but really there's no better parallel for a project to which we should compare our project, because number one, the Pritzker house is in the neighborhood. Number two, it faced a lot of the same debris flow issues that we face. It faced really avalanche issues that really never were addressed or mitigated, as our expert Andy Gleason has pointed out. And it's a fairly large house that has a good deal of mitigation. It is a little more dramatic than the house that we're planning, but still the parallels are inescapable. And I think you can come to appreciate that certainly if the Pritzker's house could be built in the manner in which it is built, we should be able to build Bohm's house in the manner in which we're planning to build it. And I think the Pritzkers have a beautiful house, don't get me wrong. And I think they've done a terrific job of their mitigation. In some cases, perhaps it fell short of where it should have been. But we've worked very hard over the last 5 years to achieve the recommendation that we got from the staff. And we've worked very hard over the past 5 years to achieve a very, what I call, superlative letter from the Colorado Geological Survey. And we've worked hard. I think we deserve the favorable recommendation we've gotten from the staff, and of course the CGS letter. I was originally going to talk about the record because I think it's important to understand what's happened in this case, and certainly for me as a lawyer, there's nothing more important in an administrative review case than the administrative record. And I'm going to cut short that discussion, and I want to get to something that I think is a little more important, like the comparability of our site, our project, with some of the other houses in the neighborhood. And then I want to talk about some of the refinements that we've made to the project over the past 5 years, and some of the improvements, as I would call them, that we've made to the project. And then I'll try to leave it at that, and then again save whatever time I have for a rebuttal. But I do think this overall process has certainly given us a much better project. Now, I think it's always helpful when we do one of these things, and certainly since I'm sort of the cleanup hitter here, to try to identify why we're here today. And really we're here to present our land use application to you, with particular emphasis on all the underlying scientific and technical work that you've heard about that we've developed over the course of the past several years, including, I think, what is most notable and has been mentioned here a number of times, and that's the fact that we have designed to and mitigated to the 100-year storm. And my understanding is that in Pitkin County that has never been done prior to this project. And I'm certainly willing to be corrected if that's wrong, but that's certainly what we understand. And then secondly, we want to demonstrate the genuine compatibility of our project to Celestial's proposed residence to homes around Celestial's site throughout Maroon Creek Valley, really. And then finally, to come full circle and answer your fundamental question that was posed to us in May of 2011, 3 years ago, as to whether or not there's a better alternative site. So when you think about it, after we came to you and appealed, and the opponents came to you, appealed in May of 2011,
You gave us a mandate to go back and determine if there was a better alternative site. I think we've proven succinctly with the testimony we've had today, all of the reports that we've submitted over the course of the past few years, that there really is no better site for the development of this residential project than our preferred site. And I think we've also demonstrated that there are certainly issues with the alternative site that certainly indicate that there would have to be greater mitigation for avalanche concerns, greater mitigation for debris flow than what we're talking about even for the 13,250 square foot site. So quickly, with regard to compatibility in the neighborhood, if you look at these houses that are in the neighborhood of the Celestial development, you've got the Bulkley residence, the Murdoch residence, the Pritzker barn, which is almost as large as our project, and then you've got the Hofberger residence. And when you look at the Celestial project fits very nicely into the scheme in the neighborhood. And in fact, I think as John Cottle has pointed out, the square footage, the footprint is even smaller than the majority of these houses. As John also pointed out, when we had the hearing before Jim True, although I must say he kind of pulled it out of thin air, he said he'd like to see a footprint of 8,000 feet or less. We've achieved that. Also, if you look at the Celestial house in the context of the Pritzker house, I think it compares very favorably. No question that the Pritzker house has a much larger footprint, but again, we've faced a lot of the same issues that the Pritzkers faced, and we've got an excellent design just like the Pritzkers did. The problem that I have with the proposed house that the Pritzkers have presented to us is this. First of all, they've actually gone to the effort of trying to design our house, and secondly, they've tried ad nauseum for a number of years now to tell us where to place the house. But if you look at the view that we would have from the alternative site, the first view is towards the Pritzkers from the alternative location with an overhead shot, which is this one right here. Second view is the view towards the Pritzkers barn or caretaker facility from a ground level shot. And the reality is that to place the house here is simply not credible. I don't think anybody here can really believe that the Pritzkers would like our house to be a lot closer to their tennis court in their house than the one that we're planning. The reality is, I think as Stan mentioned earlier, what we're talking about here is the Pritzkers and the neighbors don't want any development at this site, so they're trying to force us to a site that makes absolutely no sense, has very limited, if any, view of Pyramid Peak, and would require the construction of a home that wouldn't be as magnificent as the one that we're planning to construct. In terms of the administrative history and the record in this matter, it's very voluminous, no question about it, but it can't be ignored. And if you look through the administrative history, as we've done in putting this together, you realize that over the course of the past few years, whenever anything has been identified as a potential problem, we've rebutted that issue. We've actually taken the time to put forth the necessary information to rebut the criticisms that have been leveled against the project. And I think as Stan or someone mentioned earlier, the second bullet point, over the past several years the activity envelope has been approved 4 different times, 2 times by the BOCC and 2 times by different hearing officers, Jim True and of course Tom Smith. And no question that our project has been thoroughly studied and carefully planned, probably more so than any other project in Pitkin County. Now I'm going to run through the administrative history very quickly just to show you how voluminous this is. And I think Suzanne has done a good job of presenting the administrative history. She's done a good job of explaining that we still have certain rights that exist into 2016 with regard to the 2 TDRs that have already been awarded and with respect to some of the other issues. But we resubmitted our application in February of 2009, and here we are 5 years later still talking about a lot of these same issues. So we're hopeful that after today we can get a final determination and move this project forward. I got a little bug. let me, now let's look at the bottom of this particular slide. In May of 2011, this is when the BOCC appeal hearing was held, and the BOCC remanded this matter to the eventual hearing officer, who was Tom Smith, right here, to essentially determine if there was an alternative location. I will tell you, despite the fact that there's been some criticism of Tom Smith from the conflict standpoint, I have seldom seen a better written and a more detailed and cogent analysis than Tom Smith did in regard to this project under the Pitkin County Code. And again, there was no criticism of his substantive evaluation, but rather of the recusal issue that was the basis for the board's determination to grant the opponent's appeal. So again, I'm going to just go very quickly through this. This will give you some idea of the volume in the administrative record. This particular highlighted passage we talked about earlier in the context of the motion to strike, which I have to say was a very intellectually dishonest exercise, because the quotes that were placed in that motion were not complete, and there was no reference to the fact that the whole point of this exercise is for the board to evaluate the hearing officer's determination and to modify it as it determines appropriate. Quickly, I'm going to point to, again, I would have gone through this in much more detail, but you've heard it all today. Safety has been one of the major concerns of Celestial's property development. We've had tremendous efforts in engineering, and you've heard from John Cottle with CCY, Tetra Tech, Wright Water Engineers, and of course Trotner Geotech. The scientific studies and the different and various materials that we provided in the record to the county staff, and of course certainly indirectly to the board, have been voluminous. This is a list of at least some of the reports that have been prepared over the past few years and the details. And by the way, I'm happy to provide this PowerPoint to the board for whatever value it may have, because I'm going to go through this fairly quickly. We've already talked about Tetra Tech's findings, which are voluminous. We talked about Dr. Andrew Earls, and of course he went through a very detailed analysis of the debris flow issue. We talked about the avalanche risk and how we would address through mitigation efforts the avalanche risk, and Andy Gleason did that. And of course he talked about the various field studies that he did, the two different models that he applied to identify the areas of the red zone and of course the blue zone. We've ensured compatibility through architecture and design consistent with the code. And then I want to focus on this particular slide because I think it's important, and again this demonstrates certainly graphically the compact nature of our development. It's a little bit difficult to see certainly from a distance, but this is an aerial photo of the Pritzker's development as it was being constructed. And it's a photo of the house that was developed and of course the accessory structures while they were under construction. And if you look to the left, this is the area of the Celestial site with the shaded area that shows the area of site disturbance that would be associated with our project. And I think you can appreciate that it certainly pales in consideration to the overall disturbance that took place when the Pritzker's house was being constructed. And again, if you look at the area of displacement in the next slide, we have an area of disturbance of 115,000 square feet. That's down from 140,000 square feet. And the Pritzker house was 134,000 square feet alone. The Pritzker Lake, 202,000 square feet. The Pritzker Caretaker Complex, 52,000 square feet. And of course the horse barn at 21,000 square feet, with a total area disturbed of 409,000 square feet compared to our 115,000 square feet. And again, I think this helps to point out the level of refinement that we've engaged in and also the very compact nature of this particular project. The next area I want to get into a little bit is the continual refinements that we've made to the project, the improvements, if you will, with regard to the project. We've never hesitated to change our design or to refine our design based on feedback that we've gotten from everybody involved in this process. And we made a number of design changes and engineering changes subsequent to our filing of the application in 2009. If you'll recall, in 2009 we asked for the application of 3 TDRs for 15,000 square foot house. We abandoned that to request only 2 DRs for a 13,250 square foot house. And this is a particularly important slide, I believe, because this will identify the notable refinements that we've made to the project over the past several years. First of all, the debris and avalanche deflection wall has moved 80 feet from its original location. Second, the overall site disturbance has been reduced by 25,000 square feet, as I mentioned. Revegetation will render all site grading completely non-visible from Loon Creek Road. The proposed footprint of the residence is 5,600 square feet, as John mentioned, which certainly is well under the mandated square footage or the footprint that Jim True had identified when we had our remanded hearing before him. And in every measure, the footprint is much smaller than the house that we had originally designed. Finally, the view simulation of the current design confirms what has been shown in all prior design iterations, and that is that the house, including all of our associated structures, such as the wall and the trough, will be barely visible from Maroon Creek Road. All avalanche mitigation has been located entirely within the blue zone, as you heard. All interior spaces and exterior decks have been protected from avalanche. The trench has been reduced from 219 feet to a total length of 141 feet now. And the debris avalanche protection wall has been reduced by approximately 80 feet and now is only 180 feet long. One final point I want to make is that the Pitkin County Land Use Code requires, as Stan went into earlier, a very comprehensive and balanced assessment of all of the geologic hazards, not just the avalanche hazard, which is important to keep in mind. And that's why the avalanche wall has been incorporated into the debris flow wall, because both hazards have to be accommodated, and we've located the ideal location to accommodate the mitigation of both of those hazards. Stan went through the analysis of the code. I won't spend a lot of time going back through that. The one thing I think is important to keep in mind is that, as Stan said, the code doesn't require a grouping of engineers to agree on design. It really only requires a Colorado licensed engineer to provide professional judgment and the engineering analysis, and that's very clear under the code. So if you look at what the board mandated in 2011 in terms of whether or not there's a better alternative location for development on the property that would increase the safety for the use of the Celestial property and the surrounding properties, the obvious conclusion is there's absolutely no better site than the preferred site that we've identified and studied to a substantial extent. So if you take all the geologic hazards into account, Celestial's proposed location is superior to any of the other locations, much better than the alternative location, and in fact the alternative location will require a greater degree of mitigation, which I think has been pointed out by both Dr. Earls and Andy Gleason. And again, by way of comparison, the Pritzker's 13,800 square foot house literally faced the same types of debris flow and avalanche hazards as our site. You can see that the house is built at the basin of the debris flow, an alluvial fan, and of course there is an avalanche risk that was never really mitigated. So what are we talking about here? And this is really what's at stake. This is information that was contained in the architectural record recently in regard to the Pritzker's house, celebrating the view of Pyramid Peak and, of course, the design of the house. And again, the design of the house has been impeccably done. But in a somewhat humorous vein, what the record said is the way that they selected their house location was to take a hammer in one hand and a stick in the other and kind of traverse the site until they decided that there was an appropriate location to place the stick for the center of the house. And what they called that was their axis mundi. And they didn't pay many, if any, they didn't pay much attention at all to the geologic hazards. They felt that they could mitigate the hazards, and in fact they were mitigated. But I think, as you'll note in the next slide, that the Pritzkers had a lot of acreage that was completely unconstrained where they could have developed this site. So if you go back to Tom Smith's reference to avoidance that he analyzed in the context of the Celestial site, it's quite clear that this site would have never been approved because there were plenty of other areas that could have easily been utilized for the house that would have avoided the debris flow in the location where it was eventually sited. So with that, I think I'll just make one last comment, and that is that we're simply looking here from the board for fair and equal application of the code and consistent treatment with our brothers and sisters that developed the Pritzker property. And that concludes my accelerated remarks.
So our presentation has been long, but we hope you'll have found it thorough. We have presented a credible scientific and engineering analysis. We've shown you how this project meets the code. It provides safety for the site and the residents on the site, as well as enhancing some safety issues for the neighbors, and that it's attractive and consistent with the neighborhood itself. And with that, we're happy to answer any questions.
Commissioners, we'll go into questions of the applicant. I did want to address the timing of the evening, and this is my first long chairing meeting, so I want to give it its due process and move forward, but I also want to have weigh-in from others.
You know, my only thought on the timing issue, Rob, and other board members for consideration, is that I think that if we could get through the other presentation and then perhaps any short rebuttal, and then continue to make a decision and a discussion among ourselves at a future time. Because I just can't see us going to 9 o'clock at night after we started our site visit at 9:45. But that would just be to make sure everyone at the same time had the same access to us and the same chance for a presentation, but then make a final determination later. And I'm sorry if that would disappoint you, but at least all the presentations would be out of the way.
Michael.
Rob, as I mentioned to you earlier, I have some obligations. I have to leave at 7, so.
Okay. So we could also continue at this point, because I don't know that it would be fair to not have all 5 of us here for any rebuttal or any presentation by the neighbors and public comment. I just don't know how to proceed.
Nor do I. That's why I'm asking.
Okay. Well, I mean, I think it needs to be a full board decision, and the full board needs to be present for all the testimony.
John, any advice?
It's the board's discretion to manage its calendar. We need to afford appropriate length for public comment is the primary concern.
Absolutely. Glenn, I'll get to you in just a sec. Let me just go around this part of it.
Well, we picked this date to ensure that we had a full board, because we don't have a full board, and for whatever reason we ended up with a split vote, then we may have to go through this all over again. So I think it's critical that we have a full board. And we were able to get through the applicant's presentation. I would think that we could reschedule for the next phase of this to continue to allow for the public comment period and the opponents, and then allow the applicant for rebuttal, and then we would have a
Make a
good
determination.
determination. And I would suggest if we go that route, that we pick a date, perhaps we even do a special meeting,
Yeah.
so we don't run into this problem again. Let's try to learn from our mistakes.
I would throw out there that perhaps we could finish this up the morning of Thursday the 5th, or the day of Thursday 5th. We have the EOTC meeting and some other items in the afternoon.
Yeah, I've got a core retreat on it.
Okay. That was just throwing out there. I'm sure we're not even to the point of dates probably yet.
Right, but first we have to decide whether we are going to need to continue or move forward without Michael.
Michael?
I mean, I'd like to continue. I'd like to, this has been fascinating so far, so I'd like to be president of the continuation. So I would move to continue, and we can continue to our next regular meeting, and then, decide that this is adequate time or not.
I'm more along the lines of Rachel in terms of finding a day and committing to it for the duration of
That's fine.
a conclusion.
Yeah.
And I mean, 5 years is a long time, and I'm certainly willing to make that commitment with my schedule allowing at this point.
Would Monday the 9th work for people? Monday the 9th is also fairly close in.
I think that works for me.
We have roundtable in the afternoon.
I'm just going to have to say no.
Have this be the priority?
We have to have a priority.
Where are we? We're into June already.
Yeah,
huh?
June, Monday the 9th. Is that a
Monday the night works for me.
Monday the 9th? Would we have enough time to notice this?
June
You
9th?
continue it right now, and so there's no additional notice that's required.
Would that work for you, Rob?
That works for me.
I think we've already continued other stuff to June 11th, and I think it would be, we'd run into the same problem if we tried to do it on a regular meeting day. So I think doing it on a different day would be better. I just have a special meeting and devote the whole time to this.
Yeah, I do as well. And as I mentioned earlier, I have to find out if I'm going to have jury duty on the 10th, and, that might take me out of the regular meeting on the 11th. And so doing it the 9th, we'll be clear on that as well.
So,
Staff?
The 9th?
Steve?
One question, there might be members of the public who have made an effort to be here today,
I was going to get to that once we went around.
and maybe they should be allowed to do their, a few minutes presentation, so they don't necessarily have to come back again.
John, our public comment requirements regarding our notice today and continuing, what's general protocol in terms of public that shown up today?
Well, usually we try to afford people the opportunity to address the board if they can't come back to the continued date.
And public comment could be observed by Michael via Granicus if we continue tonight for a period of time, to allow that, to afford that opportunity of some of the public that have showed up.
Yeah, I have to go.
Yep.
So,
I would not include the opponent's
I'd like to
presentation
give
as part of that.
the opponent the opportunity to lead off, the neighboring group the opportunity to lead off public comment when we reconvene.
When we reconvene on the
Yeah.
9th.
Yeah.
Yeah.
So do you need me here for a motion or not? I gotta go.
I think we can make a motion. We have enough people at the table. Thank you, Mike.
Thank you.
So you may just, first you may ask if that works for the
Yeah,
applicant.
the
and
applicant,
proponents, the Monday, June 9th.
So, obviously, everybody in the room has heard a little bit of this conversation going on at this table. Timing is always an issue. Participation of the full board is obviously an issue tonight at this point. And we're doing the best we can to have a full comprehensive process here tonight. So at this point, what I'm going to do is I'm going to ask for a response to the conversation that we've been having from the applicant, get their response, and then I'm going to ask a response from the neighboring group on the conversation that we've been having here, and then we will continue for a period of time for people that need to make public comment tonight that will not be able to attend our meeting on the 9th, and we will get that on the record. We will hear it. Michael will watch it on the Granicus. It's all being recorded. And from there, we will accept the motion and move forward to continuing this to, I would say, noon on the 9th, which is a Monday. It would be a special date for us to come back and convene and commit for that evening, hopefully not as late as tonight, but commit to taking the time to come to some sort of determination.
If that date works, I would actually like to start a little earlier.
Yeah,
We can discuss time. Yeah, I'm wide open that whole day, so. So the applicants, please respond to our conversation.
As a point of order, will the board's mandate from earlier still be applicable, which is that the opponents would have 30 minutes for a presentation?
Well, when we did that presentation thing, I said we want to gear it towards 30 minutes and that I would give some leeway to that based on the application and everything and all the things involved. So it's at the chair's discretion. I'll leave it at that.
I'm trying to figure out what the time is because I've got a conflict that day.
Okay. Well, we'll have a little bit more discussion on that as we move along. I mean, my hope is that through the applicants, through the public hearing process, the questions, the deliberation, that it be about no more than a 3-hour period. That would be my hope. We've been going for 3.5 hours now, so.
Yeah. If we hadn't had that motion to dispose of first for an hour or so, we might have been able to finish today, but that's.
So that's our hope, but of course we want to give it its due process, and if 100 people show up to give public comment, 100 people show up to give public comment. There aren't 100 people in this room, but we want to try to give it its due process.
Let me respond to
Yes.
to the date question. We may have a conflict, and we're not absolutely certain of it. I know that you need to continue to a date certain, so continuing to the 9th would work, but there might be a conflict that would cause us to ask for further continuance.
The further continuance would delay things to our availability. And as long as the applicant's aware of that, I'm okay with that.
Understood.
And that availability could be a month down the road with our schedule.
Yeah, easily.
Well, we would try. I mean, obviously, the 9th, we've picked a date that's
Yeah. The only other two open dates I have this month are going to be like the 16th and the 18th.
Yeah.
Following Monday could be a possibility.
So the following Monday could be a possibility.
We wouldn't try to delay it, obviously.
Understood. But I know you need to continue to a date certain, and so that would work for the time being.
Understand. Glenn, do you want to speak
Yeah,
for the?
I think I do want to speak. There's been a very long presentation by the applicant, and we have prepared a response within the guidelines, trying to seek the guidelines that you've suggested. Also, speaking for the neighbors, we have George Annandale, an alluvial fan expert, and Art Mears, an avalanche expert, as well as Mark Hamilton, an attorney for the neighbors. None of them can be here on June 9th. In addition to that, there are members of the public, I believe, that are here to speak that have waited around for quite a long time. And I think it's going to be, it's just not going to work to have this hearing on June 9th. And I think that there should be an effort to come up with a date that's mutually acceptable, as was done before at the appeal hearing. And I'm not sure whether that date can be set right here, given everyone's schedules. So I think maybe the appropriate thing to do would be to continue it to a date certain. And in between now and that time, I think the staff could talk with representatives of both sides and try to pick a date that's mutually acceptable. And on whatever date you continue to, maybe it's June 11th, we have a discussion of what that date in the future might be, and that way we would have time for everyone to get together and figure out a date that works.
Are there available dates before June 9 by any chance?
Rachel and I are gone most of next week already.
So if June 9th doesn't work,
What about
June 16th was a possibility.
Monday
So we
the
could do,
16th?
we could do a date certain for June 16th at this point and still sort of.
Well, we don't want to have to come in if everyone's asked us to cancel, just to hold the meeting to continue. So I think that's why Glenn was saying, why don't we put it on, the continuance on till Wednesday, the 11th, knowing that it's just going to be a discussion of the appropriate date. It's not going to be an actual hearing. We're not going to do anything there, open and close the public hearing as we necessary or whatever, but that there will really be a discussion of finding the appropriate date.
Yeah, okay, I understand.
Okay.
Yeah, I wish we could continue now.
Right.
The challenge that I have with this is that I view this, and I said this in the procedural aspect in chairing this meeting, is that I kind of view this as the applicants going through a process with the board, and that the public comment were the public, and you can make some adjustments to that, but how much adjustments do you make for that? And I don't want this to delay months down the road. I think that works against us greatly. Quite frankly, I'm a little disappointed that we're not continuing to a conclusion tonight. For the point that we all knew that this was going to be a long meeting, and we all knew that it was going to be very involved, and we all knew that that was the plan for tonight, as painful as it may seem.
However, we are where we are, and
Yeah.
so unless we want to try to see if there's dates that everyone can make right now.
Well, there are 2 points to Glenn's
Yeah.
conversation. Was 1, the 9th doesn't work. 2, there are lots of people in the room that would like to make comments
Well, that's
now.
what I thought you had suggested. We were
Yeah.
going to hear the public comments now from the parties who are not represented, who are not going to be speaking. It cannot make the future date. But if we don't know the future date, that gets very hard to do. So we could spend more time nailing down the future date.
I would say date certain continue to June 11th.
Just set and
Because that's a normal
Regular
BOCC meeting. So we know we'll be here. From there, we can continue on to another date certain.
Just continue it.
That gives everyone an opportunity to try to coordinate schedules. So I would make that motion.
Glenn's suggestion, I think, is a good one, too, because it gives a chance for the staff side to confer with the people who are present to try to refine the time, and then do it. Set a date on the 11th.
So can we make a motion before public comment, or?
No.
No.
Well, why, are we looking to lose a participant?
I'm looking to try to move this decision
Well,
along.
no, I would have public comment first and then address the emotion.
Okay.
So the plan right now is for staff to work with the applicant and with the neighboring group to find a date certain that we can agree to on or before the date that we hope to continue this to. We haven't set a motion yet, but the date certain would be the 11th, just to set a date, and then we will continue to a different date that would work for everybody as best as possible. And then at this time, and Glenn, I was going to give you the opportunity to lead or go behind the other public comment. So at this point, we will start off with your presentation. Well, actually,
That's not what we talked about. We talked about having public comment for people who cannot make it to the next meeting.
Yes, today.
Today. So if Glenn...
You didn't listen to me.
No, I did.
George. I said my plan was to.
Was to.
Yeah.
I didn't say my plan is to.
All
My
right.
plan was to
We're all
have
getting
Glenn have the
We're all
option.
getting a little punch drunk.
But now that's no longer my plan. Now my plan is, we've concluded the Celestial presentation, where we are going to take public comment for those people who do not feel like they can make a time commitment to come back to the next hearing, and hear from those people in public comment now. When we do reconvene, we will continue the public hearing with the presentation from the neighbor group,
And the
which I
professional
consider
consent.
part of that public comment,
Okay. Very good.
at the discretion of the chair to allow for, some time for them to give a
Rebuttal
response
after,
to the presentation that was given. And then there will be a rebuttal from Celestial. So at this time, I will open the public hearing to this application and take public comment. Again, for those people who do not feel like they can make the next public hearing, we believe we're going to try to set it for the 11th, but it'll probably move from that date. So, is there anybody in the audience that wishes to make public comment at this time? Okay, well, people will be back. I will close the public comment period at this time. We will reopen public comment when we continue for additional comment from other people. This is not an official closing of public comment like some applications that
Yes,
we've
we will-
continued.
we will continue
I want to
the
make
public
that
hearing
clear
until-
for the record in terms of whatever legal way that we will need to do that. I thank you all for I know we're going to have a motion, but at this point, I just want to thank everybody that's in the audience for bearing with us, bearing with me as the young commissioner, first-time chair, trying to take that muddy water and separate it into something that's palatable.
Okay. I would make a motion to move the to move the Celestial Land Company LTD activity envelope, site plan review, special review, and GMQS exemption, modification of hearing officer determination 004-213 until June 11th, our regular meeting, at which time we will be setting the meeting date for the continued
Why
opening
don't we
the
just
present.
continue that day? I mean, it might work, but that's
Yeah.
a good day to go,
It's not a good day to go. I know that. We've already continued so many items to it, and I'm driving to Yampa that night. In which we will be setting the date for resuming the full balance of this hearing.
Second.
We have a motion and a second. Any discussion? Seeing none, all those in favor say aye.
Aye.
Thank you very much for your attention and for
I make a motion to adjourn.
Yeah, I don't think there's any pressing open discussion.